All right, good morning. This is the Colorado Energy and Carbon Management Commission. We are on day 2, 3, all the days run together on cumulative impacts and enhanced systems and practices rulemaking. We will start with a roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins,
Here.
Commissioner Shea. Mr. Chair, you have 5 commissioners present.
Great. And I believe we're going to have Commissioner Shea here in just a few minutes. She's running a little bit behind. Okay, well, to set the stage, this is docket 240600145, the cumulative impacts and enhanced systems and practices rulemaking. We have been this week listening to our staff, and then we started with cases in chief, and we remain involved in cases in chief. Before we get to the next cases in chief, and bear with me just a second, Mr. Mulvar, I want to talk a little procedural process to all of our parties. I see we've got 73 participants right now. This matter was set for hearing the 9th through the 17th, and then the 3rd through the 10th, so Tuesday through Tuesday, and then again the 17th to the 20th. That's a Tuesday to a Friday, and then we have tentatively set aside the Monday, the 23rd to the 26th, if necessary. At the outset, upon looking at the time allocations and discussing this with my hearings manager, on Monday or Tuesday the 3rd, I suggested that we really need to get through cases in chief by next Tuesday the 10th. I still believe that is important. I also suggested that if we get that done, then perhaps we would get to a place where commissioners could do initial deliberations at kind of a high level. And then I finally suggested that we might need to have a hearing on Saturday the 7th. I'd like to not move goalposts, but just alter the playing field ever so slightly by, number one, not holding a hearing on the 7th. This suggestion is derived in large part from the fact that our parties, I believe, have done a very good job of understanding that they need to be concise and efficient and expedient in their presentations. Between their presentations and commissioner questions, I think we're starting to get a good full picture of the issues that are out there. I still would hope that between the 3rd and the 10th that we get through all the cases in chief, and then we could return on the 17th to the 20th for rebuttal. I've noted that most folks are reserving at least a third, if not up to half of their time for rebuttal. So I believe we're going to have a vigorous and well thought out ability for parties to, provide rebuttal, provide opinions, etc. I'm not sure the commissioners are going to be in a fantastic place to provide initial deliberative thoughts on the 10th. There is a lot here. If commissioners want to, they certainly can. I may have an idea or two that I want to float out and want people to be thinking about. But I think we can roll into the 17th to the 20th and potentially the 23rd and beyond. And, I would instruct staff to try to help us with kind of an issue list that we could possibly make public so that we've got kind of a framework on how we're going to go through on deliberations. But a lot of the issues, I think, are identified, and a lot of the proposed ideas and solutions are identified. So, number one, no Saturday hearing. Number two, encourage everyone to continue to be efficient, expedient, and get through your points. Number three, we'll break on the 10th, and then that break now, I believe, provides an opportunity. So that'll give us our parties the Wednesday, the 11th, 12th, 13th, and 16th. And I would highly encourage parties to talk to each other during that 4 days of business meetings. You don't have to agree, but I think it would be very helpful to, now that you've heard opening statements and you've heard cases in chief and issues are being identified, to pick up the phone, have some Zoom meetings, chat with each other, see what sorts of of creative, solution-oriented things you might be able to do. So that's just me talking, but I believe my fellow commissioners would probably appreciate that as well. I think you can tell from our questions, we're trying to narrow and frame issues so that everybody understands what they are. And I think we've done a good job of that between the cases in chief and others. So those are my thoughts about slight alterations to the process. Does any commissioner have thoughts about that, have concerns about this slight approach? Any commissioner dying to have a meeting on Saturday? Commissioner Messner?
Thank you, Mr. Chair. I appreciate the modified schedule. I think that break certainly gives commissioners a time to put their thoughts together and compile everything from, I think, what will be the majority of cases in chief at least, and certainly gives parties the opportunity to develop their rebuttals and have those conversations. I just wanted to confirm, we are intending to have a rulemaking hearing on the 16th though, so that break would be the Wednesday, Thursday, Friday, right?
It's set for the 17th to the 20th. So Monday is not a hearing day in the hearing management order.
I have it
And
on
then
there is a hearing day, so.
yeah, it got altered at the last hearing management order. Apologies if that didn't get noted. And then again, we've got on our calendar, I noted in my inbox today, the 23rd, 24th, and 25th in a just in case. Obviously, we're trying to get this done by the statutory deadline of the 30th.
Okay.
Any other thoughts, comments, commentary before we move forward? All right. We now will hear from Western Watersheds Project. Mr. Mulver, thanks for bearing with.
Well, thank you, Honorable Chair and members of the Commission. My name is Eric Mulvar. I'm a wildlife biologist and Executive Director of Western Watersheds Project. My wildlife science has been published in peer-reviewed journals on moose behavioral ecology and systems ecology. And I've also spent about 15 years of my career working on oil and gas issues. So with that background, I'll go ahead and share my screen. And so essentially, I wanted to share with the Commission a report that we compiled about a year ago on cumulative impacts of oil and gas on the Colorado River Valley Field Office, which is a subset of Western Colorado on the West Slope. Essentially, one of the things that I wanted to make a point of was that currently in the regulations, the cumulative effects area has been defined as within 1 mile of a well. Our report looks at elk and mule deer. These are wide-ranging species, and a 1 mile radius area really isn't a meaningful cumulative effects area for these species. So we're encouraging the Commission to look at multiple scales. It's been suggested that data analysis units or DAUs are a good scale. I think that's right. For water issues, it's HUC 12 hydrologic unit code areas have been suggested. That's a good suggestion, but I think it would be fair to look at a lot of different scales. For our methodology, we used a GIS analysis of elk and mule deer and how their habitats are affected at various thresholds that are known based on science to affect both either elk or mule deer. We used the map layers from CPW for the crucial ranges for these two species. We use the old COGCC well data for where the wells are located so far, and road data from counties. We looked at land cover databases for habitat factors. And we limited our analysis to the Colorado River Valley Field Office, which you can see here, running roughly up in the upper reaches of the Colorado from Rifle up to Edwards. You can see this brown area is the Colorado River Valley Field Office. Also shown here, you're going to be hearing later from friends of West Mam Creek. And this is the West Mam Creek HUC 12 hydrologic unit code watershed. And it's interesting as well to note, so that kind of orients you on where that will be located. starting with elk. In winter, elk avoid roads and natural gas wells, according to studies from Wyoming. They tend to flee to more covered areas, and roads in general are an issue for these species. According to the science that we know, road densities that are less than 1 linear mile of road per square mile are optimal for elk. And in the Bighorn National Forest of Wyoming, in a study by Sawyer et al. In 1997, elk selected lands with less than a half a mile, linear mile of road per square mile to have as their habitat. And another study, the mechanisms for this include reduced energy expenditure for the elk, increased diet quality, and increases in habitat effectiveness. So we mapped all of the areas where the road densities at present in this Colorado River Valley field office were more than 1 linear mile per square mile. And what we found was for elk winter range, 84.5% of the elk winter range had road densities more than 1 mile per square mile, and 95% of the parturition or calving range had more than this threshold. So the elk in this area really have nowhere to go where they're not going to be stressed by having excessive road densities already. That's a cumulative effect at the scale of a fairly large river watershed. And therefore, you could expect that they're going to be experiencing reduced energy, having energy expenditure issues, reduced diet quality, and having lower habitat effectiveness. And so that's a negative for the elk in this area. And that's certainly natural gas and oil play a role in that. And that's where the ECMC's regulations could come in and help. In terms of avoidance of roads, the metrics vary. Typically, we're looking at about a mile to a mile and a half in open habitats of avoidance within open roads. In heavy forest, and this is from the Pacific Northwest, so this is really heavy, like almost coastal rainforest. It was more on the order of about a half a kilometer from roads, which is about a quarter mile from roads. So it really varies based on kind of habitat type as to the degree of avoidance of roads. And also one would expect to see, based on Edge and Markham 1991, the topographic barriers. So in other words, if the road is not visible because of an intervening ridge line, there might be less disturbance there because of topography. In terms of oil and gas infrastructure, the best science on point is Buchanan et al. From 2014, indicating that elk avoid well field roads by 2.5 kilometers. And importantly, once oil and gas development begins, elk avoidance of roads increases by an additional 1.3 to 1.5 kilometers from prior conditions. And this is not so much from the drilling activity itself, although that certainly is a major issue, but also think about all of the vehicle traffic that comes along with oil and gas development along the road network. So you have condensate trucks going and draining the condensate tanks every week or two. You have little pickup trucks tripping the wells and checking them out. All this extra traffic is a stressor for elk. Now let's talk a little bit about mule deer. In terms of some of the science, Sawyer et al. 2017 is a really good analysis on habituation of animals. And Sawyer et al. Found that avoidance of energy infrastructure is a long-term effect, and it can be associated with significant population declines. So this is
is this just me or is everybody else missing Mr. Mulvera?
I am.
I
Yeah,
am.
lost him as well.
Okay, stop the clock.
get used to it and go back to what they were
Okay,
doing
hey,
before.
Mr. Mulvare, you were,
Yes.
you were frozen for the last minute or so. And so we didn't hear you. So if you could go back in your presentation about a minute or two, and I stopped the clock so you didn't lose time, but we want to hear from you, and we missed that last piece.
My apologies. Apparently in this location, the internet might not be as stable as I'd hope. So anyway, I'll go back over this Buchanan et al. Study in 2014, where elk are avoiding well field roads by 2.5 kilometers. So that's more than a mile. And importantly, once oil and gas development begins, that avoidance increases by an additional mile or so from prior conditions. And so when you look at the oil and gas infrastructure and the roads, and you buffer them by that 2.5 mile or 2.5 kilometer buffer, you find that 98% of the elk winter ranges are within that 2.5 kilometer buffer, and 95% of the elk calving ranges are within that 2.5 mile buffer. And so these are habitats that would be avoided by elk to their detriment. In terms of mule deer, mule deer avoid energy infrastructure, and that's a long-term effect based on the science. These are some quotes from Sawyer et al. Study in 2017 from Wyoming. And in this study, mule deer did not habituate to oil and gas development even after the 15 years of the study. And that's important because you would think that these animals would just go back to business as usual once they got used to the disturbance that was out there and return to their original habitat uses and their original behaviors, but they don't seem to do this. And so oil and gas development, even long after the drilling phase, remains a long-term impact on these species. And you can end up with population level impacts on oil and gas, even with well clustering and liquid gathering pipelines that were put in place on the Pinedale anticline on the Pinedale Mesa to reduce the truck traffic. The development displaced mule deer from their preferred habitats to more marginal habitats. And as a result, there was a 36% decrease of the mule deer population using the Pinedale Mesa following oil and gas development. So that's a major population drop as a result of the oil and gas development. That drop was even in the face of using these liquid gathering systems. In other words, connecting each well pad to a pipeline and to central tank batteries so that you don't have these heavy trucks going out to each well pad to drain the condensate tanks. That was a significant reduction of truck traffic, but what it didn't do is it didn't prevent the impacts to the mule deer population, which declined by more than a third as a result of development, even with these safeguards in place. So in terms of mule deer avoidance and what are the metrics based on the science for mule deer and oil and gas, from a Sawyer et al. 2006 study, the avoidance of a well pad was 2.7 kilometers, or about 1.5 miles. A little bit less from a 2009 study by the same authors in the Pinedale anticline, but not a major significant difference in terms of using that liquid gathering system. And 4.3 kilometers from a conventional well pad, though, in that study. So an even bigger avoidance compared to the liquid gathering system in the 2009 study. Not so much difference in the 2006 study. There's also been found Northrop et al. This was a Colorado study, 0.8 miles from active drilling. And in Wyoming, a different figure, 7.5 kilometers from active drilling. So widely varying findings, but active drilling obviously having an effect on mule deer habitat use. And avoidance of areas within 0.4 to 0.6 kilometers from a road, even in forested terrain. So these are all impacts that are being levied on mule deer from oil and gas development. So when you look at the impacted areas within 1 kilometer from roads in open habitats and with 0.6 kilometers in wooded habitats, so accounting for that difference between open habitats and wooded habitats, 58.6% of the mule deer summer range in this Colorado River Valley field office would be affected and avoided to some degree by mule deer, and 75% of the winter range. So these are the cumulative impacts across an entire river basin, showing that the majority of the winter range and about half of the summer range are being negatively affected by cumulative effects between oil and gas development and the existing road system together. And remembering that cumulative impacts aren't just the cumulative impacts of oil and gas, but oil and gas added to the other existing impacts that are already out there on the land. This can have some population level effects on mule deer, as mentioned before. Johnson et al. Study from 2017 found that fawn recruitment was significantly reduced within 2.7 kilometers of energy development. So if you took roads and oil and gas infrastructure and you said, okay, what is within 2.7 kilometers of existing roads and existing energy development today, 99.4% of mule deer fawn production area based on CPW mapping would be within that buffer. So we have a heavy level of cumulative impact already in this field office. In terms of what the direct loss of habitat is, it's relatively small. So here, a study from Northrop et al. 2015 found that mule deer had 100% avoidance within 0.2 kilometers of well pads, or 1/10 of a mile. So that's a pretty short distance in a matter of yards, really. And if you map that out, it's only 1.6%. A complete loss or total loss of habitat effectiveness. So that's habitat subtracted from their base. But when you take into account avoidance, then that number becomes quite a bit larger based on the ArcGIS analysis and the maps we showed previously. Effects on migration. I think these are very significant. Mule deer do what's called surfing the green wave in the spring. And what that means is that they're migrating along the spring green up from lower elevation winter ranges to higher elevation summer ranges. And this becomes critically important because these animals are trying to time their fawning and their calving with the peak of spring green up. They're trying to time their migration so that they're moving along that green wave of spring green up, which has the most digestible forage, has the highest crude protein, has the most nutritious forage. And so they're maximizing their recovery from winter as they're moving from their winter range to their fawning habitats. And the females that are pregnant are building up for the nutritional strain of lactation, which happens once those fawns and calves are born. So it's critically important that these animals are able to surf that green wave and maximize their nutritional intake during this critical spring season, because they're coming out of the winter when things are very scarce and their body condition tends to deteriorate. So what does that mean for oil and gas development? There have been a number of studies done in Colorado and Wyoming looking at the effects of oil and gas development on these mule deer migrations, and finding that either the mule deer are speeding up their migrations or sort of leaping the green wave, if you will, and jumping ahead of it. And that means they're, landing in their fawning habitats ahead of when the spring green up happens, and they're having a lower availability of high quality forage, or they're getting slowed down. But either way, they're getting out of sync with that green wave. And so their migration is being put out of sync with the plant phenology that supports their optimal ability to have healthy pregnancies and surviving calves and fawns. So one of the things that's an important finding from a 2020 study by Sawyer et al. Is that habitat use for migrating mule deer sharply declines when surface disturbance exceeds 3%. So that's 3% per square mile. So, that's a very small amount. You think 97% of the habitat is completely untouched. Only 3% is affected. When you look at this from an oil and gas perspective, it's been my experience based on a lot of analyses of different large-scale oil and gas projects. 3% is about the level, a little bit less than standard well spacing, or 160-acre well spacing, 4 wells per square mile. That's about the threshold. Once you get up to that threshold of 4 wells per square mile, you're exceeding that 3% threshold, and you're moving yourself into this impact area for these species. And what we found in our GIS analysis of this field office is that that 38% of the winter range acreage is above 3% surface disturbance. 12.7% of the summer range or fawning habitat exceeds this threshold. And combined, 21% of these two types of habitats are exceeding the threshold throughout the drainage basin. And it's not just elk and mule deer. It's also sage grouse and lesser prairie chickens that have cumulative impact thresholds. So we saw that, you know, for elk and mule deer, for elk, you had that 1 linear mile per square mile. That's the least that you can do to kind of give the elk the cumulative effect that they need and provide that guardrail to prevent cumulative effects from tipping over into habitat avoidance. For mule deer, it's a 3% surface disturbance. For sage grouse, what the studies have shown pretty strongly is that there's also a 3% surface disturbance maximum. And even with a 3% surface disturbance maximum being applied, in some cases, we're now seeing that the latest USGS study that came through and showed continuing decline since 2015 indicates that maybe that needs to be scaled to an even tighter standard. For Gunnison sage grouse, based on Aldridge et al. 2012, that's the key study on human impacts on Gunnison sage grouse. 2% is the threshold that should be applied. Road densities ought to be applied at 1/2 mile per square mile for Gunnison sage grouse. That's shown also from the Aldridge et al. 2012 study. And you ought to have no surface occupancy buffers extending from sage grouse leks, whether they're greater sage grouse or Gunnison sage grouse, at least 4 miles. The current regulations at the state level is only 1 mile. That's completely ineffective. In addition, there are some noise thresholds that are critical. The cumulative effects standards that you guys have working up have a section on noise. That should be capped at 3 decibels for greater sage grouse and 27 decibels for Gunnison sage grouse at the lek. Currently, right now, the current draft regulations, what they do is they effectively authorize the oil and gas industry to undertake a cumulative effects analysis, but they don't necessarily provide any hard and fast limits on how many cumulative effects are allowed. So if the ECMC is to implement the law's direction to avoid, then mitigate, or then minimize, then mitigate, there's no avoidance for any of these species except for the sage grouse. For the elk and the mule deer, you have high priority habitats that are designated, but they're not given any no surface occupancy restrictions under the current regulations. And they're not given any limits on how much road density or how much well density that you can apply in those kinds of habitats. That's something that we would strongly encourage the ECMC to rectify by adding some measurable, enforceable types of limits on cumulative effects, in addition to having the cumulative effects analyzed. If you get into the posture of having the operators describe the cumulative impacts for each individual well, kind of 1 mile radius area, and then kind of negotiate back and forth with each individual well holder as to what the limits ought to be on a case-by-case basis, you're not going to be looking at a landscape scale that is meaningful for the species you're trying to protect. It's also true and important to note that the most recent August revision of the rules basically struck down the idea that you'll look at species by species cumulative impacts. There's really no way to measure cumulative impacts without looking at individual species. Ecosystems are collectives of the individual species that make them up. It's necessary to focus on species that are indicators of ecosystem health, and some of the species for which we have known scientific thresholds and we can understand what the limits might be are the good indicators that should be used for these species by species efforts. So in conclusion, the cumulative impacts to elk and mule deer up to this point have gone essentially unregulated. And the result is that currently in the Colorado field office, we have well field road and pad densities that exceed the thresholds that elk and deer habitat effectiveness can tolerate. And the cumulative impacts really can only be measured and mitigated on a species by species basis. There's no meaningful way to implement a prevention of cumulative impacts without measuring them based on species, because there are no thresholds that have been identified that say this is what an ecosystem can take. It's too complicated an engine. Certain elk and mule deer habitats are already listed as high priority habitats, but they're not managed under NSO stipulations, and they have no substantive protections today. So there's no avoid, there's no minimize. What basically happens for the elk and mule deer high priority habitats is you skip straight through to mitigate. And once the habitats are already impacted, it's very highly questionable that mitigation can replace that in a way that increases habitat effectiveness or increases elk and mule deer populations somewhere else in exchange for the habitats and mule deer populations that have been impacted in the developed area. And finally, greater and Gunnison sage grouse and lesser prairie chickens also face cumulative impact issues, and they don't currently have sufficient levels of habitat protections, although there are some at present. So WWP's recommendations are to add substantive guardrails, add measurable, enforceable measures to prevent and minimize cumulative impacts right there in your regulations, in addition to having the operators look at cumulative effects in terms of an analysis. Close the elk and mule deer winter ranges to future surface disturbance. You can have them offered under no surface occupancy. That's something that you can do and have those wells drilled directionally under those sensitive habitats. Recommend that you limit road density to 1 linear mile per square mile in elk winter ranges and parturition habitats. And that'll mean that new wells need to get drilled from existing well pads. We recommend that you should close lands that are already exceeding surface disturbance thresholds, but also, for sage grouse and mule deer, close the ones that are not to future fluid mineral leasing, and then just let the development happen on the existing leases and minimize that footprint. And then lands within 2.5 miles of identified migration routes should also be managed for no surface occupancy to avoid adding additional wells, adding additional roads to the already existing amount of impact. And finally, cluster developments and cluster roads and pipelines over the top of existing road and pipeline and well networks, and don't add additional ones to that in the habitats. So with that, I'll go ahead and stop sharing my screen, take any questions, and I'll reserve the balance of my time for rebuttal to the extent that I have any.
All right. Thank you very much. A lot of information presented there. You're now open for questions from commissioners. Commissioner Ackerman.
Thank you, Mr. Chair, and thank you, Mr. Mulvar, for your presentation. I appreciate the good information that you presented, especially on large ungulate avoidance propensities. Maybe you've given this some thought, maybe you haven't. I do appreciate the focus on the issues and the potential problems. One of the things that we, the commission, are faced with is figuring out some degree of standardization in our approach, particularly in beginning to figure out how to establish an area of impact. And I'm sure you've likely listened in on other presentations, and we've talked a lot about the dynamics, and I agree, and your presentation also helped illustrate that this is a dynamic issue. But we as the commission also are seeking some degree of standardization of process, at least from a beginning point. And so what staff has put together is a standardized 1 mile approach, which I think everybody agrees is not a static impact area, with an opportunity for expansion based on site-specific conditions. Based on some of the information you provided, do you have any thoughts or ideas or proposals for some degree of standardization of an approach in monitoring and assessing area of impact for wildlife? What I think I heard you say was it's a site-by-site analysis.
Well, I think, you could go for standardized areas for analysis, but I think it should be multiple scales, not just one single scale. So currently you have a scale that goes out a 1 mile radius from the proposed site, but also you could have a second scale that would either be an animal data analysis unit or a DAU. That's a much larger scale, or an intermediate scale. And the hydrologic unit code, the HUC 12 suggested by one of your experts in the earlier testimony is also a valid and useful and interesting level of scale to do a cumulative impacts analysis. So, if you have a single well site and you're looking 1 mile out, you might be catching 2 or 3 other wells in the area. Well, for a wide-ranging species or a landscape scale species, are you looking at a cluster of 3 or 4 wells in the matrix of undeveloped habitat, or are you looking at a cluster of 3 or 4 wells in the context of 8 or 900 wells that go 4 wells per square mile over an area of 30 or 40,000 acres? That's a big difference in terms of its cumulative impacts. So I think that multiple scaling, having a small scale that you already have suggested, having a medium scale that might be a Huck 12, and a large scale that might be a data analysis unit might be an interesting and germane approach to try and catch the differences in scale. And obviously, you're looking at different species, right? So for elk and mule deer that are maybe migrating over dozens or maybe even 100 miles at most. This is a species that requires a large analysis unit. If you're looking at a say an oil shale endemic plant that might have 36 occurrences over a span of half a dozen acres, that might be a much different kind of scale. So you want to have small scale a look and a larger scale look at the same time to account for the differences between small scale species and species that are using the landscape at a much larger scale.
That's helpful. Thank you for that response. And what I'm inferring from that is potentially different, I don't want to say intensity levels, but different levels of analysis based on those different scales as they broaden out. That's
correct.
Okay. I also, just a couple of clarifications, wanted to, let's see, I had a couple of notes. You mentioned, I think in your concluding slide, no new well sites or industrial impacts and I think it said sensitive big game habitats. And can you expand a little bit on what you mean by sensitive big game habitats?
Yes, I would say those would be the high priority habitats that are already designated in the regulations. So you've already got these designated. Currently, they don't have any no surface occupancy restrictions. So for additional developments in those areas, to the extent that there are leases that are there, clustering those developments so that new wells happen on existing well pads. Instead of building a new road to service a new well pad, maybe use the existing road using the existing well pad, drilling directionally, either horizontally or S-turn or one of the other technologies. These technologies are getting pretty darn advanced. At the time when I wrote that directional drilling report that I also submitted for the record with our original pre-hearing statement, they were already reaching out 8 miles from the well site to tap into oil and gas resources underground that were 8 miles horizontally displaced from the location of the actual drilling. And in Colorado, that's happening a lot anyway because of the difficulties of the topography. It's steep, it's eroded. Sometimes you just can't get a well site in over your lease. But in Wyoming, we're seeing up to 75 wells drilled on a single well pad. And that's a real degree of well clustering and concentration of impacts because it's not necessarily the existence of most of these wells are natural gas. Some are oil, but most are natural gas. And the oil ones, they have the pump jacks that move all the time. The natural gas well sites are just sitting there quietly. It's not just the well sites themselves that are causing the impact. It's the human activity at the well site, the vehicle traffic to and from the well site. That's what's most disturbing for the sensitive wildlife species, be it elk, be it mule deer, or sage grouse, or lesser prairie chickens. So that's what you want to minimize, and that's what you want to cluster and concentrate. One of the tricky parts is that and I'm an environmental professional. We're not necessarily beloved by the oil and gas industry, but I am told that the individual oil and gas operators hate each other even more than they hate us. And so it's hard to get them to work together without a requirement. So to get company A to site a well on companies B B's well pad probably requires a legal or regulatory requirement on the part of the state to say you have to do it, so that they can say, I don't like you very much, but okay, the law says I have to let you have your well on my pad, and so you can have it. It's to get the oil industry to work together, is one of the potential beneficial outcomes of an ECMC rulemaking.
Yeah, thank you. I think we certainly have seen increasing clustering of wells, and we, the commission, continue to encourage that. So appreciate those comments. I think my final question for you was, I thought I heard you say that unless it's NSO, that would be no surface occupancy for those that may be wondering what that is, that there isn't any other substantive protection. Did I mishear that? Or are you saying if it's not no surface occupancy, no other wildlife protections are protective?
No, that's not what I'm saying. I guess what I'm saying is the current regulations don't require no surface occupancy for the high priority habitat for elk and mule deer currently. Some other species get that NSO treatment. Elk and mule deer don't. And elk and mule deer also don't have any threshold-based reductions in well field density or in road density that are currently applied in the regulatory framework that governs oil and gas development at the state level. So what we could have through a rulemaking such as this one is the application of those kinds of either avoid, which would be the no surface occupancy, or minimize, which is set limits on how much well density, how much road density are permitted in the context of cumulative impacts. And one of the beneficial outcomes there is that it sets a bar that's universally understandable for the industry and makes it fair for each industry operator, so that you don't get a case where, industry operator one comes to the ECMC and gets one set of more lenient or more restrictive cumulative impacts protections, and one gets a different level, and then squabbling ensues. It also allows the industry to plan ahead and know what the level is, instead of it being developed on a case by cases. They know in advance, this is the bar you have to clear. They can then engineer for that. The oil industry is tremendously innovative and capable of dealing with all kinds of different restriction levels. I mean, we've seen in Western Wyoming, in some cases, oil and gas industry going to electric drilling rigs because they have to in some cases, and it's required by a federal decision that authorizes that gas field development. That's, once you set the bar, the energy industry can clear it, and having a fair bar for everyone is beneficial and equitable to all on the industry side, and also provides, from a wildlife perspective, the biologically suitable and biologically important thresholds that the animals need to remain on those landscapes and thrive.
Yeah, thank you. And just to make sure that I clearly understand, you're not saying that minimization and mitigation techniques are not effective. You're simply saying that NSO is more effective. Is that what you're saying?
I'm saying that NSO is more effective, and I'm also saying that neither NSO nor minimization is currently in place in the regulations. And these are gaps that are there for the ECMC to fill, so that they can credibly say, we have implemented the statutory direction from the legislature on regulating cumulative impacts by putting together, not just skipping straight over to mitigation and saying, we're going to let oil and gas development happen, and then we're going to try and apply some sort of an offsetting mitigation in response to that, but we're going to do the avoid and the minimize as well.
Thank you. I appreciate your presentation, appreciate your testimony and your expertise. Mr. Chair, that's all I have. For the record, I would just state that I believe there's significant minimization that's worked into current ECMC rules. Wanted to make sure that that's on the record. Nonetheless, I appreciate Mr. Mulvar's testimony and his expert counsel. Thanks.
Yeah, thank you, Commissioner Ackerman. I tend to agree. I've got some questions, but I'll take up Mr. Cross first.
Thank you, Mr. Chair, and thank you, Mr. Mulvar. I just want to ask a couple clarifying questions about your presentation. One, and Commissioner Ackerman brought up the industrial impacts as well. And I'm curious, as you're talking about industrial impacts, are you talking about impacts beyond oil and gas, or are you saying these are just oil and gas impacts?
Well, the oil and gas impacts are overlaid over whatever previously existing impacts are already out there on the environment. So, you might have residential development, and that has some habitat fragmentation and road network associated with that. And those road networks also can result in avoidance of habitat. So you have to look at them together, cumulatively. And you can't just look at oil and gas in isolation if you want to have a true cumulative impacts analysis. There are also other kinds of impacts as well. I mean, you might have livestock grazing that's taking a certain amount of the forage in a particular area, or you might not. You might have, you might have noise that's there from a local airport that's affecting some of these sensitive animal species that might, have a major impact. So you have to look at everything that's out there in the environment together with the new impacts of oil and gas development. And those impacts are both going to be surface impacts, which have a very small percentage of the habitat that is disturbed by a bulldozer, but also, more importantly, the disturbance impacts of displacement from adjacent habitats. That's one of the take-home messages that I hope you'll bring from my presentation, that it's not just the gross number of acres that goes under the bulldozer blade, but it's also those buffer areas that radiate out from the well site, that radiate out from the new access road, that are going to be, to a certain degree, less effective as habitat for some of these sensitive wildlife species.
I appreciate that. And part of the reason I wanted to go into this a little bit is I definitely saw some federal management kind of terminology included in this. And I know that both Western Watersheds Project and a lot of your previous work has dealt with BLM lands. And so I just want to make sure I understand part of this, because I know you said preventing oil and gas and other industrial impacts. And I'm just wondering how you propose that we manage some of those other impacts. And you mentioned things such as like the grazing and the residential. Are you saying that we should just focus on the oil and gas? If there's other things, if other things try and come in later, how do we adjust for that?
Right. Well, I think, what I'm saying is those other kinds of activities, which are not going to be regulated by the ECMC and maybe not by the state in any way, just have to be factored into a cumulative impacts analysis. In order to have a valid cumulative impacts analysis, you have to look at all the different impacts together and collectively. But you have the authorization to issue state permits for oil and gas, and to then regulate the type, the class of development that is permitted, and say whether surface occupancy is permitted or whether it's authorized under a no surface occupancy standpoint, regulating well densities, regulating how much percentage of the landscape can be dedicated to oil and gas infrastructure. These are things that the ECMC and the state, in its state permitting process, could potentially regulate. And this is a role where the ECMC can, through its regulation of permitting of wells and access roads and pipelines and other sorts of industrial disturbances, can play its part in protecting the land for the wildlife habitat and the biological resources that are mentioned in the statutory framework.
I guess I just want to understand a little bit more, understanding that we have authority over siting, understanding that we have authority over, well, beyond that, sort of the way the pad will look, where the roads can go, things like that. I'm kind of curious, especially if you're looking at, and obviously we're dealing here with a lot of federal lands in some of the areas that you're talking about, but with private lands as well, how we can do a true no surface occupancy beyond the siting of the well itself, beyond looking at where the roads will be. I'm guessing, I'm wondering where we have that authority.
Well, it's a fair question, and oil and gas leasing happens privately in non-federal situations and federally. So you'd be working with your federal partners in cases where you have federal minerals, federal surface estate. Um, but I think the way that I would think about it is if you were trying to apply a no surface occupancy, you would be limiting the pads to existing areas or existing disturbed areas, or moving the surface location of the well site outside the area entirely into an area that's not as heavily impacted, so that the mineral operator gets access to the subsurface minerals without disturbing the surface with wells, roads, and pipelines.
So really, we're not talking about necessarily ability to go on the line. It's really just focusing on the siting is what
That's right. I think that's where your authority lies as a commission.
And then the last thing I just want to quickly talk about is some of the numbers that you had for the greater sage grouse and the Gunnison sage grouse. I think the number that jumped out to me most was the 4-mile lek buffer for the greater sage grouse. Is that consistent with what the BLM resource management plans currently require?
It varies based on the BLM resource management plan. Most of the BLM RMPs west-wide require a 3.1 mile buffer. I can't recall what the Northwest Colorado plan is right now. I do know that Wyoming only requires a 0.6 mile buffer, and that's scientifically inadequate. It has no basis in science. But the current state level is a 1 mile buffer, and that we don't see as being expansive enough. What you have in terms of sage grouse, what we do know, based on Holleran's 2005 PhD dissertation, is that oil and gas drilling activity, in other words, when the well is being drilled and there's a rig on the site, the impact extends out 3.1 miles from that well pad. And when the oil and gas well is in the producing stage, and this is from natural gas, not oil. So this is not where you have pump jacks moving. This is in areas where you just have quiet natural gas well sites. The radius is 1.9 miles from the well site. So if you only have a 1 mile well buffer or lek buffer, and you site a well at mile 1.1, the impact from that well and the disturbance from that well includes the lek site itself. The other piece that doesn't, that goes beyond the protection of the individual lek and the breeding and display activities that happen every morning, mostly at those leks, is what's happening in the nesting habitat that surrounds the lek site. So the nesting habitat is known to be within 5.3 miles for greater sage grouse, within 4 miles for Gunnison sage grouse of that lek. And both the leks and the nesting habitat for sage grouse, both species, have a great deal of philopatry. In other words, a great deal of fidelity to that individual lek site and the individual nest site. So there's good science indicating that male sage grouse, when they go out and they recruit to an individual lek, will continue going out to that lek until they die. Even if conditions get really, really bad for them in terms of disturbance, what happens as disturbance moves in is that yearlings will no longer recruit to that particular lek. So as the older males die off, there's nobody to replace them, and then that lek dies off in a 2 to 10 year time lag. And so the same thing happens with the nesting females. There are studies that show that the female will nest within a 1/4 mile of her original nesting site for the rest of her life, and they have really strong fidelity to those areas. So if those areas are concentrated within, we say 4 miles as a good heuristic level to think about. That number comes from the 2011 National Technical Team report that was put together by both BLM and the states. I think Colorado had a representative on that team. And we found that to be a good, credible, round review of the science. True, 5.3 miles is the area where nesting is concentrated, so it doesn't catch everything under the hoop, but it's a solid buffer distance that I think most conservationists can get on board with. A bit of a compromise, though.
Okay. Thank you. I think that's the only questions I have for you.
Commissioner Messner?
Thank you, Mr. Chair. Mr. Mulber, thanks for providing all that information. I found it fascinating and appreciate your work on this. I did have a few questions. So one of the things that often gets utilized in our process currently is timing stipulations, particularly for winter elk concentration areas or migratory corridors or calving areas or things like that. What is your thoughts on timing stipulations and whether those are an effective tool for minimization or mitigation of big game species in high priority habitats?
In terms of big game, I would say timing limitations stipulations only get you protection from drilling and completion activities, because that's all they really apply to. So you will have your drilling activity, your fracking activity, and other concentrated truck traffic outside of the season of use. But once that well is completed, that well is going to be there producing for 30 to 50 years. And that well is going to have that level of vehicle traffic tripping the well for those individual pickup trucks, going to drain the condensate tanks for the larger big rigs. And you're going to have that throughout the winter season. And that's what studies like the Sawyer et al. 2017 study on the Pinedale anticline was measuring. It wasn't measuring impacts of drilling on winter habitat use of mule deer. It was measuring impacts of having post-drilling production level impacts on mule deer. And what that study is showing is that the timing limitations have a very limited value. And the real game is, what is the well density? What is the road density? What is the horizontal offset of these disturbances from these crucial habitats? And that's what dictates whether those habitats are going to be survivable to the mule deer, not when you actually drill the well. Because if you drill the well in the non-use season and the animal comes back to a landscape that's fully developed with, full field development, oil and gas roads and pipelines and well traffic, it's not going to be much of a consolation to that animal that the drilling happened when they weren't there.
Thanks for that. That's helpful. And your point of emphasis in this, I think, and correct me if I'm wrong. I mean, you've said a lot of different things, and so I'm not trying to minimize it, but surface disturbance ends up being, and habitat fragmentation ends up being one of the biggest impacts.
The footprint of development and what that looks like on the landscape and how that is spatially arrayed is the most crucial piece in all of this. And that happens to be the piece that the ECMC has the greatest authorization to permit. So to the extent that you can have oil and gas development that is horizontally displaced away from sensitive habitats, that's avoidance. To the extent that it occurs in those sensitive habitats, to the extent that it can be clustered and the footprint can be minimized below, say, for the mule deer, that 3% threshold, that's the minimization piece. Those should be the first levels of defense for these kinds of habitats. And then if for whatever reason the development that gets authorized is still exceeding the thresholds, then go on to mitigation and see if you can't compensate for that. But that's much more difficult as a proposition.
Okay, and that actually kind of segues into my next question. I mean, do you have thoughts on the effectiveness of compensatory mitigation?
Oh, I've seen a lot of compensatory mitigation add up to very little. Famously, the one that I spent the most time delving into was the Jonah Interagency Office in Wyoming, where they spent $51 million in compensatory mitigation for the Jonah Field and the Pinedale anticline in these two offices. And they built a number of stock watering wells, so it helped the livestock industry to some degree. But in terms of the bird species, the sage grouse and the sagebrush obligate bird species in the area, in terms of the pronghorn migration corridor, the mule deer populations, all those took a major hit. And it wasn't able to compensate. And, you know, that Sawyer et al. Study that I referenced, I think it was the 2020 study that showed a 36% decline in the mule deer population, is the proof in the pudding that all of that mitigation did not prevent a more than 1/3 decrease in the mule deer population. So it didn't offset, even with $51 million. So it's a very difficult proposition. One of the things that did happen that was thought to be a big impact, or it was that there was a very expensive conservation easement that was bought. I think it was $9 million for the Summers Grindstone private ranch to make sure it wouldn't be developed. That ranch owner didn't have any intention of developing that ranch to start with. And the purchase of that easement at $9 million kept that ranch at exactly the same habitat effectiveness as it was before there was an easement, because it didn't change any practices on the ranch that increased the population effectiveness for either sage grouse, mule deer, or any other species. It just kept things the same. So if you have, you know, the pine anticline and the Jonah field heavily depressing your wildlife populations, and then over here you have a piece of private land that you've protected under an easement that remains the same, that's a net decrease for all of those species. And that's not, there's no compensatory component to that. It just, you know, it feels good, but it doesn't, and it looks good, but it doesn't actually do much for the wildlife. What you really need is a compensatory mitigation that in an offsite area increases the population capacity or the habitat effectiveness for that species. And that's a tricky proposition, and requires some real creative thinking.
Okay, thanks. Just a couple more questions. You talked about noise and the impact of noise, and different noise standards. At least in my notes, I have 31 dBA and 27 dBA. These are specific to greater sage grouse, Gunnison sage grouse. I wonder if you could just talk a little bit more about the impacts of noise, and whether those impacts are seasonal impacts, i.e. drilling and completion activities, or whether those year-round impacts, truck traffic and those type of things. And are there impacts limited from a noise standpoint to sage grouse, or also to big game?
I have no doubt, as a big game biologist, that there are real impacts of noise to big game species, but nobody has been out there with the acoustic measuring technology for the big game species and done that I'm aware of a rigorous hypothesis testing study on what are the thresholds for elk or mule deer. I haven't come across those. Maybe they've been done and I'm just not aware of them. There has been an extensive body of science developed on greater sage grouse, and an additional body of science done on Gunnison sage grouse that does critically look at what those disturbance thresholds are. And what you're talking about here, it can be, you know, some of the earliest noise studies were done on road traffic noise, more so than drilling noise. And I would say that in a natural gas well setting, when you're talking about a natural gas field, there's hardly any noise in a facility to speak of, in my experience. That can vary. Sometimes they can have equipment on the well site that does make noise sometimes, but most of it's pretty quiet. It's really the truck traffic that's your noise. And obviously drilling is a huge noise issue, and that needs to be limited too. One of the things that I'm not sure whether this rulemaking even covers, but might be coming in the future, is geothermal development, which is a fluid mineral development where you're using the heat of the electricity. That turns out to make a pretty considerable amount of noise. And so you'd want to be really careful about where you cite those things. I'm not sure whether that even falls under this rulemaking or not.
Okay, thanks for that. That's helpful. So I'm not a wildlife expert. And so this data analysis unit metric, give me a better idea of like what that is, what size of that is. I mean, I'm now hearing the Huck 12 and I have a pretty good understanding of that and some other metrics, but this is the first time I'm hearing about the data analysis unit. So what are the typical sizes of those?
The DAUs would be somewhere on the order of 10 to 20,000 acres, I would say, as an average size. That's just a guess, and they're a CPW metric, a way
Okay.
of looking at the habitats.
Okay, thanks.
Helps them manage these species.
And then, nope, that's it. I appreciate your time, and that's the questions I have.
Mr. Mulvar, just to kind of, and Tricia, Commissioner Oath may have questions too, but I've just got kind of one kind of broad sort of summary question. As I listened to your testimony and as I looked at your maps, and you threw out a lot of different scientific studies, for instance, 0.8 kilometers to active drilling or 7.5 kilometers to active drilling. I'm trying to figure out how to square that. You talked a lot about the oil and gas and existing roads, surface disturbance exceeding 3% threshold for mule deer, 4-mile lek buffer NSOs. I'm just trying, but then I appreciated your testimony to Commissioner Messner just now that you sort of start with that, but then you then go to mitigation if you're beyond the thresholds. And I'm just trying to, is there anything left to develop from your perspective as your scientist from a cumulative impacts perspective? It seems like you kind of chalked off everything as off limits in the area in which you studied.
Well, I would contend from a legal perspective that if there's a leaseholder that they have a legal opportunity to explore and develop on that oil and gas leasehold somewhere, and have, a bottom hole target that reaches into that leasehold from some surface pad. On federal land, under federal law, you're traditionally thought to have the authorization to site at least one well pad somewhere on the leasehold. Increasingly with directional drilling, it may be that it is reasonable to say you have a right to drill within the operational parameters of your technology to get to that leasehold without being on the surface. And that's where you see so many no surface occupancy leases being authorized by the Bureau of Land Management. But I think that, to me, as from a climate and energy standpoint, should we have more oil and gas development? It's hard to justify it. But at the same time, I think we're going to have more oil and gas development. So the question then becomes, assuming that there is going to be some, let's figure out how to regulate it to minimize and avoid those impacts to the extent that we can to these wildlife species. And then for those impacts that we still can't fully avoid and minimize, go on to mitigation. But I think there will be. There's no question. But it also is true that that the overwhelming majority in the Colorado River Valley Field Office, for example, of the sensitive habitats for elk and mule deer are already impacted to some degree. And that doesn't mean 100% avoidance, but it does mean a certain degree of avoidance and a certain degree of stress for those animals that do use those habitats regardless. And
are you familiar with our current rules around wildlife?
I am somewhat familiar with your rules around wildlife, yes.
Okay. I mean, again, I agree with Commissioner Ackerman. I think they do a fairly good and extensive job of analyzation and, avoiding, minimizing, and mitigating. But I really appreciate your testimony today. I think you've illuminated a lot of good topics for us as we broach down this path. Commissioner Oath, did I miss you? Did you have anything else to add?
No, I do not, Mr. Chair. Just a thank you to Mr. Mulvar. Very informative and very helpful. So thanks for all of your testimony and written materials.
Well, thanks to the commission for
holding
such a thorough hearing.
Thank you very much. Let's take a short morning break. Let's return at 10:19. And during that time, I would like staff to get Green Latinos up with their witnesses and their PowerPoints, make sure that's working because they're going to be next. Okay, good. And this is the Colorado Energy and Carbon Management Commission. It's 10/19. It is September the 5th, and we are taking docket 2406-00145. Appreciate the next stakeholder, Green Latinos, for getting ready during the break. It really does help as we try to continue to move things forward. And with that, I would recognize whomever it is that is going to lead us off for the party, Green Latinos.
Thank you, commissioners. I'm Robin Cooley. I'm an attorney with Earth Justice, and with me today are Jess Sasmer and Mike Freeman, also with Earth Justice, and we represent Green Latinos in this rulemaking. Today, we'll also be hearing from Ian Thomas Tafoya and Patricia Garcia Nelson with Green Latinos. Ian currently serves as the Colorado State Director for Green Latinos, which is a national nonprofit organization that brings together Latino leaders to address environmental issues affecting the health and well-being of Latino communities across the state. The organization is committed to amplifying the voices of minority, low-income, and tribal communities and promoting health equity and environmental justice. In addition to his role with Green Latinos, Ian served as the co-chair on the Environmental Justice Action Task Force. Patricia Garcia Nelson is the Colorado fossil fuel just transition advocate for Green Latinos. Patricia is deeply involved in policy and regulatory work that helps shape protections for communities and improve air quality around the state. Patricia has a long history of advocating for communities and residents living near and experiencing the adverse impacts of oil and gas operations, including before this commission. So with that, I will pass it over to Patricia to start our presentation.
Thanks, Robin. To frame our comments, it is critical to acknowledge that oil and gas operations cause harm to communities across Colorado, especially Latino communities. To start, many communities experience inequitable siting practices. In our state, 58% of all oil and gas wells are in high Latino counties, despite counties covering only 35% of Colorado's territory. And oil and gas contributions contribute to real physical harm. For example, high Latino counties experience more asthma-related hospitalizations than other counties. 1 in 3 Latino children are diagnosed with asthma compared to 1 in 5 white children. Living near drilling also is linked to cancer. Latinos in Colorado have a higher cancer rate than the national Latino cancer rate, whereas the cancer rate for white Coloradans is below the national average. These physical health impacts are compounded by adverse mental health impacts. Communities with significant oil and gas drilling suffer from elevated levels of chronic stress and depression, in due part to the feelings of powerlessness and uncertainty over the harmful effects of oil and gas activities. And oil and gas impacts come at an enormous cost to communities. While some information about economic impacts like tax revenues are more readily available, adverse economic impacts will almost always be undercounted, like the high cost of healthcare costs shouldered by impacted community members. The health costs from oil and gas driven air pollution across the United States are about $77 billion annually, and those costs are not borne equally by communities. Next slide, please. One of the reasons for this harmful reality is that permitting agencies are not fully accounting for the cumulative impacts of oil and gas development, as well as other impacts on disproportionately impacted communities. This cumulative impacts rulemaking is long overdue and should serve as a vehicle for protecting communities. The legislature has 3 times directed this commission to evaluate and address cumulative impacts of oil and gas development, and most recently directed the commission to minimize adverse impacts to disproportionately impacted communities that are negatively affected by oil and gas operations. In order to fulfill this mandate, Green Latinos believes that the commission must make improvements related to at least 4 key issues in this rulemaking. Number 1, improving Rule 604 setback provisions. Number 2, adopting an adequate proximity approach for DIC protection. Number 3, establish a cross-impact standard that calls for no net negative impacts to DICs and making improvements to the community liaison position. I will now pass it to Robin. Thank you.
Thanks, Patricia. So we'd like to start with the improved Rule 604C setback from the June draft, which, as we've discussed, would require operators to obtain informed consent in order to drill within 2,000 feet of RBUs within a DIC. And as I mentioned, there's been quite a bit of discussion about this from other parties, so I'm going to try to move through this quickly. Green Latinos strongly supports Rule 604C as the baseline protection for DICs in this rulemaking for three primary reasons. First, it offers needed protections and a meaningful voice in the permitting process to Coloradans that, under state law, are disproportionately impacted as compared to the general population. Second, it aligns with the existing regulatory framework in Rule 604B, which already includes a presumptive 2,000-foot setback. And third, it is entirely consistent with legislative intent. So as we've already heard, Rule 604C is not a new setback. This commission determined in the mission change rulemaking that a 2,000-foot setback was appropriate, regardless of whether the proposed location is within a DIC. In the SBAP from that rulemaking, this commission said, based on substantial evidence in the administrative record, the commission determined that a 2,000-foot distance was necessary and reasonable to avoid, minimize, and mitigate potential impacts to public health and welfare. So drilling within this setback was meant to be the exception. And under the existing setbacks, operators can only site locations within 2,000 feet if they satisfy one of the four exceptions. Notably, one of those possible off-ramps is informed consent. So there have been some questions about whether 604C would create a situation where operators would just be offering cash to residents in order to construct. But to the extent that dynamic exists, it's already part of the existing rules through this informed consent exception. So what the 604C proposal would do is remove the operator's ability, if they can't get informed consent or if they don't want to take that route, from asking this commission to approve drilling under the substantially equivalent finding. We think that this is important for two primary reasons. One, it empowers residents of these communities to have a voice in whether oil and gas operations get sited near their homes and under what conditions. This is extremely important for communities that historically have had very little leverage when it comes to negotiating with polluting industry. And the second is that we heard testimony from Earthworks on Monday about how the substantially equivalent exception has really swallowed the rule on the Front Range, with half of the OGDP locations in recent years located within 2,000 feet of RBUs under this exception. And this is not something that Green Latinos wants to see in DIC communities. We've also heard concerns about, having a potential holdout, a person that fails to respond to communication or just doesn't want to sign anything. But again, the goal of the setback is not to create an escape valve to allow drilling in every situation that might arise. It's to incentivize operators to stay away from homes in DICs. That said, the evidence suggests that operators have been able to get informed consent under the existing exceptions. In its current form, Rule 604 includes two informed consent provisions. One of the exceptions under 604B is informed consent, and then there's also an informed consent provision under 604A for locations within 500 feet of RBUs. So according to this commission's 2023 cumulative impacts report, 13 of 71 approved oil and gas development plans were within a DIC. 3 of those OGDPs had locations within 2,000 feet of an RBU. And for 2 of those 3 locations, operators obtained informed consent from all residents to move forward with the project. So it's clear that operators have availed themselves of the existing exception. We also agree with Conservation Colorado in their testimony yesterday that the community liaisons could play a really important role in helping to ensure that informed consent is meaningful. And so we would support their proposed changes to the 604C language. The Rule 604C language is also entirely consistent with legislative intent. For example, Colorado's Environmental Justice Act emphasizes that certain communities have faced systemic exclusion from the decision-making process, and the move toward environmental justice must focus on giving residents of DICs a voice in decisions that affect their health and welfare. And that's exactly what 604C would do. It's also consistent with Senate Bill 229. The General Assembly directed this commission to administer Article 60 in a manner to minimize adverse impacts to disproportionately impacted communities that are negatively impacted by oil and gas activities. Minimize adverse impacts is defined by statute as a two-step process. First, this commission must avoid adverse impacts in DICs, and then the commission must minimize or mitigate only those impacts that cannot be avoided. Importantly, SB 229 does not limit how the commission can satisfy this statutory mandate. Rather, it delegates the authority and the responsibility to the commission to decide how to first avoid and then minimize. As this commission recognized during the mission change rulemaking, a 2,000-foot setback is, quote, necessary and reasonable to avoid, minimize, and mitigate potential impacts to public health and welfare. So you would be acting well within your authority and discretion under SB 229 by adopting Rule 604C. And many of the legislators who crafted and support SB 229 agree. A public comment letter signed by 7 state senators and 17 state representatives makes it clear that removing the 604C setback deviates significantly from the intent of 229 and would undoubtedly lead to an unacceptable increase in harm to those already vulnerable communities. So Green Latinos joins the call from these legislatures, urging this commission to adopt 604C from the June draft. Finally, the alternative direction that was put forward in the August draft does not go far enough to provide protections to DICs. Most problematically, it eliminated 604C. The August draft rules did add provisions in the 300 series that in some cases would provide DICs with enhanced process and informational safeguards, but in many cases would actually weaken the DIC protections from the June draft. It also introduces the largely illusory procedural requirements for cumulatively impacted communities, which are a subset classification of DICs. That Green Latinos and community members have long opposed, and Ian will talk about that in a minute. So while these procedural and informational requirements are important, and Jess is going to talk about some of our proposed changes there, Green Latinos does not feel that they are an adequate substitute for the 2,000-foot setback waivable only through informed consent. So now I'm going to pass it over to Jess Sausmer.
Thanks, Robin. Next, I'd like to talk about Green Latinos' proposed proximity approach for enhanced protections in disproportionately impacted communities. We understand that there are some oil and gas locations in more remote parts of the state that are within a DIC, but not necessarily proximate to sensitive receptors. The proposed rules, and especially the August draft, account for that reality, largely utilizing a proximity approach to trigger protections in DICs where procedural safeguards in those communities are targeted at areas near where people live, work, or play. The framing might change slightly between provisions, but this slide captures that proximity concept, where enhanced protections apply if a proposed operation is 1, within a disproportionately impacted community, and 2, within a certain proximity to residences, schools, or childcare centers. Green Latinos generally supports the proximity approach to trigger protections for DICs in this rulemaking. But for such an approach to provide meaningful community protections, the geographic radius must be larger. The August 2nd draft uses 2,000 feet as the default radius within the proximity framework. But a 2,000-foot radius is unreasonable in light of the presumptive 1 mile impact area. By defining the presumed impact area as extending 1 mile from a well pad, the proposed rules recognize that oil and gas operations have the potential to cause adverse impacts at least out to that distance. The proposed 2,000-foot default radius unreasonably constrains safeguards for disproportionately impacted communities to roughly 1/3 of its presumed impact area. To recognize that residents may be harmed by the operation, but do nothing to engage those residents in the permitting process or even notify them of the proposed operation is unjust and inequitable. Any person living in the area where a proposed oil and gas operation has, quote, the potential to contribute to cumulative impacts, quote, in other words, the impact area, should be entitled to those protections. Instead, Green Latinos proposes that the commission adopt a proximity approach to trigger procedural protections in DICs, but with a radius of at least 1 mile. As we heard from commission staff, there are so many impacts that could occur and receptors that could be impacted beyond 2,000 feet. Generally speaking, we have proposed a 1 mile radius in DICs for things like agency consultation, community outreach, and notice throughout the rules. This 1 mile radius would match the scope of the impact area, ensuring that potentially impacted residents are appropriately engaged in the permitting process, and that the scope of information provided by operators for proposed locations in disproportionately impacted communities corresponds to the impact area. Green Latinos offered red lines on this revised proximity approach in Exhibit B enclosed with our pre-filed written testimony, with a few examples included on this slide. We would encourage the commissioners to review Exhibit B for more detail. But overall, this is a streamlined revision that will offer meaningful protections to communities without being unduly burdensome for operators or this commission. Providing a little extra process to communities in the form of expanded consultation or community outreach plans, for example, is a relatively easy lift for operators, aligns with this commission's goal of encouraging increased public participation in the permitting process, and would better inform and engage disproportionately impacted community residents. In line with this 1 mile approach, Green Latinos also proposes to expand the existing setback in Rule 604B from 2,000 feet to 1 mile of residences for proposed locations in DICs. Under this proposal, there would be a presumptive setback of 1 mile in DICs, but proposed locations could still move forward within that 1 mile radius if operators satisfy one or more of the conditions in Rule 604B 1 through 4, including if an operator demonstrates that it will provide substantially equivalent protections for DICs. We propose red lines on this concept that can be found in Exhibit A, also enclosed with our pre-file written testimony. And now that we've laid the foundation for this 1 mile proximity approach, Ian will explain why Green Latinos prefers this framework to the concept of cumulatively impacted communities.
Thank you, Jessica, and thank you to the commissioners. I'm Ian Thomas Tafoya, the State Director of Green Latinos, and we're here to talk to you about the superiority of this proximity approach that takes into account the actual emissions and the potential harm that is impacting communities, and why disproportionately impacted communities as a whole deserve this protection, and why we don't want to continue to set a precedent around the term CIC. Next slide, please. So, as you heard in the beginning of this presentation, I served as the chair of the Colorado Environmental Justice Action Task Force, and I have the recommendations pulled up here in front of me. With a conversation about CIC versus DIC, I think one of the most important things that we need to think about when we're talking to disproportionately impacted communities across the state is that we need to have a way of explaining it to them, but it's standardized across agencies. It's already a hard concept to understand if you're a disproportionately impacted community, and it takes time for us to be able to have that conversation. And one of the commissioners here was on that task force. You may recall that several people in the community didn't even like that term, disproportionately impacted communities. They wanted more of a positive framing. But we ended up in this situation with disproportionately impacted communities, and we made changes from the original statute that had been put forward from SB 1266 And in that time, we recognized that there needed to be some flexibility for agencies in order to implement the work that they were doing, and that it would have to go through rulemaking. But I think beyond the ability to do this, I think it's very important to understand that leading environmental justice organizations like Green Latinos have done an extensive amount of community engagement across the state, traveling to all 64 counties. This year alone, having more than 20 events across Colorado just through the legislative session, and continuing to have these conversations about helping people understand what rights they have. And the more complicated we make a system of saying, well, I understand I'm a disproportionately impacted community, but at the Air Quality Control Commission for this regulation, I meet this definition. And for this one, I meet this definition. That doesn't help people lift the burden for environmental justice. That doesn't make this more plain language for people. And this is a critical part of the Environmental Justice Action Task Force recommendations from my perspective. I know that many might be aware, and I think this is in our original statements, that Green Latinos we are in active litigation now with the Air Quality Control Commission to challenge this for the very specific reasons that I'm telling you now. And so I think what's more disconcerting for Green Latinos in our perspective is that knowing that environmental justice and environmental organizations are aligned against this concept, have done to the community stakeholding, have even gone to the first time, I can tell you the first time for Green Latinos ever brought active litigation against a rule. We're in a situation where another agency wants to double down and thinks that this is an appropriate outreach for environmental justice communities, that this is something that we're asking for. We believe the proximity approach better protects our community, and we are very clear that we do not want to continue to set a precedent of using CICs as a way of excluding disproportionately impacted communities. Now, I think there are some examples, and maybe I'll get these in the questions, where I think targeting of resources may make sense. But when we're talking about putting the burden onto industry to protect communities, it's certainly not that case. If we go to the next slide for me, please. One thing that we want to make very clear is that from our research, we know that there have been 0 permits within the last 5 years that have been authorized in what is defined as a CIC under this definition. So if you go to the next slide, we just don't believe that it meets the standard of warranted and reasonably tailored to protect people. Some may make an argument, oh, this is additive, it's going to protect our communities. But when you see that it actually doesn't have a real impact because we're not seeing development within these communities in the last 5 years, you say, is this reasonably tailored or is it warranted to protect our communities? We don't think so. So just to reiterate my final argument here, disproportionately impacted communities as defined and protections for all with a burden on industry is certainly the choice for Green Latinos, and the amount of painstaking resources that we've put into community outreach across the state, we can tell you that our allies agree with us. And I think I'm passing it on next.
Yeah, thanks, Ian. Next, we'd like to talk about Green Latinos' proposal for a cross-impact standard. So as we heard from Commission staff, Section 315 of the proposed rules requires operators to perform a cumulative impacts analysis that's going to provide valuable information regarding, a lot of different impacts, air, water, wildlife habitat, and information about DICs. But there's nothing in the rule that tells the Commission what to do with all that data, especially when it comes to DICs. Specifically, the rule doesn't provide a standard for determining whether all the existing and projected impacts are simply too much to impose on already overburdened communities. So what we are proposing is a no net negative impact standard. And this is similar to the one that the legislature adopted for injection wells for CCS, and that's the language that you're seeing on the screen there. So this standard requires that the Commission deny a permit where it has net negative cumulative impacts on any DIC. And we recognize that the Commission has not yet implemented this statutory language, the standard for CCS. But we do think it's important to establish a similar standard here so that the Commission is saying to DIC communities that you will make a determination based on the best available information that you have, whether on balance a project is net positive or net negative for DICs. and whether the project should go forward. And then importantly, make a record of that decision. So, I think there are going to be a lot of considerations that will go into that decision, looking at the adverse impacts, the beneficial impacts, how do they compare, how do community members feel about the development? And one tool that's already come up in some of the discussions that we think could be helpful for assuring the commission that there are net negative impacts might be community benefits agreements where operators can commit to certain steps like plugging other wells or air monitoring in exchange for community support for a project. But at the end of the day, our proposed standard would help level the playing field for DICs and ensure that operators are working not just to mitigate the impacts of their development, but to on balance avoid harm altogether. I'll now pass it back to Patricia to talk about the community liaison.
Thanks, Robin. As the final part in our presentation, we want to emphasize the importance of the community liaison and suggest some improvements to this role. We have worked for years with the Commission to build trust within our communities. A community liaison would help bridge a gap and allow community members to participate in the permitting process. It has taken me nearly 8 years to learn everything I know about how and what this commission is able to do. Having someone help navigate everything would have made a real difference for me. And we hope that it will positively impact this process moving forward. Green Latinos provided red lines in Exhibit C, also enclosed in our pre-filed written testimony, to help fortify and strengthen the role of the community liaison. We encourage the commission to, and which we encourage the commission to adopt. These red lines incorporate key concepts from other partners and are supported by Conservation Colorado, Western Colorado Alliance, Sierra Club, Earthworks, the allied local governments, and Larimer County. Our proposal recommends improvements to the qualifications, duties, and hiring of these liaisons. First, given the importance of this role, we want to ensure that the liaisons are sufficiently independent. We request that 1, the addition of a conflict of interest provision to Rule 224B to ensure that there's no actual perceived or potential conflict of interest between the liaisons and any operators. And 2, clarifying language to ensure that the liaisons are not subject to discipline or adverse professional consequences should they take a position on behalf of a DIC that is different by those taken by the director, ECM staff, or the commission. Second, we proposed some additions and clarifications with respect of the duties of the community liaison to ensure that 1, the rule extends to all matters within the commission's jurisdiction and is not limited to new applications, but contemplates issues and community concerns that may arise related to oil and gas operations after permitting. 2, liaisons are invited to participate in all Rule 301G pre-applications consultations for new locations within a DIC, can review and provide comments on community outreach plans, and can assist communities as necessary to enter into community benefit agreements. 3, if necessary, liaisons are empowered to communicate the views of DIC residents about a complaint or concerns related to oil and gas operations or applications to the commission. And finally, we urge the commission to reinstate the hiring deadline of December 31st, 2024 proposed in the June draft with a short as needed extension to recruit highly qualified candidates for this position. The community liaison is a positive and meaningful step towards protecting communities, but these improvements will help ensure that this role lives up to its promise. And with that, we are finished with our presentations and would like to reserve the remainder of our time for rebuttal.
Thank you very much. We could maybe stop the screen share. I'll be able to see everybody a little bit better. And then we'll open the panel up for questions from commissioners. Commissioner Cross.
Thank you, Mr. Chair, and thank you very much for this presentation. It was very helpful. And I appreciate the looking at additional ideas to try and resolve some of the disputes we've seen between some of the different parties kind of thus far to this rulemaking. I wanted to try and get a better understanding on two main parts of your presentation. Number one, I was hoping, and I know I had a previous conversation before this hearing began, a conversation with Mr. Freeman, and he said it was best to talk to you as well, but I was hoping to get a better understanding of the cross impact standard that you're talking about. And so I'm just really want to get my head around how the standard's developed, how it works. Yeah, just a better understanding.
Sure, I think I can start on that one. You know, what we're trying to do, I'll maybe start with sort of the rationale behind it. But what we want is a standard that forces the commission to look at, you know, all the impacts, all the mitigation, and decide, you know, is this too much for this community? Is this the straw that breaks the camel's back? Which is, you know, is really the purpose of cumulative impacts rulemaking. So what we envision is, you know, looking at all the adverse impacts, all the beneficial impacts, and then, you know, I think there's going to have to be, well, looking at community input, whether there's a community benefits agreement. And I think there's going to have to be exercise of the commission's discretion. And, you know, I think that could be developed further through guidance. It's my understanding that there will be some additional guidance on the cumulative impacts analysis. And so that might be a place to sort of, you know, articulate the factors that would go into this balancing. But it, you know, puts the commission in a position of making that determination of, you know, how much is too much. And, you know, if we don't do that, I think we're just not able to meet the legislative direction here to address cumulative impacts and avoid and minimize, because what we will see is incremental impact after incremental impact. And at some point, you know, we just can't continue in that direction.
Okay. And I want to definitely follow up on a couple portions of that. But overall, is the goal to look beyond avoid, minimize, mitigate, and kind of say, as you're doing this, you have to balance the benefits and the consequences, the adverse impacts, and take it from that approach in terms of the avoid, minimize, or are we kind of setting aside avoid, minimize, mitigate?
I mean, I think it fits in with avoid, minimize, and mitigate. You know, if we're going to avoid harm to communities, we've got to look on balance at both the, you know, the harms and the benefits. I mean, we're still going to have impacts. So, you know, each of these, you know, impact areas that we might be looking at, air quality, water, are going to have, you know, minimization associated with them too. So, you know, I don't think it's one or the other. I think it's sort of part of trying to both address cumulative impacts and avoid, minimize, and mitigate them.
Okay. And are you proposing any kind of, I want to say bright line, but kind of, when I hear standard, I often think of, you know, legal standards, you have to have preponderance of the evidence. You have different things like that. When you talk about the cross impact standard, I guess, is there that sort of bright line, if this, then this, if not this, then this? I think that's a big part of what I want to try and understand as well.
Yeah, I mean, I don't think this lends itself to a bright line. So you know, what we are using is the no net negative impact standard that the legislature adopted for injection wells for carbon capture and sequestration. So that's where we we took that standard. We thought it made sense because it's something that already exists in Colorado and Colorado law. So it's not a bright line rule. Like I said, I think there's going to have to be some exercise of discretion as well.
And this would apply across all DICs.
Yes.
Okay. And I was hoping that you could go into a little bit more. One of the things you talked about in the beginning of your response there was the community benefit agreement. And I was hoping I could get a little bit more detail on the community benefit agreements.
Sure. I mean, I don't think this would be something that's written into the rule. It's I think just something that the commission might consider in terms of considering a project and all the various impacts. You know, if the operator has developed a community benefits agreement with the community that is most impacted, that, you know, sets forth the idea is to, you know, get to a place where everyone is comfortable. So, you know, there might be air monitoring or plugging wells that's associated with it, or additional greenhouse gas mitigation beyond what's already required. So any number of things that could go into those agreements. And so we see that as maybe, you know, something that the commission could consider in making this determination.
And one of the things I was curious about with the community benefit agreement as well is, do you foresee that going beyond operational, we'll call them set-offs, so additional GHG requirements, additional monitoring? Do you foresee it having supporting paying for community services, paying for community gathering places, supporting activities, whether it be, you know, sports or gatherings or anything like that, or is this more so focused on the direct operational impacts?
I mean, I think it could go beyond, and I want to let Ian jump in because I saw you raise your hand, Ian.
Yeah, thank you, Commissioner Cross. You know, this community benefits agreement idea I know is become a bigger issue as we're talking about emerging tech, as the Department of Energy and IRA has pushed forward for this. But I want to just be clear, like, these aren't new concepts. Like, I come from local government. You saw that in I work for 3 branches of local government, and I could tell you, let's say a liquor license or a bar that's coming into a community where they have to have informed consent to talk with the localized community about their liquor license. They make decisions collectively about, hey, we're going to close the bar at 10 o'clock and we won't blare our music loud on the patio, right? When we're talking about community liaisons and informed consent and what could end up in a community benefit agreement, I think the most important thing is that the community is at the table with the developer to have those conversations. What I would hope is that it would not all be pay to play to we support this, we support the localized sports team, but we're not going to have any impact on the air quality surrounding you and these other things. Could they be additive? Certainly. The most important part, though, is that the community is at the table determining what is the most important and value impact for them. And groups like Green Latinos, as well as community liaisons and other advocates, have a responsibility to educate and inform communities about what kind of things they can advocate for. But at the end of the day, it needs to be between the community for this agreement, just like it is on a localized level for any number of other kinds of licenses.
Okay, that is very helpful. I appreciate that. And then the other thing that I wanted to get a little more clarity on was the second point, the proximity for the enhanced protections. I think I understood you to say is that instead of the language that's currently in the draft, the August draft, that says within DICs within 2,000 feet of an RBU, HOBU, et cetera, in a disproportionately impacted community, changing that to then say within 1 mile to meet the same impact area that was proposed by staff. So then you would be able to have development within the 1 mile, but then you start to do the ESPs, the additional protections, the additional notice and things like that, that would currently be within the 2,000 feet, but extending that to within the 1 mile.
Correct, Commissioner Cross. Our proposal would be extending those procedural protections in the rules from the default 2,000-foot radius in DICs to 1 mile. Things like CDPHE consultation, community outreach plan, public comment. And so you'll see in our red lines, we proposed extending that 2,000 feet to 1 mile in DICs. So that's correct. And then the other piece of the 1 mile approach would be our proposal to extend the presumptive existing setback in Rule 604B to 1 mile in DICs with the existing off-ramps. So it's sort of a two-piece approach. Yeah, substantial equivalence or informed consent, the existing off-ramps that are available in Rule 604B, yes. As a way to build on the existing baseline of Rule 604C that was proposed in the June draft. We see that as sort of the fundamental baseline, but as a way to build on that, acknowledging the 1 mile impact area, we would propose expanding that presumptive setback of Rule 604B in DICs to 1 mile.
Okay, I think that's what I heard you. I understood it to be, but I wanted to make sure that I clarified that as well.
No, I appreciate the clarification.
No, I really appreciate that. I think it's helpful to delve into a little bit more of these details, and I do appreciate the thoughtful consideration to try and come to some ideas about how we can bridge some of these differences from what we've been hearing. So thank you very much.
Other questions from commissioners? Commissioner Oath?
Yeah, thank you all very much. Your presentation was extremely helpful. Thanks for that. A couple of questions, some of which we've talked about before, but just kind of want to talk about a little bit more. On the first issue with setbacks, kind of recognizing very much, I get what I'm struggling with conflicting thoughts on this, right? And informed consent and the right way to go here. And part of what's on my mind and what I'm struggling with is, knowing that part of environmental justice is ensuring meaningful involvement in decisions that impact people's lives on the one hand, and on the other hand, I worry that, an approach that places so much burden on individual people to learn about potential risks and impacts and what the potential best management practices are that could mitigate it, and what should be done. Is that the appropriate way to ensure public health protection, right? Making an individual become informed about and engage in a process that make sure that an operator has agreed to things that will be protective. And I recognize that, our baseline rules also have a role in that. But just since you guys are on, you and your organization are on the ground talking to people, really want to hear your response and thoughts about how you think about that, and why where you land is that requiring informed consent is the best way to protect people who are close to potential development.
I can go ahead and start. I think that one of the most important things to remember is that a lot of people are asking. We're coming to the legislature to pass these laws because that's what our community is asking us to do. Our communities are asking us to participate on their behalf at different, policy environments. And so people want to know, and I feel like it's important that the information is readily available. People like us at Green Latinos and our attorneys were able to find all the information, despite a lot of the systems being outdated and difficult to use. But we want to make sure that all of this information is accessible, because it is difficult to find all of these things. So letting people know what's happening in their environment and being part of that decision-making process is so much in the spirit of all the laws that we've been passing in the last few years. So I think it's really, really important to, it's not necessarily putting the burden on people, but it's letting them be informed and letting them make that decision for themselves.
Okay, thank you for that. I appreciate it. Then shifting to the cross impact standard, thanks for that presentation and the additional questions with Commissioner Cross. That was helpful. One just piece of clarification. I'm trying to, would you be proposing that if that standard were adopted, is the determination based on the information that's proposed to be required in the August draft, like the Form 2B and the cumulative impact analysis, or is it different information required in order to apply that standard?
I think it's primarily the information from the cumulative impacts analysis and the draft. For example, like community benefits agreements aren't in the regs anywhere, so there might be additional information as well that would be relevant to your decision. So I think it would be a little of both.
Okay. Sorry, just taking notes. That's helpful. Okay, and then I'm trying to understand how that standard in practice would be different from what is proposed. So could we look at the rule? Shoot, it's going to be in 315. I'm going to lose track of at the very end of 315, right before 316. There's a subsection 3 that talks about the commission's review of cumulative impacts analysis. And you're probably scrolling, so I will.
Are you talking about 315B3, the adequately evaluate and address cumulative impacts language?
Well, the title was different, so let me see.
Okay.
Yes, I am. Yeah. So the 3, commission review of cumulative impact analysis. So commission will review the operator's cumulative impact analysis and determine whether or not the proposed application, adequately evaluates and addresses cumulative impacts. And then in making the determination, commission will consider these factors. I'm trying to square that with kind of the cross impact standard or no net negative impact, because it seems like that is what would be considered. So just how do you see them as being different?
Yeah, I mean, I think that they're similar, but I think saying there will be no net negative impacts actually gives us a standard for what it means to address. Because address could mean a lot of things, and it doesn't necessarily mean on balance, we're not going to have impacts on DICs. So we see this as a stronger requirement, and sort of, or maybe stronger is not the right word, but a more a standard that tells us what the threshold is for addressing, and that's not having that negative impacts on DICs that are already overburdened.
Okay, so maybe just a little bit more like explicit about what the commission's determination is and what they're finding. Okay.
Yeah, another I think important part that we also took from the language on CCS is just the written justification and rationale for that, which I think is really important to community members.
Okay. Thank you. That's all I have.
Other questions, Commissioner Messmer?
Thank you, Mr. Chair. Thanks for the presentation and the information and all the work that the Green Latinos have done in preparation for this rulemaking. I do appreciate that. A lot of my questions have been answered, but I'm still working on the no net negative cumulative impact standard. And certainly in my different roles with local government, I've utilized the no net adverse impact standard in a number of situations. And I will tell you, it's difficult to administer, but it works. And so have experience with that. But I'm also trying to figure out how a community benefits agreement, which I understand what that is and what the intent of that is. But what is really an agreement between the community and an operator, separate from a local or state government, and how that ties into decision-making at the state government level in a regulatory process where certainly local governments, state governments have community involvement in providing feedback on what elements may need to be developed in an application to mitigate adverse impacts. And so, like you said, Mr. Tafoya, whether that's hours of operation, whether that's noise standards, whether that's lighting, whether that's, sighting, I mean, lots of different things to, mitigate adverse impacts. But in the elements of a community benefit agreement, how we would utilize that in determining ultimately a no net negative cumulative impacts. That's a mouthful. Standard. So I'm just trying to get my head around it. How, as if I'm looking at an application, and I know that there's an agreement that's been worked on between the community and the operator is presenting that agreement saying, I would like to use this agreement as a beneficial offset to whatever the adverse impacts are of a particular application. And so I'm struggling with that a little bit. So if you could provide a little color or help me understand, that would be great.
Yeah, if you guys don't mind me going first to my lawyers, and maybe you can follow up afterwards. I think one thing that's going to make this conversation a lot easier for all commissioners across all these different agencies are the upcoming air toxics regulations that are actually going to be set in human health. And so when we talk about what the net or net negative or net positive impacts to overall pollution loads and what those are known to do to our bodies based on our best scientific evidence and agreed by CDPHE, I think those kind of standards over just the ability to pollute up to a certain level, but actually truly based in health. This is actually a regulation that I was working on, the Air Toxics Act, even before I worked at Green Latinos, because it was impacting my community in North Denver. And we're now, I think 7 years later, finally going to see the first standard set in a series of rulemakings next year. And I hope that that kind of evidence is going to make that kind of job easier for you all.
No, I appreciate that, because to me, a no net adverse impact standard is if this much emissions is being produced, then we're offsetting it by retiring these facilities or plugging these wells or whatever that may be. I mean, so when you're talking public health or emissions or kind of quantifiable impacts, then, my land use brain from a regulatory standpoint, that works for me. What I struggle with is other things that may be included in a community benefits analysis and whether or not that actually offsets whatever adverse impacts there may be in an application to determine a no net negative cumulative impact standard. Does that make sense? And so I think, and that's just what I'm struggling a little bit. So I don't have a problem with no net adverse impact standards or no net negative cumulative impact standards, but I'm trying to figure out how, if there was in an agreement, which is a private agreement between the community and the operator, something like, hey, we're gonna build a park over here, and that's going to create a benefit to the community. But how I apply that then to a no net negative cumulative impact standard in our regulations. Does that make sense?
Yeah, I mean, I think one thing to offer is just one of the considerations that you're going to want to undertake is what does the community think about this? And so, you know, I think community benefits agreement and what's been agreed by the community is just additional evidence for you to consider and gives you a sense of, okay, where is the community on this? And if there's been this agreement, then that's indicative of some support for the provisions that are within that agreement. So I think of it as more informational, I guess.
Okay, that's fair. And there could be elements in there that are more applicable than other elements, but certainly give a flavor or a sense of where the community is sitting in on a particular application. So that's helpful. So thank you. Appreciate the presentation and the information.
A question or two on the community liaison provisions that you guys are proposing. I've been reading back through the red lines, and I see this conflict of interest piece, and I don't know who could speak to that better. And what I'm getting at is that the two positions and maybe more down the road, they're going to be employees of the Energy and Carbon Management Commission, and they're going to report to the community relations manager, who then reports to the director. And I don't know all the specifics here, but there are a lot of employment protections for employees of the state that address sort of a conflict of interest or issues like that. And I don't know if I've got a question or if y'all can speak to it. I maybe want to get my attorney generals at some point to speak to it. I think I get where you're going, but if that's a solution that needs to be derived at, I don't know if the way it's put here sort of syncs up with state employment guidelines. And I'm not questioning the piece. I'm just wanting to have a discussion about, you know, how we might get to the right solution. That's a really bad question. I apologize.
I'll start, and then I think Jess can help as well. I think one of the things that the community has seen is a lot of the times the commissioners will tell us that they're limited by what's in regulation. And so I think having something in this whole role is important to be in there, frankly. And I feel like that's one of the ways that the community liaison will be able to succeed at their role, is having, you know, all of these things in regulation that we have proposed in our red lines.
Ms. Salzman or Ms. Cooley or Mr. Freeman, do you mind if I get you in a room with my AGs to sort of think about this and, you know, try to, you know, see? I mean, I see what you're getting at. I just don't know if the right answer is in the red lines just yet.
Yeah, we are, we're happy to continue those conversations, and you know, would be glad to have those continued discussions and put a finer point on it. I think our goal is to just ensure that the liaisons are sufficiently independent, and that was the intent of the conflict of interest provision, both from operators, but then also understanding that the liaisons are, you know, a position within the agency, that they are an independent voice for disproportionately impacted communities and are empowered to take positions that would be, you know, different from the director or staff. And so just trying to have some of that in writing so they are sufficiently independent in practice, but happy to continue those conversations if it's not captured in the red lines.
Okay, well, I think that Ms. Osmeyer is helpful to understand kind of the rationale, and I'm going to encourage some further discussions around that point, and didn't want to miss that opportunity to ask you about it today. Yes, Mr. Tafoya. You're muted.
Apologies. Commissioner, I also think perhaps an additive voice to that type of conversation, as if this negotiation would move forward, would be to have a conversation with the Environmental Justice Ombudsman, who, created by the Environmental Justice Action Task Force, was meant to have some level of independence and authority, but yet still reports to Jill Hunsaker Ryan, the director of CDPHE. I do think there have been limitations from that role that we have seen as he has become effective in that ombudsman role, to be able to go beyond just summarizing, but saying, this is my opinion as a person who's been empowered to be the ombudsman, to be a voice for the disproportionately impacted community, so that can be officially part of the record. And I think, as we were negotiating, you and I and others at the Capitol, we have no expectation that we're going to get it all right the first time, whether that's the EJ Ombudsman, the liaisons for ECMC. We're always trying to improve and get better. And I think we've learned some lessons over the last few years about how effective that role could be and what could be done to make it better.
Yeah, and I recall those discussions, and I think we can have an offline discussion, and I think that might be helpful, and I'm happy to be involved with that. In terms of sort of landing what this is and what this is not. But I appreciate the discussion here today. Again, I don't have any answers. I just wanted to put a frame around it because I think it's a topic that deserves some additional discussion. Other commissioners with questions? Well, we really appreciate your participation with us. It's really super critical. We appreciate you all taking time out of your day to be with us and all the prepared pleadings that you've presented to us. We will look forward to continued engagement on a lot of these topics. All right.
Thank you very much.
Let's take 5, and Mr. Thomas, if you could set up whomever it is that's going to go next. Let's return at 11:26. All right, we are back at the Cumulative Impacts and Enhanced System and Practices Rulemaking. It is 11:28 on September 5th, and we have Ms. Chitor. Good morning.
Good morning, all commissioners. Good morning, Mr. Jeff Robbins.
You are recognized. Go ahead with your presentation.
All right. Are you able to hear me clearly?
Yes.
Okay, so yeah, good morning, commissioners. I am Madhvi Chitor, 13-year-old eco warrior, youngest UN Child Advisor, 2024 Time Kid of the Year honoree, and voted Best Upcoming Peacemaker by 14 Nobel Peace Prize laureates. I am the founder of 501c3 nonprofit Madhvi for Ecoethics and the Ecoethics Global Movement. I fight for every living being's fundamental right to clean air, clean water, clean soil, clean food, and great health of my generation and future generations. Thank you for taking the time to listen to my testimony, and thank you for all your efforts and that of the team, Ms. Sabrina Trask. I am suggesting a few modifications to the rules so that we may achieve the common goal of reducing nitrous oxide emissions, meeting ozone standards, conserving our water, conserving our soil and its biome, and thereby preventing our food chain contamination, and bottom line, the health of Coloradans itself. My modifications are also due to my study of statistical and regression models with Python and R programming language. The 100 series rules. Please include definitions for the working pad surfaces and oil and gas locations and their boundaries. Since they're used interchangeably all throughout the rules, not only in the 300 series, but also in the other rules. We need the definitions so that there is uniform understanding and implementation of the rules. This has a direct correlation to the definition of impact area and how its perimeter is calculated, that is, whether from the boundaries of the working pad surface or from the oil and gas location. 200 series rules. Please include the need for community liaisons for CICs. From my understanding, cumulative impacted communities would not only disproportionately impacted communities, but also communities beyond it and into the impact area. So we need a community liaison for the CICs that extend beyond the disproportionately impacted community. Please kindly include wash areas, gulches, and ditches, along with wetlands and other water bodies. Wash areas are the integral part of the land's ecosystem. The wash is a tributary that channels stormwater, flash floods, urban runoff, shallow groundwater in ranches, open areas, and valleys in national parks. It is a natural wetland, and its marshy qualities help polish impurities from water that flows through it. And it also supports a variety of plant and animal species. Please enforce monitoring and CI cumulative impacts evaluation of sulfur dioxide of surface temperatures, tremors, and ground shaking in the 300 series rules. I have mentioned these occurrences in the documents and on my slide. I have discussed with Commissioner McGowan, Karen McGowan, and also have given testimony since November 2023 that the surface temperatures must definitely be monitored in the oil and gas location and also in the impact area. Commissioner Karen McGowan at that time complimented me that I was the only one who had mentioned that. I will explain what ground heat is. When oil and gas is extracted, the voids fill with water, which is a less effective insulator. And this means that more heat from the Earth's interior can be conducted to the surface, causing the land and the ocean to warm. So, oil and gas extraction contributes to climate change as surface temperature rises. Not only the land, but also the groundwater gets warmed up. So I request all of you to include ground heat also in cumulative impacts. An example is that there's warming trends in oil and gas producing regions around the world were studied. These places, which include Saudi Arabia, Arabian Gulf, Gulf of Mexico, the North Sea, and Alaska, reported high rates of warming, between 3 and 6 times higher than the average rate worldwide. And ground heat also contributes to nitrous oxide and ozone pollution. Ground shaking and tremors. Tremors or ground shaking have been reported during drilling and wastewater injection. The USGS has released reports that drilling causes tremors and can cause a larger magnitude 7 earthquake. To enhance permeability, fracking intentionally causes small earthquakes, but it also has been linked to larger earthquakes. The largest earthquake known to be induced by hydraulic fracturing in the United States was a magnitude 4 earthquake in Texas. The density of the oil wells is directly proportional to the magnitude of tremors felt. For example, 160 oil wells in the Loudly Ranch is very, very significant. 5, please include in the definition of cumulative impacts explicitly soil quality, tremors, and surface temperatures. Why should we monitor what only was required in the statute? Soil is the silent supporter of life itself on this planet. So soil quality is very, very important, as soil quality directly impacts our food chain itself, our farm animals, game animals, beef, dairy, crops, vegetables, food, fruits, etc., etc. So the ECMC cannot ignore it. 6, please enforce soil layer evaluation up to 50 feet below the surface. A USGS report found VOCs and hydrocarbon concentrations at depths of 50 feet below the surface. 7, please increase impact area to a 3-mile radius as drilling fluids and produced water discharges. Impacts have been seen to travel to these distances. In fact, I would request ECMC to consider 2 types of impact areas, rural and urban. Urban impact area 3 miles and rural impact area 15 miles radius. I will list now all the different impact regions defined in the current ECMC rules, which were 2021 version, which are more than 1 mile. A, 303 rules, same 15 stream miles is mentioned. B, hydraulic fracturing treatment at depths 2,000 feet or less. So within 2 miles of the proposed oil and gas well. In 411 rules, 5 stream miles. In 504, 1.5 miles. 614 rules 2 miles, 803 rules 12 miles, and 907 rules 2 miles, and then 1202 is 1.25 miles. The impact area of the zone of influence is dependent on the density and the disturbance of the anthropogenic structures, like oil and gas facilities, from the human neighborhoods and wildlife habitats. Now, I want to explain my thought process in cumulative impact analysis. I was listening to the Conservation Colorado presentation as well as everyone else's, and I see the need for 3 thresholds. 1, the individual threshold units in molar concentrations or distances for pollutants, wildlife, water bodies, etc. 2, thresholds for regions. And 3, anthropogenic structure thresholds like oil and gas wells, the working pad surface, roads, pipelines, produced water ponds, buildings, the manufacturing plants, etc., etc. To compute the zone of influence of an anthropogenic structure, say just for the oil and gas industry, there are statistical regression models. And I've been studying the statistical models in my spare time using the R programming language. I also see the need for the Colorado Water Control Board and whoever is responsible for soil quality to be involved too. 8, emergency contact information of the operator must be provided to residents within the impact area. I request ECMC to mandate that the operator also provides an emergency contact number that can be used at times of leaks or at times of some untoward incident where people in the disproportionately impacted neighborhoods of an oil and gas location call a number, but call that number with an immediate response. And so far we have seen that with no response for even 2 days. 9, in the rights conveyed section of the 314 rules for CAP. If the commission approves a CAP, the operator should separately evaluate cumulative impacts for each individual oil and gas development plan proposed within the CAP. CAP rules section does not mandate any information on the working pad surface from the operator. Working pad surfaces are huge disturbance creating structures and will contribute to the cumulative impacts. So when an OGDP is submitted, a new CI report must be presented to the commission. 10, please characterize what is no significant land use changes in the CAP, the oil and gas industry. So I request the ECMC to list like what encompasses as a significant land use change in the CAP. 11, in the 1201 rule, change wildlife mitigation plan to wildlife impact mitigation plan as a little cursory change. And 12, I request that even oil wells should have a setback of 2,000 feet from buildings, public roads, above ground utility lines or railroads. I plead with the ECMC to create a rule such that the owner of the land must not be allowed to be bribed or bought over by the oil and gas industry to circumvent the setbacks. This also includes for like funding for school funding or any other funding, because we are all connected. Planet Earth is our only home and we all share it. Let's protect it. Thank you.
Thank you very much for your presentation and for the work that you've put into this. It is very well done. It is very easy to read and understand, and it's very helpful to the commission as we struggle with a lot of difficult, disparate asks from everyone. So we appreciate you being with us. I don't know that I've got any questions. Your information is straightforward to me. I can understand it, and I think it's well done. But some of my other commissioners may have questions, and so this witness is open for questions. Well, as I indicated, you did a great job, and when there's no questions, that is a confirmation of doing a good job. So thank you very much. Look forward to your continued taking time out of your day to be with us. And we will take the remainder of your time and give you a rebuttal for that if you choose to do so.
Yes, I do want to do that.
All right, Hearings Manager Thomas, please elevate yourself. Next, we've got a 45-minute presentation and then a 50 and then a 20. Just because I'm a little bit hungry, I'm inclined to take a 30-minute lunch before we jump into allied local governments. That might take a while, given that we generally have a lot of questions for that stakeholder. So
And
what
Mr.
if,
Chair,
yeah,
if I may, due to some unavailability issues, we've actually moved Greenhouse Connection Center to go next afternoon. And then we would get into the local government group. I apologize to the parties for a lot of movement, but we're trying to accommodate schedules. So I think a lunch break would be appropriate still, and then starting with Greenhouse Connection Center afternoon and then local governments.
so we'll go Greenhouse Connection Center, that's Harmony Cummins, and then we would move to the various local government presentations.
Correct.
How about let's return at 12:15. All right, we have our commissioners back with us. This is the cumulative impacts and enhanced system practices rulemaking docket 240600145. It is 12/16 and it is September 5th. We're proceeding with cases in chief from the parties. Next, we will hear from the Greenhouse Connection Center. And now you guys are recognized for your presentation.
Thank you for having us here today, commissioners. We are excited to be part of the cumulative impacts of oil and gas rulemaking. My name is Harmony Cummings, and I spent 8 years working in the oil and gas industry. I was also the bill champion for HB 1242, water conservation and oil and gas operations, and I'm a member of Colorado's Produced Water Consortium. I sat on Denver's Mayor's Sustainability Advisory Council for Environmental Justice and was the co-chair for 2 years. I currently sit on CDPHE's Community Council for Environmental Justice and Air Quality. I'm the founder and director of the Greenhouse Connection Center and a mom of 2 great boys. The Greenhouse Connection Center. We're a physical community space located in the heart of North Denver's Elyria community. We build bridges and rainbows between community members, government agencies, elected officials, health experts, and decision makers to come together to learn from each other, have conversations, and advocate for policies that are protective and beneficial to communities. What we do, we give tours so people can experience the multifacets of what impacted community members live every day. We provide experiential outings. We ask people to tap into their senses, to see, smell, taste, hear, feel, and experience what it's like being in a highly polluted and directly impacted neighborhood. This October, we'll be hosting a tour for the Air Quality Control Commissioners and staff, and we extend an invitation for the ECMC commissioners to set up a tour with us anytime. We are grateful for the staff who have already done so. We also work to elevate community and marginalized voices in decision-making processes. This rulemaking today. These marginalized voices include community members, women, single parents, Indigenous perspectives, youth, students, working parents, people who speak English as a second language, those on the LGBTQ language, and a lot of the people that we work with struggle with having access to computers, food insecurities, housing burdens, and so on. I was going to talk about what it feels like to be in one of the heart of the most polluted communities, but I'd like to pass that over to Candy, who is a lifelong resident of Swansea, a mother, and a former Denver City Councilwoman. Candy, passing it to you.
Thank you. Again, my name is Candy Sedevaca for the record. And as Harmony said, I'm a lifelong Swansea resident. My family's been in this community for now 6 generations. I'm also a mother of a new baby that I'm very concerned about living in this community. I'm a social worker by training, a community organizer, and a policy expert. As the former councilwoman representing this district, I was inspired or catalyzed to run for office by our many fights around housing and environmental justice. My family was one of the first families to file a lawsuit against ASARCO. It was ASARCO versus CDBACA, or CDBACA versus ASARCO. And that legacy, that fight was passed on to me. What was it, 4 generations later? We're still fighting the same fight, and it's only been exacerbated by the continued disproportionate concentration of dirty industries, of industries that are new and impacts are unknown. And I have tried, as not just a community member, to organize, to file lawsuits, to do community monitoring, to do ground testing, to do lead testing, to get an odor ordinance that we finally got that's unenforceable. But as a council person, I tried to get our city to really address the impacts of cumulative pollutants in our community. There was an unwillingness at the city level to take on any kind of role in monitoring or enforcement of pollution. I was forced to continue fighting at the state level. And even at the state level, when we brought the first real benchmarking or air monitoring bill, we were fighting not just the industry, but we were fighting our own public entities who are supposed to protect us. And I think that we need to take into consideration the dire situation in these communities. I have had an air quality alert that was sent to me almost twice a week, every day this summer. And I think that's only getting worse. And I hope that you all are understanding what we mean by cumulative impacts. When I say unknown industries, unknown impacts, experimental industries, those are adding on to the old pollution that we're experiencing because of transportation, because of the railways, because of highways. And then we have the concentrated industry here. These new industries that I'm talking about include marijuana. They include data centers that are being proposed for our area. Like I said, we have pollution in our water, in our air, in our school buildings, through paint, through all of the benzene and lead, all of those things. And I hope that you all are understanding what we mean when we say we need help defining cumulative impacts and really giving community tools for enforcement. And I'm also here to answer questions if there are any questions for our community. Thank you, Harmony.
Thank you, Candy. We held a variety of stakeholder meetings with our community members to talk about the definition of disproportionately impacted community, to learn more about their lived experience. And some of the things that came to light for us is that several people in our communities live in mobile home parks. This has been a protection, or one of the categories that's been removed from ECMC's definition of disproportionately impacted community, yet the residents of mobile home parks are often some of the most burdened and a lot of times on the verge of becoming homelessness, and this is their last housing option. We encourage the ECMC to please include protections for mobile home parks in their definition of disproportionately impacted communities. On the picture that you see on our screen, you can see the oil train. I used to personally work on these oil trains when I lived or worked in oil and gas. This train sits about 50 feet behind our center, and it dissects the neighborhood in half. And for years, elementary age kids would have to climb up and through the oil trains to be able to get to school and back. I wonder, does the school get in the way of your kids going to, or does a train get in the way of your kids going to school? I know that this doesn't happen in the neighborhood that my kids live in. And so I ask, when we think about disproportionately impacted communities, it's in the impacts of oil and gas. I know it goes beyond the scope of just what the ECMC is covering here today. I know that the ECMC has a definition for cumulative impacts, but I really want to just stress that people, no matter how you permit things, people experience these stresses all at once and all the time. We need a new approach to permitting, the way that a nurturing parent cares for a child, looking at all its parts, wanting the child to thrive and have the best livability, not how much we can take and continue to take and extract endlessly, and how much we can pollute that child. That's not how we would care for our child, and that's not how we should continue to care for our earth that also cares for us back in return. Here's just a few of the health impacts. We brought in medical experts and doctors to help talk to community members. And what we found is that whether we're talking to community members out by the Aurora Reservoir or out in Weld County or in the area where we are in North Denver and Commerce City, a lot of there's tons of overlapping issues, and a lot of them are the same chemical exposures. I won't read the list, but wanted to include it here today. Here's some more about air pollution that happens, the benzene, the toluene, the methane. Methane is a huge problem, and what we're finding is that this has been underreported, but a huge one for the Denver metro area is ground level ozone. Communities near oil and gas sites can be exposed to life-threatening concentrations of emissions, which acts as air pollutants, including VOCs and particulate matter and other gases. VOCs then mix with the heat and the light from the sun to create ground-level ozone. And the ozone doesn't just stay in one area. It travels, and a lot of it settles significantly more than 2,000 feet, significantly more than a mile. So the reach of the impacts of oil and gas go far, far beyond, and we need to consider them all. Again, here we are talking more about ozone. Candy mentioned it today. We all are getting these ozone notices. We do a lot of work with Denver's Love My Air program, and some of the common things that we talk about with them is that many days from late June to early August this year had ozone concentrations in the low to mid 80s and a couple in the high 80s. The standard is 70. We are still very far from attaining the EPA's ozone standard. We know that NOx and VOC emissions are cumulative air quality impacts from oil and gas that can help lower these high ozone concentrations. All the best air quality models still show oil and gas is a significant contributor to ozone pollution. This is especially true as more wildfire smoke impacts ozone concentrations in our region, which we have no control over. So we need to reduce cumulative emissions from oil and gas as much as possible, since it's one of the only things that we can control. The focus of cumulative air quality from oil and gas should definitely be drilling and fracking. We know the quantity of emissions from these activities are far more than the emissions once a well is in steady state production. So electrification and staging drilling and fracking activity outside of the ozone season are key considerations for cumulative impacts. Pollution knows no boundaries or jurisdictions. This is something that Candy just mentioned, and similar to what moms are being told to look at right now, we're being told to keep our kids inside. Since I've been doing this work and learning more and more, when my kids ask me, Mom, can we go to the pool tomorrow? I tell them it depends on the air quality, kids. I'll check the EPA Air Now app, and if it's in the orange or higher, and also I'm getting a regional air quality ozone alert, we're not going to play outside. Health experts are just beginning to scratch the surface of the combined effects of ground level ozone with particulate matter and other pollutants and VOCs. When we mix these things together, we create an air pollution cocktail that's being breathed into our lungs and our children's lungs. Children's little lungs are not fully developed. They're more sensitive. Plus, children breathe at a rate twice as fast as adults, meaning that they filter twice as much of the air and the particles through their lungs. This is what this summer looked like. I check this all the time, like I said, because it's a big deal. And I'm a mom who's scared. It's said that the life of every child born today will be profoundly affected by climate change. Overall, air quality has improved over the last 50 years as a result of the Clean Air Act. However, the EPA reports that 60% of children in the US are still exposed to pollutant concentrations above current standards. The air pollution is predicted to get worse as a result of climate change, and air pollution causes and exacerbates climate change. And climate change worsens the health effects of air pollution. So we are in this vicious cycle right now, and it's not the world we want to leave for our children. I want to start to shift a little bit into data gaps. I did a lot of research in working on the water conservation and oil and gas regulations. And one of the things that I looked at was the cumulative impacts report. But some of the concerns that I have is we're using estimates in this instead of actuals. And when I estimate that I'm going to be somewhere at noon, let me tell you, I'll probably be there at 12:15. I know when we give estimates, we do our best, but even ECMC staff has told me, Harmony, you know that OGDP estimates are all over the place. I think that this is a really concerning data point, especially as this is what we present forward to the public as the cumulative impacts of oil and gas. I also think that there needs to be a true up to actuals. Even in the report itself, the future ability to compare actuals to the estimates will be perhaps one of the most powerful tools for evaluating cumulative impacts that the ECMC has. We know this. I just can't believe that we've had oil and gas happening for so long, and maybe I'm misunderstanding what's happening and the conversations I've had, but how is this the first time that we are looking at comparing the estimates to the actuals? And I also asked the commission, what happens when there's a variance? What happens when water usage comes in significantly higher? What happens when air emissions are more? Seriously, what happens? I heard a great idea mentioned from one of the staff earlier in this rulemaking about the creation of a CITER public interface so that industry and community can query data. I think it's really important to be able to have this data by operator, by basin, by county, by air, by water, by land, by wildlife, and also show totals. We really encourage this idea and think it would be helpful for all the stakeholders involved. Also, I thought I heard someone mention that the data from CAPS is not included in CITER. If that's accurate and I heard that correctly, I think that there's a huge data gap. And again, I don't know how we can make informed decisions when our data is not as informed as it needs to be. And something super important to me is that we need totals. I want to see the total of water use this year. I want to see the total of water use for the last 10 years. I want to see the total of air emissions. We have a similar dashboard for the ECMC to show production, I don't know, violations, other things like that. I think it would be really, really helpful to see these other indicators as well. And I also know that some of this information might be in the on-GARE system. These systems need to sync with each other. We've said that before, and I know that there's timing issues and other things. Back when I was researching for 1242, I asked for the total amount water utilized in 2022. It took weeks to get the information back, and there was a large reporting discrepancy. This leads me to believe that I was the first and only person asking for water totals for the year. And I believe the timeframe was in April, or probably around April. Again, how are we looking at cumulative impacts if we're not looking at the sum of these things? I struggle with this methodology of evaluating cumulative impacts and encourage us to do better. One of the things that I've noticed in sitting in the Community Council for Air Quality and Environmental Justice, one of the things that we get to have the opportunity to have is different state agencies come to present to us about different air quality presentations that they'll be giving to commissions and to the public. And then they kind of ask our feedback of what we understood, what we didn't. But what jumps out to me over time, and something that we realized in the research of 1242, is that where are the trucks associated with oil and gas counted? And the answer is a bit up in the air. But I can tell you that they're not counted in the oil and gas categories, as you can see here and here. They're actually counted in the transportation bucket. So what I've encouraged them to do is, can you please break out what percentage of transportation is actually attributed to oil and gas trucks? I just asked this question again on Tuesday and got another convoluted answer back about why that's not possible. And again, it makes me further question the data and the modeling. Some other issues, sorry, let me catch up to where I am speaking right now. There's some other issues that are impacting why we don't feel so confident in the data. There have been past modeling errors that have been off for oil and gas ozone, I believe up to 90% off. If we can't look at something with a reasonable check of 90%, I think that that's problematic. And how do we know that the numbers that were being presented today are actually accurate? I struggle with this, and I hope that you have a better grasp, as I am just someone on the outside. Also, ozone is very complex and hard to understand. I rewatched the presentation given to the ECMC Commission back in October, talking about an 8-hour ozone average using the 4th highest point, and my brain stopped working because logically those things don't make sense. These combined issues definitely cause further distrust, confusion, and uncertainty with the public. And for air emissions, there's a disconnect and confusion between departments and reporting and who is accountable. I still don't have a clear answer of where actual emissions are counted, and does this include pre-production emissions? I've been told that pre-production emissions are short-term and kind of sporadic, so we don't start actually counting the emissions until we're in the full production stage. However, the majority of the emissions happen during pre-production. So I hope that I'm just not quite understanding that correctly, and that that information is actually available. And if so, would love to figure out ways to make this more accessible to the public so we can have a better understanding and have more confidence in the data. There's timing issues with a permit being approved in 1 year, but not actually drilled for a few years later. To me, I think I could make these comparisons in an Excel spreadsheet. When I worked in oil and gas, we would spend millions of dollars on accounting systems to do all sorts of things. But really, when it came back to it at the end of the day, we were still calculating things in a good old Excel spreadsheet. So that's some of the issues on that side, but then there's also issues that we don't trust the industry. And it's even been well known that the industry for a number of years was doing research on climate. But then Exxon is a famous example who went through a board change in the 80s, and then their scientists who were doing all this research that seemed to be pretty spot on, accurate, but didn't look good for the fossil fuel industries, put those same scientists to go discredit their own information and reporting. So there's just a lot of discrepancy in the data all over the place. How do we know that these numbers are accurate? How do we know when things are reasonable? How do we make informed decisions? How do we really know we are making our targets? Community has a hard time trusting any of it. Please help us restore our belief. If the industry is given a new standard and let's say for ozone, and they reported they met that standard, but didn't actually make any changes, they just reported the lower number that they had adhered to, would the commission or the ECMC staff be able to tell? Another area where there's a significant amount of gaps is water. For the first time this year, the ECMC, actually the 2023 Cumulative Impacts Report, compared the estimates to the actual water usage, and on a very small scale. And what they found is that one of the operators in the Front Range was about 50% higher in their actuals over their estimate. And again, I ask, what happens? The water is gone and used, the drilling is done, and where do we go from here? And how do we work with this? This variance is high and highlights the strong need to expand the scale in which the ECMC compares estimates to actuals and finds more ways to verify data. Water. So water is something very near and dear to my heart. Water is life. Water is crucial for everything that exists. The DJ Basin uses significantly more water as they drill down further and have longer laterals. I did a ton of stakeholder engagement for 1242, speaking to everyone from faith groups, indigenous people, communities in the Western Slope, academia, industry experts, environmental groups, and I learned a lot. But one of the things that we learned is that there's a lot of variances for what they're saying that the water usage is versus what's being shown in the cumulative impacts report versus what the industry is saying has happened versus the estimates to actuals. And again, I'm skeptical of the accuracy of all of it. And again, as these new wells become longer and longer, this uses significantly more water. That water is mixed with fracking chemicals and sand, is highly pressurized, travels miles down and across, mixes with salty brine and known and unknown constituents. This water comes back up whole and is then known as produced water. In most cases in the DJ Basin, it's only used once, becoming so contaminated it needs to be put into deep injection wells underground, forever removing it from the hydrological cycle. Many injection wells built more than 20 years ago are having structural issues and leaks. And it's hard to know about unreported spills, leaks, and issues until the vegetation won't grow. And by that time, it's too late. And when I did all this stakeholder engagement, it became many people had concerns and said that it's unfair that one person gets to use the water to the point of extinction. And I know that oil and gas water usage compared to the percentage of all the water used in the state is a small percentage, but that small percentage is removed and forever gone and has a cumulative impact over time. And I also want to highlight that the majority of the water used on the Western Slope is reused, and that other basins across the state use significantly less water. Communities want their water back, and our earth needs the water back. In addition, many municipalities are having to build many multi-million dollar dams and pipelines so that we can have drinking water for survival. This drives our residential prices up while oil and gas gets to continue to do this. Again, and I ask us to think about a better way to do things. Speaking of a better way of doing things, there needs to be a cumulative impacts assessment over time. When I worked in oil and gas, I would sit in managerial meetings where we would consider who should we write one of those big $50,000 checks to, the food bank or the fire department? What would get us better PR? They would say the food bank is one of the most utilized in the state. And I would wonder if oil and gas has been here for years and so good for the community, then why does it have one of the most used food banks? Has oil and gas really been that beneficial to the community, or significantly more so beneficial to their profits and their shareholders? And is this true of who benefits over time? In our pre-hearing statement, we advocated for the need for progressive cumulative assessment over time. We need to look at many factors: valued environmental and social components, health indicators, jobs, environmental resources utilized, crime, truck traffic, water utilization, ozone action alert dates, complaints registered in the systems, temperature increases in the area, asthma cases reported in school, property values, spills, violations, injuries, and explosions. This assessment should go further to include so many valued environmental and social components to be a holistic evaluation. I understand some of the data might not be attainable, but it would be interesting to evaluate the number of personnel hired by a company at the executive level, the managerial level, and on the site level who are actually from the local community, as well as their mean and median salaries. I used to do payroll, so I would often see these imbalances. There is a need to compare producer profits compared to the taxes and fees paid compared to the charitable contributions made. $1 million in charitable donations might seem like a lot of money, but comparatively, is it? Many of the financial components of the assessment are already reported by the industry in their banking borrowing base reports or shareholder profits reports that are already available to the public. These reports show financial health, strengths, weaknesses, and risks of a company. We believe that this assessment needs to go over time, starting with a baseline and continuing to evaluate in year 1, 2, 3, and so on for us, however long the well is producing. In earlier presentations, we heard members from the EJ Task Force, and other organizations that spoke of the importance of the environmental equity cumulative impact analysis. We agree that there needs to be this baseline analysis and think it's really important, but as we stated again, it's a starting point and there needs to be that continuation after time. Here's a picture of us at the bill signing for 1338 Cumulative Impacts and Environmental Justice, which mandates 2 of these analyses. We're hoping that at least one of them will happen for the oil and gas sector. It's important to have strong baseline information, considering that we don't have that today. And again, making it more encompassing and making it over time. And I want to highlight that many felt that this legislation continues to fall short, like much of the legislation does. When communities continue to be harmed by the living effects of inaction, lack of accountability, a lack of enforcement. Communities want more than measurements. They want more than lip service. They need a reduction in pollution and harms caused to their families and communities. Some of the things removed from this legislation were having to government agencies have to actually utilize and consider the data in the environmental equity and cumulative impacts analysis. What's the point of doing the analysis if no one's going to use it? How many government reports and programs get created just to sit on a shelf, collect dust, and merely check a box? As I mentioned before, some of the key indicators that we need to consider and that we hear a lot about the benefits are charitable donations and other financial benefits to community members. I want to highlight that what we see here is some of the things I pulled from Civitas's Q2 of 2024's earnings highlights. Something that they talk about is that they donated $1 million towards charitable causes in all of 24. But when I look to their 6-month net income ending on June 30th, they made close to $392 million in net income. So when you compare the $392 million in just the first 6 months of 2024 compared to their $1 million in charitable donations in 2023, I find that to be incredibly off balance. In addition, in 2023, Civitas paid out $668 million of dividends to shareholders, meaning they took money from the company and gave it back to investors. That money could have been going towards more charitable donations, and it could have been going towards equipment and improvements to better run their operations in a way that's less burdensome and impactful to communities and the environment. They have the money to do so. They're just not putting it in the places we need them to do. When I worked in oil and gas and I worked on those oil trains, we would load the oil onto the trains and have it travel down to the Gulf of Mexico where it would unload. That train would travel all over different elevations, heats, pressures, and the pressure inside the car would change significantly. And when you opened up the cap of the train, you could just see it and you could hear it going, and all the emissions going into the atmosphere. Some of the states started requiring us to put on recapture systems onto our train offloading sites. Some states didn't. Guess which states ended up having recapture systems and which states didn't? We knew how to do it. We knew we should do it. We had the money to do so, but only did so in the states who required it to be there. I also want to highlight here these 19 voluntarily plugged wells. Those 19 voluntarily plugged wells and the environmental impact of that, it's appreciated and also is nothing compared to the 160 plus wells that's going to be drilled around the Aurora Reservoir area and those communities. When I worked in the industry, one of the main reasons why abandoned and low producing wells were not plugged was because the industry was waiting for new technologies to re-tap them, because it's cheaper to dig into that existing hole to start a whole new one, especially when you knew that there were reserves already under there. Have you heard of horizontal fracking and how that changed the industry? What's coming next and what do we need to be prepared for? Something else I want to just point out that I noticed when I was looking at these slides or at their presentation, it's just the amount of profits and the attitude. 3 times in Civitas's report, they marked the achievement of reducing Colorado's regulatory risk. The industry touts the governor's earlier oil and gas compromise as achievement, but environmental and community groups don't see it as a win like the industry has it all. We see this once again as profits taking priority over people. This rang true in the latest version of these draft rules. The industry sees regulations as a profit risk, and communities need you to protect them from it. Something else that I think is really important to note is I did human resources when I worked in oil and gas, and actually my whole career. My first love is made in the USA and having a strong labor force and what that does to keep families and communities going. I think it's really, really important to debunk the narrative around oil and gas and job creation. The industry rhetoric around job creation and reducing dependency on foreign oil is what kept me in the industry for 8 years. More jobs are being lost to automation than they are to regulation. I have people who work in the industry telling me, my billionaire CEO tells me every week, close more deals, cut more costs. And when they say cut more costs, they mean cut more jobs. The field jobs for oil and gas have been cut by 20% since the pandemic, and those jobs are not coming back. Yet production increases and oil and gas profits continue to increase. In addition, when we were working on the legislation for 1242, I worked with the pipefitters union to try to put in language to be protective of equipment for workers, to have proper training, to make sure that we were utilizing local workforces. And it's the first thing that the oil and gas lobby told us to remove. When I worked in the field and would be in these managerial meetings, they referred to the workers as worker ants, and they were numerous and disposable. And again, I want to come back to the profits. I listened to some of the public comment last night, and I want people to know that regulation is not driving up your heating bill or the price at the pump. What's most driving up the price at the pump is corporate profits. The producers make billions of dollars. The producers' services, pipelines, railroads, trucking companies, marketers do too. If they took less profits, Coloradans would benefit in their pockets. And with that, I'm going to hand it over to Morgan Brown. Crystal. Oh, sorry, Crystal. There we go.
Afternoon, Commissioners. I'm Crystal, a recent graduate from the Masters of the Environment program at CU Boulder, with a background in environmental engineering and experience in sustainable transportation and waste management, and I'm currently interning with the GHCC. Coming off of what Harmony said about profits from the oil and gas industry, what we have noticed throughout this rulemaking process is that even though the intended mitigation hierarchy is avoid, then minimize, and then mitigate, what currently seems to be happening is this. Pushback from the industry has come against most things that would lead to avoidance of impacts through permit denial. Mitigation measures, on the other hand, seem to be their happy place, which is why, unsurprisingly, as Mr. Matt Foote of the Sierra Club aptly said yesterday, the community liaison position remains unscathed by industry feedback. And acknowledging that the ECMC has the responsibility of ensuring that permit denial criteria cannot be arbitrary and capricious, we also ask that you recognize that this is what is happening, if you didn't already, and that you acknowledge that the lived experiences of people and communities tell the real truth of the effectiveness of prevention and protection measures. To conclude my slide, we want to echo what 350 Colorado said yesterday, urging the Commission to go beyond granular rules for procedures and practices and to return to the purpose of the rulemaking, and also urge you to avoid impacts through permit denial. Why? Because as Mr. Matt Sura said yesterday in his presentation for Conservation Colorado, the ECMC can do what APCD can't, which is deny permits. I now pass the time to my colleague Morgan to further elaborate our concerns.
Hello, Commission. Thank you for this opportunity to present as party to this rulemaking. My name is Morgan Brown, and I am currently the youth organizer and digital specialist with the Greenhouse with a focus on elevating community voices. I graduated from Colorado State 2 years ago with my bachelor's in human dimensions and natural resources with a double minor in ethnic studies and political science with the intent to take a grassroots approach to environmental law and policy as I'm doing today. On top of going to school full-time, I worked 2 other part-time jobs and was also a campus ambassador with Defend Our Future, which is an affiliate of the youth affiliate of the Environmental Defense Fund, where I led environmental initiatives on campus and in my community. After I graduated, I started as a fellow for the Methane Partners Campaign, which leads federal methane regulation within the oil and gas industry, and also moved up to be an organizer leading our efforts for our campus ambassadors nationwide. I simultaneously started my own LLC to further conduct my work as an environmental consultant. And after I finished my fellowship with the Methane Partners Campaign, I started as their campaign coordinator for the Colorado Methane Coalition, which is a state table to lead our campaign efforts in passing the Colorado Methane Rule, which passed in July of last year, and the Colorado Methane Protocol. With these being passed, Colorado then became the first state in the nation to adopt rules to cut methane pollution and develop a comprehensive program that utilizes direct measurement-based emission reporting to demonstrate that we are on track to meet our emission reduction goals. Through my work, I then began to see methane as an umbrella issue to the ways that industry is perpetuating harm and putting profits over the needs of people. With this methane rule, the protocol then became the way in which the rule was enforced and the way that we could provide enforcement and accountability mechanisms towards how the data will be gathered, an important piece that a lot of rules tend to fall short of. Even still, a report was released from EDF on July 31st of this year that exposed that new data from the US oil and gas methane emissions are over 4 times higher than EPA estimates and 8 times greater than industry targets. As Harmony mentioned when speaking on data gaps, these gaps exist in every industry, which is why enforcement and accountability is crucial to ensuring actual protections are met. And being that we are already leading the country in our methane regulations, I also see this rulemaking as another opportunity for us to lead the country in the way we permit oil and gas. So to start, I want to recommend that there needs to be a culture change at ECMC. Right now, on average, an inspector comes to a well site once every 3 years. And so I really can't emphasize enough how this does not allow for the mitigation hierarchy to succeed, as you simply cannot avoid harm when routine inspections are being taken to ensure that aren't being taken to ensure that environmental catastrophes like spills, which have irreversible environmental consequences, are again being avoided. Many inspectors feel overextended and don't have the capacity to thoroughly do their job. So this leads me to my next point, which is that a culture change primarily needs to consist of a need to hire more staff in order to provide that accountability, that transparency, and enforcement necessary to implement these rules. I also want to name that we recognize that the commission and the staff is tasked with the impossible in this rulemaking, yet the impossible is made possible with more help and support. So I know, speaking for myself, if I didn't have the support of Harmony, Crystal, my friends, family, and community behind me, I wouldn't have been able to find success in participating in this rulemaking process. With that, I would like to talk a little bit about the expansion of the role of the liaison and suggest that we need not only this liaison to do more, but have additional liaisons and a legal fund. So with that being said, the role of the liaison needs to go beyond DICs, as the current rules unfairly restrict the availability of community liaisons to only DICs. As you've heard from many other parties before me, overlooking other communities that also experience significant challenges in engaging in these intricate procedures. This can include not only directly impacted communities that don't qualify as that, but students, healthcare professionals, environmental groups, and anyone living in a non-attainment area that needs assistance. We would also like to emphasize that access to information, resources, and involvement in decision-making should not be contingent upon a community's DIC status. Every impacted community deserves the opportunity to engage meaningfully in this process, and the burden should not be put on us as community members or nonprofit organizations that already have limited capacity to do this job on your behalf. Speaking to my own experience as a party to this rulemaking and a group that has no lawyers or attorneys to assist us in this process, we do not have the funds to participate in this rulemaking in the same way industry does, and so we are naturally at a disadvantage. Much like us, community members are in a sinking ship and not only drowning in these rulemaking processes, but their voices are being drowned out by industry who has more money to continue to pay to pollute. If there was a legal fund for those that are struggling, then they could advocate for themselves more, and there could be more meaningful engagement in these processes. One of the events that we had over the summer was a pollution and solutions tour where we stopped at a residential oil and gas drilling site before we went to Jack's Solar Garden, an agrivoltaics farm that creates local sources of renewable energy, food production, and Colorado jobs, or what we consider to be the hope of the future. At this site, we were at the home of Kathy Kemper, which is portrayed in these pictures, she is actually not considered to be a CIC or a DIC, despite her home being within 2,000 feet of an active oil and gas drilling site. She has given countless testimonies to the ECMC before, and even still has been told that there's no unusual activity happening, despite the fact that this site has experienced 2 spills of 3 to 5 barrels of oil, one in March of 2023 and another in April of this year. Not only was she never told that her neighborhood was going to be turned into an oil and gas fracking site before she bought her home and moved in, but no information was provided to her when there were spills as far as what the remediation process would be and how these spills would directly impact her health. In talking about the mitigation hierarchy, this is yet another example of how there's no tactics in place to avoid a situation like this, and nothing was done to even minimize or mitigate the harm for Kathy, especially because, again, she is not considered to be a DIC or a CIC. I know that this has been touched on a lot, but I would just like to expand this by quoting Senator Faith Winter's letter that she submitted to Aaron Ray and the commissioners on August 21st, as well as the 24 other representatives that signed on. She expressed that the newest draft rules reflect, and I quote, inadequate protection of disproportionately impacted communities. One recommendation that she requests is to, and I quote, remove the term cumulatively impacted community from the draft rules, as this term is counterproductive to environmental justice and serves only to weaken protections for impacted communities. As you can see on this map, which was provided to us by Earth Justice, geologically, there are no oil and gas developments happening near or in CICs. And as Faith Winter's letter states, there have been, in fact, no oil and gas permits issued in a CIC in at least the last 5 years. She goes on to say, and I quote, the CIC language included in the new draft is incompatible with the statutory defined definition of DICs and her legislative intent, which is to protect all DICs and not just a subset. This is therefore a tactic that we would like to refer to as oil and gas lighting. In other words, this language allows you to act as though you're providing protections for DICs when really these measures are falling short of providing genuine safeguards. DICs are then led to believe that they're being protected, even though, as this map illustrates, the regulations are ineffective in mitigating the real risks these community members are facing, and that you heard from public comment sessions. This then results in a dissonance between the perceived intent of the rulemaking and the actual outcomes, causing community members to doubt their own experiences and concerns regarding the ongoing threats to their health and environment, especially if they don't qualify as a DIC or CIC. Since the industry is going to be presenting last and is then going to have the opportunity to provide rebuttals towards our presentations, I would also like to stress that they too will be practicing oil and gaslighting by downplaying, denying, or misleading you about the environmental and health impacts of their operations, especially when they are allowed to give data that is often not verified and there are no consequences for that variance. This will involve providing false or misleading information, discrediting our legitimate concerns, and or shifting blame to make affected community members question the validity of their experiences. So we hosted a cumulative impact public comment workshop a couple weeks back, and through that we were able to gather what were some common themes among our community members in this process. So overall, mistrust is huge and is really the overarching theme in this process, with one person in particular asking the question of why should anyone trust this rulemaking or these systems when time and time again they feel let down and the commission has not given any reason for community members to trust these systems. And so I would like to ask the question of how are you going to address the mistrust so that public and affected communities can meaningfully engage in these processes and feel like their voices matter? And so this mistrust stems from the fact that time and time again, profits are prioritized over the safety and lives of people. And the most recent draft being a clear example of the power industry has in these spaces to get exactly what they want, how they want it, while community members are forced to make more and more sacrifices. People are tired of making comments and not feeling heard when their health, lives, and safety is at risk. And so everyone deserves the right to live and not just survive. Many of our community members do not have access to healthy air, water, and land due to them being on the front lines, with many of them struggling with asthma because of this fact, as well as countless other health concerns that Harmony mentioned. Breathing clean air then becomes a luxury, not a right, in a state known for its natural beauty. Also, as Harmony mentioned, we're experiencing ozone alerts every day, the highest worldwide temperatures, and many community members feel like they can't leave their homes. Going back to my community liaison slide, our community members lack the resources and knowledge to know what's going on and be informed with the best ways they can engage. Our community members want hard facts, not estimates, and need governmental systems that are determined to avoid the harm rather than scramble to mitigate it, and need enforcement rather than more empty promises. Rules without teeth are useless, and our community members need a dedicated commission to ensure that these regulations are more than just a paperwork exercise. That being said, we do provide our community members with the knowledge and data of what's going on, but many of them are surprised to discover how bad the air quality really is, and again, are gaslit to think otherwise. Ultimately, people are afraid of what's going to happen if we continue down this path that we're currently on. And our community members, being that they're on the front lines, are at the highest risk of developing these health issues. So again, we really need ECMC to hire the staff to address these issues. So it's not up to residents who already have enough on their plates, such as full-time jobs, raising families, and juggling with the struggles of raising basic costs. One of our key partners is Cultivando, which is a nonprofit organization led by Latina and Indigenous women who live in Commerce City communities that they serve in. They follow the Promotora model of community engagement, educating and empowering other community members to promote health equity, collaboration, and social change. A large part of their work was conducting a multifaceted air quality monitoring around the Suncor refinery after they were told that their lived experience does not count as data, even though it is qualitative. Once they did start gathering this quantitative data, they were harassed by industry and intimidated to stop. They made an amazing documentary about this process, but regardless, I just wanted to share the social and environmental justice themes they found to illustrate our intersectional findings. I would like to finish by covering concerns and challenges that we have had with this rulemaking process as a whole. And so to start, the introduction of a new draft rule in June without adequate consultation not only undermines the work that community organizations such as ours put into our pre-hearing statements, but also undermine this rulemaking process as a whole, as it was clearly persuaded by industry and the governor's motives. As prior to our pre-hearing statement being submitted, the commission had communicated in a Zoom on enhanced systems and practices that they are working towards, and I quote, a solution-oriented rulemaking that you can collectively request to have a holistic approach that creates a regulatory arena that allows operations, staff, stakeholders, and the commission to look at holistically at OGGP. This in turn not only undermines our position as party to this rulemaking, as it was a clear indication of the direction this rulemaking is headed, but also undermines the work and intent of legislators that crafted this rule. And again, to quote Faith Winters, the ECMC had over a year to develop rules that fulfill its statutory mandate under HB 23-1294 and was granted an extension under HB 24-1346 to provide the agency additional time to respond to stakeholder concerns. And yet it has come to our attention that the current draft deviates significantly from the intent of these laws we work to pass, jeopardizing the protection of disproportionately impacted communities and allowing operators broad leeway to exceed pollution thresholds and ignore state directives to reduce greenhouse gas and nitrogen oxide pollution. We are then informed that this draft rule was in fact a supplementary suggestion to the first draft rules, yet this was never properly communicated and created more confusion in an already confusing process. Either way, in a proper rulemaking, a new draft rule would allow for a new pre-hearing statement, yet in our rebuttal, we were forced to not only respond to new rules, but other people's pre-hearing statements and with less pages. Ineffective communication seems to be a clear theme, as not only was the intentions of these rules not properly communicated, but we were never provided the one-pagers, toolkits, summaries that we were promised to not only set ourselves up for success, but set our communities up for success that would be engaging in public and written comments. This then increased my own workflow, as I was forced to do more work I'm not getting paid for on top of submitting the pre-hearing statements, rebuttals, and presentations, which is only one of my workflows as an environmental consultant. The non-existent resources that we are given to engage community members is a clear indication that public comments are performative at best. And so how do you expect us to engage others on a process that we ourselves are struggling to engage in, simply because these rulemakings are set up to disempower the very people that are the most affected, and the ECMC claims this rulemaking is intended to serve? Being that we are participating in this rulemaking not as environmental lawyers and attorneys, but as community members, and do not possess the funds to seek out assistance, this process is inherently more difficult for us to navigate. That being said, our largest suggestion was to give red lines to help in drafting this rule, yet given our position, we do not possess the ability to do that. It then becomes clear that the people that do have the money, like industry, are able to provide better red lines and are more likely to have their suggestions included, with the second draft being a clear example, which is dismissive of the financial barriers that we are unable to overcome and the lack of care to our voices in this rulemaking. I do believe that most of these concerns and challenges could have been overcome with more staff, as this rulemaking process has made me question not only the integrity of the ECMC, but the overburdened staff that seems to lack the support they need to truly be successful, so that we in turn can be successful. And I would like to pass it back to Harmony to close this out.
Perfect. In summary, we need a new approach to permitting, and I think we all know that. Additional staff is needed for better implementation. Improved data is needed for permitting and cumulative impact reports, and there needs to be a cumulative assessment over time. Oil and gas that is permitted by the ECMC and produced in the state then travels on rail, pipes, and trucks to compressor stations, terminals. Some of this oil and gas is then processed at Suncor, which is just 1 mile from our community space. Then back on a pipe, truck, or train, and then burned at a utility plant, asphalt factory, a military base, or at DIA. All of this progress, production, and profits have real consequences on the cumulative and compounding impacts being felt by Colorado communities today. I understand that much of what I just said is outside the jurisdiction of the ECMC and this rulemaking. Today, we plant the seeds for fully looking at and protecting people from the cumulative impacts of oil and gas, because currently no one really is. And again, communities are experiencing the full impacts. The ECMC is the starting point with permitting, and we ask you to do as much as you can to be protective. I want to also highlight that even with Colorado's regulations, we still deliver some of the cheapest barrels of oil at WTI. And a lot of this is due to our cheaper produced water costs. And I have to ask one more question here. What happens when a community becomes a DIC because of oil and gas operations? We would love to continue connections, conversations, collaborations to come together with a variety of stakeholders to truly form data, information, reports, information that we can put out to the public, and giving the opportunity for a public to meaningfully dialogue with you all so that we can all create a better world for the future. Thank you.
Okay, thank you very much for the presentation from the Greenhouse Connection. A lot of information there. At this time, the panel is open for questions. All right, I'm not seeing questions, which means you did a really good job of getting through a lot of information in a short amount of time. So with that, we will look forward to your continued participation with us as we move forward through this rulemaking. Thank you very much.
Thank you.
All right, let's take 7 minutes. Let's return at 1:22, and let's get the allied local governments up. There's a whole bunch of them, and get their PowerPoint up, make sure it's working, and then we will go into our next case in chief. We are all back. It is Thursday, September 5th. It is 1:22. Docket 240600145. We continue with cases in chief, and we now will hear from the allied local governments. Who is going to take it off here? Ms. Burke.
Good afternoon, commissioners. Thank you. This is Kate Burke with the Boulder County Attorney's Office. Looks like our team is all assembled. I just wanted to start by saying we discovered while getting ready for this that some of the numbering in the red line we provided with our PHS was off. So I'm going to be submitting a revised one as some of the subheading numbers were 1s instead of 2s, that kind of thing. So we'll submit a new one so that's clear. And then I'm going to turn it over to Kim Sanchez and brag on her just a little bit that she is an expert in land use planning and maybe one of the few that you're hearing from today. So I'm hoping you'll take advantage of her being with us today.
Ms. Sanchez, good to see you.
Good to see you. Good afternoon, commissioners. My name is Kim Sanchez. I know many of you, but for those of you who I haven't interacted with yet, let me allow myself to briefly provide a little bit of information. My background is in environmental policy and land use planning. I have a Bachelor of Science degree in environmental policy analysis and planning and a Bachelor of Arts degree in Spanish, both from the University of California at Davis. And I also have a master's degree in public policy from CU Boulder. Been a planner at Boulder County for about 25 years now, where I first started as an intern. When completing my master's thesis, I now act as Deputy Director of Community Planning and Permitting. I've been involved in the oil and gas arena for several years now, which has included participation in all COGCC and now ECMC rulemaking since 2015. As the ECMC LGD for Boulder County, I interface with the public on oil and gas development issues and questions and have helped lead the efforts for Boulder County's 2012 and 2020 oil and gas regulation updates in our land use code. So in my testimony today, for my piece of it, I'd like to offer you a planner's perspective, and I'd like to focus on 4 things. 1, I want to reinforce why evaluating cumulative impacts is important. 2, I'd like to walk you through how to apply the avoid, minimize, and mitigate rubric and encourage you to reframe this in the rules per our suggestions. 3, I'd like to recommend that the oil and gas locations, DICs, roads, and wildlife habitat be added to the ALA requirements. And 4, I'd like to address the importance of impact area being adjustable based on site-specific conditions. So let's start with cumulative impacts. Analyzing cumulative impacts is an important exercise in land use planning, and it becomes particularly important in the context of oil and gas development, where the additive impacts can become very intensive for an area. There's been a clear effort to do a lot of thinking about this, so the ALG does want to acknowledge ECMC staff and the commissioners for their efforts and for listening to our input, as well as for your stamina in these proceedings as always. It can be challenging to put this kind of analytical framework on paper, as has been evidenced in this rulemaking, but really addressing cumulative impacts is a simple concept, and it's about looking at the impacts of an oil and gas proposal both individually and at a broader level, similar to how we would look at any proposal in the planning world. It's about it's about taking ECMC out of the world of reviewing oil and gas development on a permit by permit basis, where those permits are looked at in isolation, and widening your lens to look at the singular impacts of oil and gas, as well as its incremental and collective impacts within a region. Given the mission of ECMC and the directives provided through legislation and the direction provided by the governor, the agency is now tasked with evaluating and addressing the additive impacts of each new oil and gas operation on top of existing land uses and development. To this point, Governor Polis clarified that sources of impacts beyond those directly regulated by ECMC should be considered. He pointed out that some impacts may not be addressable by the ECMC, but they can still be analyzed to develop a fuller picture of the totality of impacts on Coloradans. Consequently, similar to many local government planners, ECMC must now consider every proposed oil and gas facility in the context of all the impacts it will impose on the surrounding area, as well as how those impacts build upon each other and contribute to the broader region. To do so, it's critical that the information submitted for a cumulative impacts analysis be meaningful, and that the ECMC use this information to discern how to look at the operation differently. The evaluation of cumulative impacts is tremendously important, particularly when you think of the intense aggregate impacts that large-scale multi-well pads can add to what is already occurring or what's planned for an area. These are significant operations as they're proposed in the current day, and they generate real impacts on the environment, public health, and wildlife resources. Here's an example. So imagine you live in a subdivision that's surrounded by open land. There's a major oil and gas facility a quarter of a mile from you to the north and another to the east. You notice it, you feel the lighting, the noise, the traffic, et cetera, from these facilities. Now, an operator is proposing a new 20 well pad south of you, and you've heard there's another 30 well pad that's coming in. Perhaps 1 was tolerable, 2 is a problem, but now the prospect of a 3rd and 4th means these impacts continue for years and years in your life. Maybe 1 would have been fine, but several others in the same area surrounding you add up to being too much noise pollution, too much traffic, too much air quality degradation, too many impacts on wildlife. This is a simple example. Now imagine if there's already an existing refinery in the area, or if the area is a disproportionately impacted community. Cumulative impact analysis needs to be conducted to make informed ECMC determinations on individual projects in the context of real-world conditions. Piecemeal review of impacts has led to excessive burdens on certain areas, particularly, as has been pointed out, on DICs. It's critical that ECMC evaluate if the layered impacts that add up are just too much for an area and should be avoided, or if particular conditions to minimize or mitigate the impact should be required. To this end, the ALG has a couple of suggestions to help conduct a proper CI analysis. Namely, we recommend that the separate analyses required in Rule 315B2E be synthesized to consider their accumulated effects. These separate 7 elements, 8 if our recommendation to add a subsection for traffic impacts in the impact area is added, need to be considered together and in light of existing conditions. Individually, each element may not be too impactful, but when added together, the project may pose an unacceptable impact to the impact area. It's only through synthesizing these discrete pieces of Rule 315B2E that a true CI analysis can be complete. So we ask that one of the ways to achieve this would be to take our recommended 2 and have that be a 315B2F. So next, I'd like to move on to the avoid, minimize, mitigate rubric. This is a catchy phrase, and we worked really hard to incorporate it into the mission change legislation as well as the rulemaking. However, it needs to be applied correctly in order to be meaningful. Land use planners use this analytical framework to make decisions about how development occurs in an area. It's a simple and useful way of analyzing impacts, but we need to disaggregate it in order to use it correctly. The main thing I want to emphasize here is that this is a hierarchical method of analysis. That is, avoiding, minimizing, and mitigating are not equivalent options. Let's look at this rubric in the context of cumulative impacts analysis. So a CI analysis involves evaluation at 2 levels. First, we want to evaluate the impacts that are created by all aspects of a proposed oil and gas facility. Its air emissions, its light, noise, traffic, etc. And second, we'd want to consider how those impacts incrementally and then collectively affect a region. In both of these steps, the avoid, minimize, and mitigate hierarchical approach would apply. The first goal is to avoid the impacts if and when possible. And this analysis should begin with real consideration of big or substantial changes, such as relocating the facility to a different area or resizing it, possibly downsizing it to avoid adverse impacts. The alternative location analysis is an important tool here to incorporate into the evaluation of the site at this stage. After examining how to avoid adverse impacts, if there are no legal or technically practicable ways to achieve this, even by changing its location, then trying to minimize the impacts of the proposal becomes appropriate. Examples of minimizing impacts of oil and gas development are things like phasing the project or perhaps imposing seasonal restrictions to lessen the impacts on wildlife. Lastly, and only then, it's only if the operator demonstrates that there's no way to minimize all adverse impacts that mitigation measures could be considered. This may include more localized practices like physical barriers on the site or time of day restrictions. From the ALG's perspective, however, it's inappropriate to state that a package of BMPs will avoid, mitigate, or minimize impacts, all of those things together. Instead, these should be tiers that are looked at as distinct levels of analysis. The ALG offers edits to Rule 315B2D to bring the rules that are proposed closer to this analytical approach. One last thing I want to say about this is that the layering of adverse impacts, which cannot be avoided, minimized, or mitigated sufficiently, can potentially result in an overall situation that's unbearable on an area. And there may simply be a point reached where the impacts are too much and the application must be denied. The agency has the duty to say no when the cumulative impacts of too many multi-well operations at the same time or in the same place jeopardize public welfare, the environment, and wildlife. 2 final recommendations that I want to make. Next slide, Kate. The first is that the ALG strongly recommends restoring oil and gas locations and DICs and adding traffic corridors and wildlife habitat maps to the informational requirements in Rule 304B2B. And next slide, we'd like the impact area to remain adjustable based on application specifics. So operational impacts can vary significantly in their geographic scope. Some aspects of cumulative impacts are regional in nature, such as those related to air emissions and impacts on watersheds or wildlife migration patterns. However, many others are more specific to a location in an impact area. So having the ability to vary an impact area based on specific information about the location makes a lot of sense, and such discretion is a key part of an effective analysis. We do appreciate that the draft rules appropriately allow stakeholders to provide input on such localized features. particularly those departments that have the expertise, and to develop the right impact area for a project. So we do support the ECMC red line to 301 F1, and we'd also encourage you to adopt our red lines that are proposed to Rule 301 G2 Big G related to participants. Thanks, and I'll be available for questions.
Thanks, Ms. Sanchez. And next we have Ms. Paraños.
Thanks so much, Ms. Burke. So my remarks today go to one issue, and that is this commission's authority and duty to consider the impacts on air quality and climate that incremental emissions from planned operations may have on an operator's compliance with NOx and greenhouse gas intensity targets. We believe this commission has clear authority and a duty to protect against adverse impacts to air quality, including the formation of ozone, and to avoid or minimize impacts to climate. This includes protecting against cumulative adverse impacts caused by the addition to the atmosphere of emissions from planned operations. The June 14th draft acknowledged this duty and required the director and this commission to consider the impact of projected NOx and greenhouse gas emissions from proposed operations on an operator's compliance with NOx and greenhouse gas intensity targets in Rules 306, 307, and 316. We support these provisions, and later in this presentation, we have suggested red lines that incorporate staff language from the June 14th draft into the August draft. Very briefly, before I get into sort of some of the nuts and bolts of our recommendations, I do also want to thank the commission staff for its hard work on these rules. We have participated in the commission's efforts to update their rules since 2022, and we greatly appreciate the incorporation by staff of many of the recommendations that we've made throughout this rulemaking that were intended to ensure that ECMC rules align with and do not conflict with AQCC rules. You've heard quite a bit already from other parties and your AAGs regarding this commission's authority to promulgate rules that protect public health and the environment, including air quality. So in the interest of time, I won't unduly belabor this point, but I do think it simply bears repeating that this commission has clear and explicit authority to require operators to demonstrate ongoing compliance with the NOx intensity targets when reviewing an OGDP application, or in the case of NOx intensity, a Form 2D. In addition, we believe this commission and the director must consider the impact that emissions from planned operations will have on air quality, public health, and the environment in order to fulfill their statutory duty to regulate in a manner that protects public health and the environment and protects against adverse impacts, including cumulative impacts to public health, the environment, and air quality. Very briefly, I also think it bears repeating, especially given the very eloquent presentation that you just heard, to just remind this commission that clean air is a prerequisite to public health. The chronic, persistent, elevated levels of ozone in the non-attainment area threaten public health. You can go to the next slide, Kim, or Kate, rather. Thank you. This summer, from June 1st to August 31st, CDPHE issued 52 ozone alert days where ozone concentrations were forecast to exceed the 2015 ozone health-based standard. Said another way, the millions of people, including children, who live, work, and recreate in the Denver North Front Range ozone non-attainment area were exposed to unhealthy levels of ozone more than half of the days this summer. We strongly support this commission using its authority to protect public health, clean air, and the environment by ensuring operators comply with AQCC intensity targets. However, it is not enough for operators to demonstrate that emissions from their current or past operations comply with AQCC intensity targets. Operators must also demonstrate that emissions from planned activities will not cause the operator to exceed these targets. As the agency that decides whether to allow the construction and operation of additional oil and gas production activities and the emissions that inevitably are produced by such operations, it is incumbent upon this commission to ensure that the incremental emissions from planned operations will not contribute to adverse impacts to public health, the environment, or climate. As I mentioned, the June 14th draft acknowledged this as it explicitly required the director and ECMC to consider whether or not the operator will be in compliance with its NOx and greenhouse gas intensities in rules 306, 307, and 316. I also just want to go back to the discussion that Commissioner Oath and Ms. Trask had on Tuesday, which was about this specific issue regarding whether or not planned operations would cause an operator to fall out of compliance or exceed their intensity targets. So, as Ms. Trask highlighted, the draft rules ensure that the director will have sufficient information to consider the impact of NOx emissions from proposed operations when reviewing the Form 2D. Rule 316B requires operators provide detailed information regarding all of its planned pre-production operations in the non-attainment area during the summer ozone season. Included in this information is the number of wells to be drilled and completed, the enhanced systems and practices the operator plans to use to reduce or ensure that its NOx intensity target will be met in the upcoming year, and a narrative description of the operator's ability to not exceed its NOx intensity target for pre-production operations in the summer ozone season. This information provides a comprehensive picture of whether the operator is likely to exceed or comply with its NOx intensity target. In addition, operators submit estimates of greenhouse gas emissions from the proposed operation on their Form 2Bs or Form 2Fs, as appropriate, and an estimate of the expected greenhouse gas emissions from sources owned or operated by the operator and from reasonably foreseeable truck traffic associated with the operator's oil and gas locations in their cumulative impacts analysis in Rule 315B2. With this information, the director and commission, in consultation with CDPHE as they deem fit, can determine whether greenhouse gas emissions from proposed operations will cause an operator to exceed their greenhouse gas intensity target. On the slides, we have suggested red lines that add language from staff's June 14th draft to the August draft that require the director and commission to consider whether emissions from an operator's planned activities will cause an exceedance of the operator's NOx or greenhouse gas intensity standard when reviewing an OGDP pursuant to rules 306 and 307, and when the director reviews a Form 2D pursuant to Rule 316. We've also taken a requirement from the June 14th draft with respect to Rule 306B2B that requires the director to apply a condition of approval in cases where the operator is out of compliance with its NOx intensity target. That condition of approval would prohibit pre-production activities occurring in the summer during the ozone season. And very quickly, just lastly, the Environmental Defense Fund submitted public comments to this commission in this rulemaking that discuss studies conducted in Colorado, including in Broomfield, that identified threats to public health from oil and gas emissions and suggest ways for this commission to address those threats. We want to support EDF's recommendations and urge the commission to take them into consideration as appropriate in this rulemaking. Thank you.
Thank you. Next, we're going to have Lindsay X speak to some environmental justice issues.
My name is Lindsay X, and I have the pleasure of serving as the Policy Director for Colorado Communities for Climate Action, or CC4CA. It's nice to be here with you today. My testimony today is going to focus on two key issues from the rulemaking process: community liaisons and cumulatively impacted communities. Regarding the community liaison, as was noted by staff, the ALG is one of the parties that supports the inclusion of the community liaison roles in this rulemaking process. We would encourage commissioners to direct staff to add language that no one currently or recently on the payroll of a regulated entity should be eligible, or with another actual or perceived conflict of interest, as will be discussed, it sounds like, with Green Latinos and the state's attorneys in this space. We also note that in our pre-hearing statement that the community liaison needs to be included in all major parts of the permitting process and not just one part or another, but it needs to be viewed as a system. And finally, in recognition of the request for brevity, the ALG would note that we endorse the red line submitted by Green Latinos and others regarding these positions. On the next slide, we want to focus on the need to maintain a focus on DI communities. And this is just a critical issue within the rulemaking, and there's already been a lot of discussion on it, as you know. We support the June 14th draft regarding protections for DI communities as a starting point, and we want to make a few points, and we want to illustrate these points with a couple of examples. So for those of you that like maps, we're going to show a couple maps in a moment. The addition of CI communities does not add meaningful protections. And as Green Latinos highlighted earlier today, to our knowledge, there have been 0 permits sought or approved in CI communities in the past 5 years, which does nothing to expand notice or inclusion in practice. And even without a practical application of this language, it's in direct contradiction to numerous pieces of legislation that are guiding this work. And we've highlighted on the right how House Bill 24-1346, which we know this commission was engaged in, explicitly references the entirety of DI communities and not a subset referencing CI communities. And finally, by definition, DI communities are already overburdened. Adding more pollution into these communities puts them at even greater risk of becoming CI communities. On the next slide, this map illustrates 2 neighborhoods that are directly adjacent to each other that have the potential to be subjected to 2 different processes if the August draft rules are adopted by the commission. On the left, you see a census group scoring in the 66th percentile on EnviroScreen, and just across the street, a neighborhood with an EnviroScreen score in the 95th percentile. We often discuss, and it's certainly been discussed between commissioners already, how air pollution ignores community and neighborhood boundaries. And by applying the August draft rules, the community to the west could be subject to the same pollution as the CI community to the east, but also have a very different process. And further, on the next slide, this piece is the same neighborhood that shows a census block group that's just to the north of the one that we highlighted prior. While the block to the south was in the 66th percentile, this block group is in the 79th percentile and would just miss qualifying for the requirements in the August draft that apply only to CI communities. And this community, when you consider the very purpose that these rules are designed to address, is highly impacted. They're in the 92nd percentile for asthma hospitalizations, 85th percentile for exposure to certain toxic air emissions, and 82nd percentile for other air toxics. This is just one of multiple examples from across the state that we found, and we're happy to share additional examples if it would be helpful to illustrate how CI communities is not the right tool to address some of these concerns. And even staff noted that they believe that this may not be the right tool as well, and we certainly concur. The commission cannot leave DI communities behind or ignore the segregation that this use of the term causes. And therefore, the ALG endorses the comments that Green Latinos shared earlier in their presentation and other parties that recommend a proximity approach as opposed to using CI communities to ensure the strongest protections for all DI communities in alignment with the legislative directive. Thanks. Kate, I'll turn it back to you.
Thank you. So I'll finish up here. So again, Kate Burke with the Boulder County Attorney's Office. You've heard a great deal about 604 and the June 14th version that included 604C, a new 604C. We strongly support that version over the August 2nd version. We specifically endorse the great comments by Earthworks and Green Latinos and other parties and won't repeat those. I do want to point out or sort of re-emphasize along with my allies there that the stricter setback would not be redundant to the other DIC protections added into the rules. The August 2nd draft does add a robust set of procedural protections. We recognize and appreciate those, but we want to point out the difference between procedures and outcomes. And those additions improve procedures, they don't guarantee outcomes, whereas the strict and tighter setback would be much more protective of the outcome there. Okay, what I want to spend most of my time on the cumulative impacts analysis at the CAP and the OGDP levels. And this is something I've been thinking a great deal about in the last few days, is listening to commissioner questions and other parties. And so I came up with a proposal that might be of interest to you for further discussion. So First of all, we were very glad to hear that we weren't the only ones confused by the draft as to when the CIA actually takes place. But I echo Ms. Leafwood that we're very happy to hear staff's intent that a full CIA still occurs at the OGDP level, even if it's part of a CAP. The bottom line is CIA is essential at both levels, but it should be done differently and with different focuses or foci at each level. At the CAP level, we're talking about a landscape level, broader look at the impacts across a larger area, and especially with a focus on those impacts that travel furthest. So that would be air emissions, water bodies, for example, wildlife migration patterns. And that's very important information, but it does not a substitute for the granular level that would happen at the site-specific level. So at the OGDP or the Form 2A level, which in a wonky sense, these are actually the same. People keep mentioning them differently, but it's the same procedure. So that level is very important to look at the granularity of the local site. It's also the temporal proximity of when the analysis is done to when the development is done, which I'll talk about in just a second. And then we're focusing especially on impacts that don't travel so much. So health impacts in particular, HAPs, noise, odor, light, dust. We are hoping that you will add traffic to that. And I just wanted to point out, you're more familiar with CAPs than I am, but I just glanced at the PDC Guanella CAP, which was recently approved. It covers 52 square miles. It proposes 22 separate locations, and development is proposed to happen over 10 years. And so this is what we're talking about. And yesterday, I think it was, Commissioner Cross had a dialogue with Ms. Leafwood about geography. And I think this is what she meant, or at least what I mean when I say geography, that you could have a location in one corner of this 52 square mile area, and then another location in a different corner. And those are 52 square miles is a great distance, and they could be very, very different as far as topography, ecosystem, wildlife usage, human development patterns. They're going to be quite different from each other, and therefore needed to be treated individually. And then again, if you develop one immediately and one 9 years from now, again, whatever patterns existed at the CAP point may have changed significantly. So here's my proposal. I'm trying to find a way to cover cumulative impacts at the two different levels, but appropriate to what those levels are actually looking at. So at the CAP level, I'm proposing a two-piece review. First, we have the Form 2F that staff proposed, although we think it needs to be beefed up. We don't think it covers enough topic areas. And then secondly, what's not in the current draft is as an analysis needs to happen at that point of whether that area can absorb that project. Back to what Ms. Sanchez was talking about, this is the critical question in cumulative impacts. I don't know how Form 2F plays into the review process, or whether it only goes into the CIDR database and is never looked at. That's my fear. I'm hoping that it's something that they sit down and look at. But 2F is a fine idea. It can be made appropriate to that larger scale CAP review, but it needs to be actually considered at the CAP level to decide whether that CAP is appropriate in that area. And I did want to point out that in the CAP rule, operators aren't required to even identify specific sites. They can, but they don't have to. And so you could have a CAP application that doesn't even say where the locations are going to be at all. So this is yet another reason why we need part 2, which is at the OGDP and Form 2A level. And this is also a 2-part piece. What I've tried to invent was a Form 2B light, which I'll line out here in a minute. But very importantly, it's also followed by the full 315B CIA as well. So my idea for Form 2B light is that at the CAP level, they've done this Form 2F, they've covered some of the larger scale impacts, and now we're doing Form 2B, and there may be some overlap, and maybe we can parse that out a little bit. So from my reading through the requirements of each, my proposal was that just as written in 315A, so no change to the Form 2B, would be these 3 topic areas: impacts to public health, impacts to local water resources, and to the public welfare items, which are noise, light, odor, dust, and we hope you add traffic. So those are all still considered for the impact area as they normally would be. And then the light portion is, and this is complicated, and again, it's just a first thought of mine in the last day or two, that we could perhaps eliminate or cut down on some other portions of the Form 2B if the timing is right. So if the 2B is coming in 12 months or less after the 2F, there's no need for the operator to report yet again on their same intensity target compliance. They already did that. If it's more than 12 months out, then we probably need a new report. And then my other effort was that if the OGDP is coming in less than 2 years after the Form F or 2F, then they would be reporting on the update or the differences that what have changed in the last 2 years on the air resources, wildlife and ecosystem usages, biological soil resources, the existing and permitted ONG in the area, and the existing and permitted industrial facilities in the area. There's a decent chance that not much will have changed on those elements in 2 years. However, if it takes them more than 2 years to get around to their OGDP, then I think they do need to do the full analysis on those pieces. So this is just a, oh, and then of course it's followed by the full 315B cumulative impacts analysis as staff mentioned was the intention in their presentation. So just something for discussion. It's not fully vetted or fully hashed out. I haven't really talked about it with other stakeholders either, but something for consideration. And I think that ends what we wanted to present now. We can reserve the rest of our time for rebuttal. And of course, we're here for questions.
Great. Thank you very much to the panel. I might start out this time. I haven't started too often. Ms. Burke, do you have a chance to bring up the red lines that were attached to your pre-hearing exhibit?
The ones with the wrong numbers on them?
Yeah.
Yes, I can. Just a minute. It's going to take me a minute to fish them out. Yeah.
So, and this, I'm just looking at my notes and I'm trying to turn it into a question, and this is for you, Ms. Sanchez. So bear with, because you were speaking very quickly on a lot of really important topics, and I want to kind of dive a little deeper into some of this. We've heard from a number of different parties, and now from you as well, that there's this disconnect of looking at cumulative impacts on this permit by permit basis versus looking at it sort of, I think you used the term synthesized. And that's why I wanted to bring up the red line to get you a chance to sort of walk through how you would take us through that. I think that's 315B2F, perhaps. Do I have that right? And if so, can you walk us through a little? Oh, wait a minute, Ms. Burke, you're sharing a screen, but it's not really doing much for me.
Okay, what are you looking at? I'm not sure. Let me stop and start again.
Okay.
So are you seeing?
There we go. Yep, that's
Okay.
better. That's better. So I think this 315B2F was the idea that Ms. Sanchez had floated about sort of synthesizing this down. I'm going to get back to the avoid, minimize, and mitigate here in just a second.
And will say this is one of the ones that was
yeah, that's fine, but the words are on the paper.
This is what we're talking about. Yeah.
So looking at that, a narrative now of the combined impact set forth under 315B2E, we fully avoided, minimized, and how they will combine with the existing conditions and the impact, and how they will combine with each other to create an overall impact profile. So yesterday I had a discussion with Mr. Freeman about, he had advocated for a similar approach that we need to look a little more broadly and not permit by permit. How does one turn this piece of paper into a permitting protocol? Like, generally speaking, we get two forms of applications at the commission. We get permit by permit applications, which is normal, and then sometimes we get comprehensive area plans. I can certainly see this synthesis approach that Freeman advocated for and you're advocating for sinking well into a comprehensive area plan. How do we do this, though, if the operator's coming to us with just one location?
Are you directing that question to me, Commissioner?
Yes.
Okay. Well, there's sort of two distinct things. So I think this synthesis is talking about all of the plans that are above not being looked at as separate things, but how do all of those descriptions of impacts collectively affect an area? So that's the synthesis part.
So this one is the 7 or 8 different areas plus transportation that you would advocate for.
Correct.
And then you bulk them all together and come up with this analysis under this. Okay, let me follow that line of thinking then as well. So if we do that, then what form of approve, deny, approve with conditions does the commission need to create? And it may already be in there. There's a lot in this rulemaking, but like, how do we apply that? How do we like, oh, this one's easy. It's absorbable, or this one's not. I mean, it's like the old definition from county government days of it. Is it compatible or not?
I think that's the $1 million question. I mean, I think that's tricky, where you are determining, you know, what is unbearable, what is overstressing an area. So it does take analysis to do that, but you're using all of the data that has been given to you and the public process to help determine if those things are overbearing for a particular area. I think the point we're trying to make is that when you're just looking at an individual permit, you're not getting the full picture. It takes looking at the, you know, all of the impacts for that facility, and then looking at it in the context of that site, along with everything else in the site, to see if it's just too much.
Okay, so and that I think is the second $1 million question. The first being when you're looking at one area and you've got the 8 things, including transportation, and then you do a synthesis. How do we know when it is absorbable? It is okay. It is not, you know, a problem. And then the second question is, and this is what Mr. Freeman was getting to yesterday, and I think what you were getting to is, you can't just do a cumulative impact analysis based upon one permit. You need to look broader. And if that's the case, and if they're not doing a 50 square mile cap, how do we determine what I mean, you know, we've got the impact area being 1 mile. Is that the answer? You just, and you may want more than a mile, or you may want it to be adjustable, but is that how we do it?
I think that's a start. So you're looking at the impact area. So it's the minimum 1 mile, which could be adjustable based off of site specific conditions, or, you know, extensions that may need to be made, but we have that 1 mile. And then we're looking at what's in that 1 mile that exists that could be already contributing to, you know, intensity in that area. And then how is the proposed oil and gas facility incrementally adding to that, with all of its kind of singular impacts that are proposed individually with the facility itself.
And then we still have the first $1 million question to try to answer is, how do we make that, albeit subjective determination? Okay. Ms. Burke, if you can.
I think the tricky part of this is that, I mean, maybe there are some quantitative thresholds that can be, you know, outlined, and maybe that's easier with things like the air emissions, and, you know, I would defer to Elizabeth on some of that stuff. For other things, it is more subjective, but, you know, you're looking at everything in the area to see, you know, what is too much. Sorry, I lost my train of thought with that when I deferred to Elizabeth. So I'll let her go and see if that thought comes back to me.
Ms. Parnos, would you like to add?
Sure, just very briefly. So I think exactly what we're proposing would answer sort of part of this question and concern, Chair Robbins, which is, so the staff has chosen to rely on greenhouse gas and NOx intensity targets established by the AQCC as a way to measure whether or not the emissions from the operator, and in some instances, all of the operator's operations, will impact air quality. So you now have this objective standard in your rules, which are compliance with, having the operator demonstrate compliance with greenhouse gas and NOx intensity targets. Those are quantitative, clear standards. And what the draft does a really good job of is taking those standards, making sure that the operator is in compliance with those standards as those standards apply to the operator's historic activities and emissions and current emissions, but not considering the planned emissions, which is what you guys do, right? You permit new activities. And so we think it's just crystal clear, and you have all the tools available in at least this one instance for evaluating cumulative impacts. And that would be how do the additional emissions from the planned operations, how will those impact operators' compliance with their greenhouse gas or NOx intensity? That one seems like a relatively simple one because it's quantitative. There's other examples that we haven't proposed here that, for example, Mr. Freeman discussed on Tuesday, such as that we've talked about in the past, which we think requires some modeling, but that would be looking at, for example, the operator's estimated hazardous air pollutants and doing some modeling to determine whether or not the addition of those hazardous air emissions to what's already in the air in the impact area would cause concentrations of hazardous air pollutants that exceed health-based standards, which again are quantitative objective standards. That's not something we're talking about here specifically, but just that's another example.
But let me push back just ever so nicely. ECMC doesn't have the expertise to do air modeling. We don't do air modeling. So how does our staff have the ability to understand whether the operator's proposal will exceed its NOx intensity target in the future?
By all of the information. So the information that your staff is asking the operator to submit, it's estimates of NOx emissions, it's estimates of the wells that will be drilled, what BMPs, including what type of drill rigs the operators will use. The operator has available from the manufacturer what the estimated NOx emissions from those drill rigs, completion equipment, et cetera, are. And so, and they have to provide that information to you on their Form 2B or 2F. You have quantitative information. You don't have to do any modeling. There's no modeling required. You simply look at that, you consult with CDPHE, you say, wow, as in fact, Ms. Trask was discussing on Tuesday, last year, this operator barely complied with its NOx intensity target. They came within an inch, right? They're now proposing 50 new well pads. They're not proposing to use electric drill rigs. They're not proposing to use the cleanest frac equipment out there. In fact, they're estimating that there's going to be additional NOx emissions from those activities. Looking at what they've done and consulting with CDPHE, we think there's a real risk here that the operator is not going to comply with its NOx intensity. We think that is the kind of determination that you absolutely can make, especially in consultation with CDPHE, and it does not require any type of modeling.
Okay, I'm hoping my staff is taking good notes there so that we can sort of dive into that a little closer, as we have a break here in this. Let me go back to Ms. Sanchez and Ms. Burke, if you could move to 315B2D. This is Ms. Sanchez's ideas around how Boulder County and the ALJs, I'm sorry, it's all the ALJs, but Ms. Sanchez works for Boulder County because I can see it, but how the ALJs would advocate for and avoid, minimize, and mitigate. And I just wanted to give you a chance to walk through that, Ms. Sanchez, for the edification of all the other 135 people listening in.
Sure. So, this is what I was trying to speak to is it's really about breaking down breaking that framework into 3 different tiers. So first, avoid. So, avoid, mitigate, minimize. It's used kind of this collective phrase, this term of like all 3 things together as one sort of throughout the rules. We did make comments in our pre-hearing statement that while we're speaking about this in the context of the cumulative impact rules, this really applies wherever that term is used, because there are three separate things. So the first thing you would want to do is avoid the impacts if you can. Like an example of this in the planning world would be a house is proposed in the floodway. The property isn't encumbered by the floodway for the entirety of the parcel. So when we look at, and again, these are just really simple examples to illustrate the point. We move the house out of the floodway and our regs require that. So it says avoid the impact, as our first kind of tier. So we move it out. Secondly, if we can't completely avoid it, then that's when we're considering ways to minimize the impacts. And so that would be, the things like, are fewer wells on that well pad going to perhaps minimize the impacts? Are there other things that can be done? If that can't be done, then we move to mitigation. And those are sort of, the package of BMPs that happen kind of regularly on a site, but those aren't sort of the answer in every time. There really needs to be this higher level of analysis of truly considering sort of substantial things like relocating, saying no, downsizing, and looking at those options of avoidance first, minimizing second, and then minimizing as sort of a third option. So that's, I think, what I'm trying to get across about the hierarchy.
And then you tie it all up with your synthesization at Roman sub 4.
Yeah, so I think that was another issue that I had with the regs in some part, is that cumulative impacts and the analysis of those it's a different concept than avoid, minimize, and mitigate. That lens of avoid, minimize, and mitigate can be used to analyze cumulative impacts, just like it can be used to analyze an individual oil and gas facility. But they're two different things. One is sort of an analytical lens of how to assess the impacts and how to kind of address the impacts. The other is looking at the impacts of the facility itself, as well as how it fits into the broader region.
Thank you for that. Ms. Burke?
Thank you. I just wanted to add the other piece that we built into these red lines is some transparency. So if an impact is not going to be avoided, we want to have it be clear why that is. So we want the operator and or the staff to go through the exercise of being clear. Why are we not avoiding completely? Why are we not able to minimize completely? And then this last piece we added is if it's in or near a DIC, I think is what we meant. Oh, no, I'm sorry. It's not. It's everywhere. Is that at the end of the analysis to just be very clear and transparent and thoughtful about these are the impacts that we're allowing to go through, and this is why in this case. So I just wanted to point out to that piece of our red lines as well.
And then go ahead, Ms. Sanchez.
One other thing I would note, just because I was speaking so quickly, and I apologize if it was too quick for everyone, but the ALA, the alternative location analysis, is really a big part of that avoidance piece. So when we're talking about is this location the most appropriate for it, whether it's on a site or in a region, that's where the alternative location analysis can really be valuable if it's done in a way that's meaningful. So, I think I've been to presentations before where I've heard of how operators do their ALA, and it's basically just saying how they rule things out. That needs to kind of be a mind shift of looking at what other locations might be better, and a real consideration as to whether the site they picked is actually the best one, not just based off of perhaps their mineral rights or whatever, but with all of these other considerations about the broader region.
Great, thank you. Ms. Burke, one final question from me to you. It gets to your cap and your cap level Form 2F beefed up and then Form 2B light that you sounds like you put together in the last few days. I'm interested in further exploring that. And as I think about further exploring that, my notes said at cap level, proposed two-piece review, Form 2F immediately needs to be beefed up. And then that will establish an analysis of whether that area can absorb that project. Did I get those notes right?
Yeah, yes, and that last clause there about whether the area can absorb that project is an analysis piece that I don't think currently exists. I don't think the Form 2F, this is part of the process I don't understand. If the Form 2F, I understand that it populates the CIDR database, but I don't understand if there's a stop in between where somebody sits and looks at it and reads it and considers what it means. And so that might be actually an addition, or it might be just memorializing something that already happens. But the Form 2F gets submitted with the increased or the added information, but then the new piece being somebody stops, looks at it and says, is this okay in this region?
Okay, yeah, I think that's another $1 million question of how do we know
Yes.
whether that absorption is allowable or not. So
Yes.
we'll continue to scratch on that. I appreciate the in-depth proposals from ALJ. And now I will turn it over to my fellow commissioners for any additional questions for the panel. Commissioner Messner beat Commissioner Oath by a hair.
I always wanted to be on Jeopardy, and so I'm pretty good at hitting the button. But thanks for the presentation. I really appreciate it. A lot of good thought went into this, and I thought it was helpful. And Ms. Sanchez, I really appreciate you bringing up this this mitigation hierarchy conversation, because to me, how that mitigation hierarchy gets implemented is kind of a keystone of how our rules work. And so I think your comment of the fact that avoid, minimize, and mitigate are not equal, but it is a hierarchy, ends up being a really important concept. And I appreciate your suggested additions, into Rule 315 to highlight that. I do note that in the existing rules, particularly Rule 319, no, it's 304, hang on just a second. 304C19, sorry, I was confusing myself. I mean, it talks about implementing the mitigation hierarchy, and there's multiple pages in the statement of basis and purpose on how to implement the mitigation hierarchy, and I think talks about a lot of the things that you're bringing up here, which I think are relatively boilerplate land use applications of the mitigation hierarchy. Do you think that more needs to go either into the statement of basis and purpose or into the rules, or get pulled from the statement of basis and purpose into the rules to better clarify how the mitigation hierarchy gets applied, not only to cumulative impacts analysis, although I know that the mitigation hierarchy in the existing rules and in the current rules focus a lot on cumulative impacts and the cumulative impacts analysis, but then also goes on to talk about wildlife. But I guess my question is, I wonder if what you've put in the rules is enough, or do we need to bolster that out further so there is no confusion as to how to apply the mitigation hierarchy?
I would agree with that and fully support it. I think wherever and whenever it's mentioned in the rules, whether that or the statement basis of purpose, any additional clarity on how to utilize that framework would be helpful.
Okay. And I wonder, as you have this, maybe during the break, not the break today, but the break later next week, if you would take a look at the statement of basis, current statement of basis and purpose, page 91, and maybe think about like what language could be utilized or pulled from that into the rules, or whether whether you have additional language you might recommend. So I do have one question though, because I've struggled with this one a little bit. And so whether it's at the cap level, whether it's at the OGDP level, kind of the jurisdiction of traffic, right? And, you know, local governments have often, I don't know if you claim jurisdiction over traffic, but have utilized traffic analysis as part of their processes. So talk to me a little bit about like the role of local government versus the role of the state in requiring traffic analyses, information around traffic planning. Like, how do you see that working, either from a cumulative impacts analysis or even from a cap or an OGDP standpoint?
I think that it's the ALG's position that even though local governments, many certainly look at the traffic impacts, it's not out of the realm for ECMC to also evaluate the impacts of traffic that are associated with an oil and gas facility. So, you know, we know that truck traffic is known to have significant impacts, whether that be a source of emissions or a source of noise, vibration, travel disruptions on a particular corridor, how it may affect residents nearby. I think there are certainly impacts that are related to a specific oil and gas facility that should be analyzed in the context of new proposals.
Great, thanks. I agree. So someone want to speak?
Ms. Burke?
I was just going to add one thing to that I think on the one, there's associated truck traffic with the oil and gas operation, and that's been recognized at least for, let's see, I think the new definition of impacts to climate includes associated truck traffic. So we're clearly recognizing that truck traffic is part of an oil and gas operation. And then I think beyond that, there's also the governor's statement that even activities that might be beyond COGCC's direct or ECMC's direct jurisdiction can also be considered. So I just wanted to throw those two pieces
in the analysis of the cumulative impacts. Yeah. So again, Ms. Sanchez, so there's often this question, how do you evaluate cumulative impact? How do you evaluate whether or not cumulative impacts have adequately been addressed? And so in my experience with land use planning, that is done by particularly performance-based land use planning through the utilization of referrals and consultations. And so in Boulder County, in your process, if you've got a land use application, like how many referrals does that go through internally and externally to bolster any kind of finding or decision-making to help make those decisions around the potential impacts of a land use application?
We have a lot of referral agencies that we'll send to, depends on the nature of the particular application and who might provide expertise. So I think that's why we really support a lot of the involvement at the pre-app and the consultation and, you know, in figuring out what the impact area should be when this process is starting off. But I think there's a lot of expertise out there that can be relied upon. It's all information, it's all data points. Sometimes you can defer to an agency for their expertise. Other times it's just input to be considered. Ultimately, I think the, permitting agency, whether, in my world, the local government, or in your world, the ECMC, does need to provide some analysis of that. And I think that's sort of the mind shift, I think, that needs to occur also, is that, a lot of what's being submitted, it's not just about checking it off the list and submitting a plan, but it's actually doing something with that information and discerning it to see if, a different determination should be made based off of what's submitted.
That's right. And utilizing the information that's being provided by the referrals, the expertise that's being provided by the referrals and the consultation, but then ultimately having to utilize judgment and expertise of the reviewing body to determine whether or not it's met that bar, right?
That's correct. And, you know, and I think that, you know, this goes back to this idea of the $1 million question. In some ways, I wish I wouldn't have mentioned that, because as Elizabeth pointed out, Ms. Paranos pointed out, there is some guidance already that directs us to when something might be too much. At least in the, you know, as it relates to air degradation. That's really clear guidance that we have. That we can rely upon. In, you know, in other worlds, I feel like it's not always black and white. There perhaps could be better guidance that's provided, but ultimately it's going to take some analysis from, you know, people and training people to use this rubric of avoiding, minimizing, mitigating in order to, you know, really create to make some smart decisions about, you know, what it is that we're developing.
Right. And like, to get a little more specific, I mean, I just to get a little more information, and, you know, Boulder County, I assume, probably has 8-10 different internal referrals that happen as part of a land use application, depending on what the land use application is. And then, you know, maybe half a dozen external referrals as well, or again, depending on what the land use application is, and those all help inform that decision making. And, you know, at ECMC, we've got 2 externals. We've got CDPHE and we've got CPW. And the CDPHE referral, while often focuses on emissions or public health, you know, also probably needs to, and I'm asking your opinion, needs to focus on potentially, it needs to at least have the experts within the agency's eyes on the application in order to have an expert opinion on that. Would you agree with that?
Yes.
Okay.
I also think, you know, aside from departments or agencies, you have the public process and, you know, people that are participating as, you know, as these things proceed. A lot of people spend a lot of time really navigating the ECMC website and trying to figure out what proposals are, you know, coming to them, you know, near where they live. And you heard from a lot of the citizen advocate groups, you know, so far. So I would say that, and local governments. I mean, that's why we have really, you know, fought to be a participant in many of these processes, or at a minimum get notice, so that we can look for opportunities to provide input.
Thank you. So my last question, and it's probably more of a comment than a question, but it's to Ms. Burke, and it's really interesting. I have in my notes from yesterday or the day before a concept really similar to what you brought out here, as far as you know, how to apply the cumulative impacts analysis and the data associated with the Form 2Bs or 2Fs from a CAP or a OGDP. I think both are important. I think you hit the nail on the head as far as, you know, there are different things that you're analyzing at the CAP level that you're analyzing at the OGDP level. And at the CAP level, you may not have the level of detail necessary in order to be able to analyze certain things, but you certainly have that at the OGDP level. I mean, I think about it like, you know, if you have a comp plan, like a CAP, you still have to have subdivision planning, right? If you've got a subdivision, you still have to have building permits. And so, I mean, this is all important pieces. They're just at different levels. And so I also am very interested in that getting fleshed out and thought about a little more, because I think that's, you're on track, I think, from my perspective on like how that could potentially work. So like I said, not really a question, but a comment.
Well, I appreciate that, and I'm more than happy to talk with anyone. Like I say, I haven't even really talked with my usual set of co-thinkers on it yet. But the other point I wanted to make a little bit earlier too, is I think in this rulemaking, and because of the climate situation and the legislative and administrative direction, we're focusing a lot on air, but we need to think about noise and odor and light and these things. And these are, very local. They're not going to be traveling a mile from the site. And the other point I wanted to make about the $1 million questions is we do have in the rules, I remember distinctly from Mission Change arguing about decibels and lumens and some thresholds around noise and light. And so some of those things, it's tricky, but they can also be quantified to some extent. We can create some sort of thresholds around those too. And I just don't want those things to get lost in sight of the urgency around climate and air. But let's not forget these other public welfare issues as well. And then back to what you're saying, that there's no way to analyze those at the cap level.
Great. Well, thanks for the presentation. Thanks for the work on this. No further questions.
Other questions from commissioners to the panel? Commissioner Oath.
Thank you. And actually, at this point, it may mostly just be comments, because the topics that I was interested in talking with these folks about the previous commissioner questions covered as well. So first, Ms. Paranos, thank you very much for the kind of explanation about thoughts on kind of how ECMC could be looking into the future at NOx emissions coming up. That was kind of precisely what I was thinking about when Ms. Trask and I talked about it on Tuesday. So thanks for articulating that very well. I appreciate that. And then similarly, Ms. Burke wanted to also say I'm very interested in the idea that you put forward. It has been clear the last couple of days. I too have been wrestling with and asking parties what is the appropriate information to be provided at the CAP stage and at the OGDP stage in order to be the most helpful without being duplicative and really being meaningful. So I think your idea is very interesting. I am hopeful that other parties will be thinking about it, that there will be ongoing conversations, outside of, the proceedings. And then, certainly we'll be interested in hearing other parties' thoughts on it when they have a chance to have those understand it well and then have their chance to talk with us as commissioners. I hope. So looking forward to seeing how that develops.
Commissioner Ackerman.
Thank you, Mr. Chair, and I'll be very brief. I think Commissioner Oath made the point that I was intending to make, which is I'll be very interested in hearing particularly what operators and others have to say about the proposal put forth by Ms. Burke, and reiterate what the chair said, that really do appreciate it and found it very helpful. I've been pondering much along the same lines with what you've laid out here. One clarification on that though, Ms. Burke, if you would, you mentioned, and if I missed this, I apologize, but if you can reiterate for me, you mentioned a couple of times that the Form 2F would need to be buffed up or beefed up. And I'm not sure you went into kind of your thoughts on what needed to be beefed up, or if you did, I missed it. Can you let me know or reiterate?
Yes. Yes, I did. Do you want me to reshare or just, it'll take me a minute to do that, or I can just read out?
Don't worry about resharing. I'm already embarrassed enough.
Okay. So Rule 314E10 already has some elements for the 2F. So we have, those are great, good start. And then, but the additions would be, okay, in 314N, it talks about water resources, but then the content just talks about storage tanks. And so unless I'm missing something, there's really nothing there about water resources. So I think we need a piece around water usage and the impacts on water bodies. So that's an addition. The second one is impacts to climate as newly defined, should be part of it. Number 3, I had the transportation corridors and traffic patterns, as we were discussing. Number 4, I have the existing permitted and proposed oil and gas facilities in the CAP area. And by the way, I'm pulling a lot of this from the alternative location analysis piece, so these aren't coming out of the blue. And then the last one was existing and permitted industrial facilities in the CAP area.
Yes, thank you. I appreciate that. I did hear and internalize all that. I just didn't make the connection with the beefing up of Form 2F. So thank you so much.
Yeah.
And then just one question. This one's probably directed at you, Ms. Sanchez. And again, appreciate your expertise and found it to be very helpful. Thank you for your thoughts. You mentioned the importance of having, I don't think you said it this way, but a malleable impact area, and I didn't find anything in the Allied Local Government's comments on the proposed 1 mile starting point. And I didn't hear anything about that today. And I think we've had this discussion with a couple of different folks that we are trying to kind of synthesize and understand how we standardize to some degree. Does Allied Local Governments have any thoughts on the proposal of a 1 mile starting point with opportunities for media specific expansion?
I think we support that.
Thank you.
So as long as there is the opportunity to adjust it, perhaps make it broader based off of the specific impacts and the site specific features, be that a wildlife corridor or more broadly like the air shed, then we may need to adjust it. But I think we are in agreement with the 1 mile minimum as long as it can be adjusted. And we did ask for more participants to be added so that those folks can be conferred with at the very beginning stages when the impact area is being determined initially.
Thank you. That was my next question. So I appreciate you touching on that. And I was inferring from your statements that on those media that don't travel largely, that you would have some thought about the 1 mile buffer being at least an appropriate start in some cases. So I appreciate your clarification on that point and appreciate the thoughtful approach by the Allied Local Governments. Thank you.
One last question, Ms. Sanchez, before we let you go. And I have no idea where this is, but somewhere within the August draft, there is a reference to, we built in a Hardy pre-app consult process. And then I think the August draft had if the local government is doing a similar Hardy pre-app local consult process, then that could substitute in for ours or something like that. Are you familiar with that piece?
I think Kate is, so I would defer to her.
Okay, Kate.
Yeah, I think the way I understood it was there is so we're not talking about the local government's own pre-application under its own code, but there is a local government pre-app consult opportunity. And then there's a general pre-app consultation opportunity. And I think it says if you do the local government one and enough participants are there, then that can suffice for the second one. And I have to look at Ms. Trask or the AAGs to make sure. That's the way I read it. It feels a little bit clunky, but it was clear enough. I mean, it helped. The earlier draft was unclear about which consult was when and what.
Okay, and maybe we can refine that as we move forward with the process. Just wanted to get your quick thoughts on that before you leave.
No, I thought it was plenty inclusive and appropriate and good timing and all that. It was just a little bit unclear. And just the only additional participant we added, this actually refers back to the geothermal rulemaking we just did. We wanted to expressly say that community-based groups for DICs should also be available to be included in those pre-apps. So any groups, for example, the Greenhouse Connection Center, a group that's identified by the community should also be included.
Great. Again, really, I'm sorry, Commissioner Cross.
Thank you, Mr. Chair, and thank you. I also think that most of my questions have been answered already. So I just want to, and I think Ms. Burke, this will be directed at you, just to get a little bit more clarity on the cap proposal that you were talking about. So the way I understood it was you will do a cumulative impact analysis and the 2F information, again, beefed up at the cap stage. And then at the individual OGDP stage, you would want to do the analysis as well. Is that correct?
Not quite. So probably should define terms. So when I say it's a cumulative impacts analysis or a CIA, I'm talking about the full Rule 315B full-on CIA.
Okay.
I do not recommend that at the cap level. I don't think it's going to be meaningful or really doable. So what I do recommend is the beefed up Form 2F, but then that somebody stops and reads that form and determines whether that looks like it's gonna be okay in that region, if that makes sense. So a cumulative impacts look, but not a full-on CIA at that level.
Okay. So the cumulative impacts is not twice, it's the
Correct.
information going into the documents twice. Okay, that is part of what I wanted to make sure I clarified. And then you talked about it, we'll call it almost like, I think a hearing and NEPA sort of issue. You said within 12 months, some of the information would not have to change and that's with respect to NOx specifically?
Yes, and that was on my very vague understanding that the NOx intensity is evaluated annually. I'm not even sure if that's true, but I just thought there's going to be some period of time where at the 2F, at the cap level, they're going to say we are not in exceedance and don't expect to be. And then if 8 months go by, that information should still be good, but I would actually look to Ms. Baraños and others. No, she's shaking her head no. So that might be need to be looked at a little more closely. But the intent there is that as long as the information given at the cap level can remain fresh, if you will, then we can just reuse it. But there's going to be some time frame when it becomes stale and we have to redo it. What precisely those timeframes are going to be sounds like we're going to have to get some pencils out and figure that out.
And would this potentially be breaking out some of the different information? So NOx is maybe good for a year, but maybe some other information included in the 2F might be good for, and I know you mentioned 2 years for some of the differences, but might some of it, you know, waterways or roads, something might be good for a certain amount of time, or do you see that kind of being analyzed on a case-by-case basis?
Well, I know that case-by-case basis is tricky for the agency, just the way you work and the number of things that you look at. So I was trying to create more of a framework. I hesitate to put actual times to any of these things without getting a lot more input from people who know. But so I'd say conceptually, as I say, some of it will last and some of it won't. And we just have to be careful of that. And I just think about those instances where development crops up around a site that wasn't there, and that can happen relatively quickly. Or, for example, wildlife, as I understand it, wildlife occupation patterns can change significantly within a handful of months or from year to year. So just to have a way to incorporate those changes that are coming, but also at the same time be trying to avoid any duplication and redundancy.
No, I absolutely appreciate that. And that's helpful for me to understand as well, because I know there's obviously the talks about, well, this is duplicative. Why are we doing this again? Or why are we doing additional analysis? So that I think that is helpful. And I appreciate the thoughts and concepts of trying to make sure that we make it a more efficient process. As I said, I think my other questions were answered. So thank you very much for everyone.
All right. Thank you, Allied Local Governments. We've appreciated your presentations to us over the years through Mission Change, through this. So we will let you go for now, and we will move to our next stakeholder. But first, we're going to take a break. Let's return at 2:55. And at that time, I believe we are going to hear from Garfield County. So if we could get Garfield County, or not Garfield, it's Garfield County and the Rural Local Government Coalition. Get all those guys set up, and we'll be back at 2:55. All right, we are back. It still is September 5th. It is 2:55, and we still are undertaking docket 240600145. We now will hear from Garfield County and the Western and Rural Local Government Coalition. Ms. Gutierrez, good to see you.
Good to see you. Thank you, Chair Robbins. Commissioners, let me just get our slide deck up for us.
Good afternoon, everybody.
Good afternoon, Mr. Nguyen.
Okay, do you guys see that slide deck? I can't tell when I'm sharing.
Yep, it looks good.
We're good to go. Okay. Well, good afternoon. Thank you all for the audience. It's always a pleasure to see you. My name is Ana Gutierrez with Womble Bond Dickinson, and I am representing Garfield County and the Western and Rural Local Government Coalition. Because that name is a mouthful, you'll likely hear me say WRLG, or the coalition for short. And I'm battling a cold, so just bear with me through that. I recognize your time is important, and this is a long hearing, so I'm going to be as efficient as possible. Let's jump right into agenda. I want to start with just a little bit of background on the member communities of the coalition to give you some context to some of the positions we're going to present, and it's going to be a bit different from what you've heard to date, which has been largely from sort of the more urban communities. We're then going to take through what these local governments see as the key issues to be reasonably resolved in this rulemaking. Those are DICs, CICs, and the co-equal siting authority of local and state governments. And then I'm going to summarize and step through some of the recent revisions from staff that the coalition supports. I've already introduced myself, but we have the benefit of Mr. Kirby Wynn, the Garfield County Oil and Gas Liaison. Kirby's available to answer any questions you may have. I just want to flag that Kirby's out tomorrow through next week. So if you do have specific questions, we would love to field those today. So this slide here, it visually reflects the 23 counties and municipalities that are members of the WRLG. And as you can see, they comprise a sizable portion of the state. Notably, these are very rural communities with large land masses and relatively smaller populations. So when we're talking about communities throughout this rule, we need to be sure we are in fact targeting people and not large swaths of land. It's also important to recognize, as the data show on your screen, that there is considerable oil and gas production in these member communities. That considerable production runs hand in hand with the health and wealth and welfare of these communities. This graph shows all the jobs stemming from oil and gas development and all the wages earned by employees, and this is just limited to Mesa and Garfield County alone. So in just the last few years, industries provided jobs to over 2,000 employees in Mesa and Garfield counties and brought $40 to $60 million in wages. That's real money putting food on tables of our communities. And if you draw that out locality to locality, you see how important resource development is in these communities. What this chart doesn't show us is the immense funds coming from taxes as well that go to schools, community centers, libraries, cultural centers, emergency infrastructure, all those things that are really important to these communities. The takeaway here, and we're going to dive into this, is many of these communities, as we'll talk about, they're defined really broadly as DIC. And when I say community, I should clarify, entire counties are defined as DIC. And those definitions sit there on the basis of economics. So without resource development, we will really truly see these communities suffer. With that background, let's dig into the proposed rules and the coalition's requests to this commission. And I want to kick us off with DICs. Let me start with a statement that doesn't lack clarity. All members of the Western and rural local governments fiercely advocate for their communities. In those efforts, WRLG supports very intentionally and very pointedly underrepresented and disproportionately impacted communities. Bottom line, there's no debate there. WRLG's concern is not with the purpose of DICs. Like I said, we support that. It's really the application of the definition, which is frankly too broad to really implement its own purpose. The reason is that DICs start at the census block, and then a census block need only meet one of the criteria listed on the screen that you see to be deemed DIC. While we take issue with the breadth of the definition of DIC, that's not before the commission today, that's statutorily defined, but we can be careful about how we apply that definition and implement it in these processes. So notwithstanding the criteria that brings a community into DIC, WRLG asks this commission to remain highly focused on people, actual communities. If application of DIC is so broad and we're obligating more stringent regulations on uninhabited Colorado, then we've lost focus. These are visuals in Kirby's pre-filed witness testimony, and they show how the baseline of the census block is really just too blunt of an instrument for Western and rural Colorado. This is because the census blocks are generated off of population. And when you don't have high population densities, you have really broad squares, if you will, that get selected as DIC. So on the left, that's the entire state, and you'll see entire counties really on the peripheral where populations are lower are defined as DICs. By comparison, on the right, you see a zoomed in visual of just the Denver area, and that shows there's much more precise and smaller demarcation between census blocks. And that's a lot of the examples you've been seeing from testimony so far today. They've all been highly focused on that dense Denver area census block. Makes sense, but we just need to draw your attention to the fact that that is not the experience in all of Western or rural Colorado. And again, the reason for that is because there's so many more people in those highly populated urban areas. We also need to keep in mind the terrain in Western Colorado in particular. The severe peaks and valleys, mind you, as beautiful as they are, they create a really dynamic and different experience for potential impacts. So when folks are loosely referencing within 1 mile of an oil and gas location, you could be up and down 2 mesas within that impact area. And you're not truly having an exposure in the same way you might on the open plains or in the Denver area, for example. So we have to be really, really careful not to overgeneralize what is an appropriate scope of impact across the entire state. This next map shows the visual of the topo map that I just showed you. And sorry, that last map was just Garfield County alone, just by way of example. But this layers on all occupied structures in Garfield County. So residences, industrial buildings, offices, hospitals, libraries, everything we could think of that really, demonstrated where people live and have their community coexist. And the point here is they're fairly dense, and you'll see there's a lot of open space that remains in Garfield County. But again, the entire county is designated as DIC. So our ask here, and why we walked you through those mappings, is when we're talking about DICs, we ask that the commission stay focused on the people, stay focused on the communities, and not just broad swaths of land or boxes that are sort of less intentional than they need to be. In earlier briefings throughout this process, WRLG, we proposed global changes in some of the drafts that came from staff, where we had requested every reference to DIC also have an association of proximity to people. So this example you see on your screen is just one example. And again, we drew that out globally throughout the rule. But when we had conversations with staff and other stakeholders, nearly everybody agreed with us. And this was adopted and can't say adopted, was included in your draft rules and is currently reflected in what you're looking at. And what we ask is that you maintain this language in there and the importance of proximity within those any final rule that you adopt. Let me move on to CICs as a related topic. The definition of CICs is on your screen, and you've heard plenty about it already this week. The definition of CICs builds off of DICs, which again is at the census block level. And then it adds that layer of the Enviro screen score at the 80th percentile. Unfortunately, this newly added definition of CIC, and I think we've heard, quite a bit of feedback on this one, and this is maybe a slightly different angle, but it also fails to consider that proximity to humans, right? So the carefully crafted language that we worked closely with stakeholders to implement with respect to DIC. So you see this broad DIC, it's too broad, let's focus on people. We added the proximity to the building units. Now we've come back out and say all CICs and all CICs at census block, with the only modifier being the 80th percentile. So in many circumstances, that circle of CIC, it sort of consumes the neatly woven work that was done with the tailored CIC definition. I've also heard other stakeholders say CIC is not, it's too narrow in its own right. Regardless, I think that CIC on its own is not getting us to the goal we are all targeting to be at. The issue again with CIC is that it stems from the census block. And with more rural communities, that's not going to have any relationship or evaluation of people, communities, humans that might be impacted. And you have to look at really the more nuanced articulation of what's happening in this area. That said, we understand the issue, we truly do, and we support the overarching goal. And so we're here to find a solution with the commission, with other stakeholders. To address this friction, if the commission keeps the definition of CIC, WRLG proposes two options to the commission. The first would focus CICs to consider oil and gas locations within 2,000 feet of people and community. So any listed occupied structure, essentially. This is the same solution that staff selected for DICs, and the same exact logic applies. This is the proposal shown on your left, and this is WRLG's preferred option. The other option on the right would allow ECMC to leverage the definition of impact area. Currently, as drafted, your impact area offers flexibility relevant to the particular circumstance. So here, the proposed modification would be CIC is its DIC, you add the EnviroScreen score of 80th percentile, and then a community, right? People and their buildings and the structures would be within that impact area that is defined from each OGDP to OGDP. I will say we do not support the 1 mile impact area as a starting point. As we said before, when you're looking in Western and rural local governments, that 1 mile it looks a lot different than when you're looking in a more urban area. So we don't think that one size fits all really lands well when you're applying it across the state of Colorado. We would be more supportive of as currently drafted, more flexible approach. So you can look location to location to determine what is the appropriate impact area for which we need to analyze. So this is just putting the definition of CIC in action so we can think about how DIC and CIC has played out and what it means in our rules. This here is Rule 304D related to lesser impact area. Just as a reminder, and some of you were sitting on the commission then, this dates back to the mission change rulemaking, where this commission adopted the lesser impact area to specifically have a process that was more streamlined for Western and rural communities, where there were specific operations that would take place in remote areas. I know I sound like a broken record, but unless the commission focuses on people in its definitions of DIC and CIC, this type of concept is going to be null and void. So with respect to DIC, the current draft manages this very well by reference to DIC plus proximity to humans. We need that same correction with respect to CIC. And so that's why we're requesting one of the two changes on slide 14, or I'm hearing several requests for CIC to go away. We wouldn't be opposed to that either. All right, I'm going to shift us now to co-equal siting authority. This is absolutely fundamental to how ECMC and local governments interact in the implementation and truly all the rules, including cumulative impacts. Rule 302, currently on your books, title is local governments. We worked really hard during mission change to carefully craft and really surgically draft interactions between local governments and ECMC, so each would respect each other's processes and allow them to proceed in parallel. As a part of mission change, Rule 302C was adopted, and it stated the commission will defer to local government siting disposition. So take the red line on your screen, put defer back in. That's what your current rule says on the books. Here, the proposed draft rules would revise the word defer and change it to consider local government's disposition. Now, this seems like a small change, but it's really, really important. And the edit, frankly, it's unnecessary, and it upends the balance, or at least shows to the world a slightly different intent than I think this group is aiming for. Meaning without that bit of protection, the local governments, I'll say it differently, ECMC could override a local decision and locate a facility in a jurisdiction in the site not selected by the locality. Now, conversely, we're where the commission may decline to approve an OGDP or a location that was approved by the local government. So we recognize the governing authorities could reach opposite positions. That's a known quantity. The concern is just changing to consider because it doesn't properly respect local government's authority. You could consider and then quickly dismiss somebody's opinion, We just want to make sure we get there. And it's really a drafting exercise, but it's an important one to get right. Our preferred solution is to revert to defer. Business as usual, as you are implementing this rule and this provision, has been proceeding without issue. So from our perspective, no change is necessary. If, however, the commission is compelled to make a revision, our alternative option would be to proceed with your word consider as proposed in your current draft rules. But we need to add more color around that, because just to put it pointedly, there's not one single word in this dictionary, that would allow us to get there, right? It doesn't house all of our intent. So all we're asking for is, let's document our intent, let's make it colorful. And the goal here is to memorialize that. So when this set of commissioners in 10 years, I mean, maybe you want to be here in 10 years, but assuming you don't want to be here in 10 years, there's no lack of ambiguity on, how state and locals interact on these issues. It's truly what we're going for here. We note that in the August 29th SBP that staff published, there was some added language in the SPP that appears to be modeled after what you see on your screen here. We support those edits, just to be very clear, but we do ask for the text in the rule as well, so we don't lack clarity. I'm gonna take a minute, a little pause on the walkthrough of the rules, just to say a quick thank you to staff and the supporting AGs. Please consider this a virtual thank you note. I know this is an incredibly challenging project for you, competing interest and really complex material that you all are wading through. And in the spirit of appreciation, I want to call out specific drafting that WRLG does support. I'm going to flip through these relatively quickly, so if you have questions, of course, let's talk through those in Q&A. This goes to, I think it was Chair Robbins, you asked a question at the end of the ALG's presentation on 301F. Recall, this is the pre-application consultation process. From WRLG's perspective, the current draft rule essentially maintains status quo, and it respects strong local government pre-application process. I think this was staff's original intent, perhaps maybe a little bit confusion in the first draft. We do think this current draft gets us there. And again, the genesis of that pre-application process was from local governments who asked for that process and asked the director to attend their meetings. Those were remarkably successful after mission change. So this rule is just trying to grow that opportunity for other local governments who haven't been able to implement that. So we support this process, and we think the drafting looks good from our perspective. WRLG, we offered thoughts and revisions to the community liaison section, but following staff's most recent draft and the SBP language, the coalition has no further comments on this section, and we support that draft. WRLG supports the deletion, of the previously proposed definition of biological resources. That definition gave us a lot of heartache. It was extremely vague and confusing and offered no regulatory certainty to operators nor structure to the commission. And I just add that this species and habitat is of priority importance to Western and rural local governments, and we are closely monitoring this issue. One thing to think about as I've been thinking about this issue is the legislature did identify in this most recent session a lack of potential data regarding rare plants and invertebrates. And we heard from some folks on that, but the legislature tasked and directed CPW to study that data, to fill that data gap. And I think we need to give CPW time to do that analysis, complete that evaluation before we try to draft rules around those concepts. I'd also flag that in 2020, CPW published its status report, as it does from time to time. That report addressed, among other things, big game species, range and migration corridors. And that was published at the direction of Governor Polis, who called on agencies to focus on the conservation of the state's big game. That report shows that the populations of our primary big game, elk, mule deer, bighorn sheep, they're at or above target and objective levels. So I think that's just important to keep in mind, that we're not working in crisis mode at this point. A couple other points is in the experience of Western and rural local governments, right, when species are involved in these OGDPs and these applications, operators are required by ECMC to develop wildlife mitigation plans. So Mr. Wynn and Garfield County and all these counties, they see these wildlife mitigation plans come through their processes and their evaluation. Those are prepared in concert with CPW to identify, are species present, is habitat present, and then how do I, using the hierarchical approach, avoid, minimize, and mitigate to make sure, you know, those impacts, again, follow that rubric that we've discussed throughout the past couple of hours. That coupled with the 1200 series rules, which are extremely strong and developed through mission change. I think there are, if we need clarification in the rule, to be clear that those elements of analysis of cumulative evaluation that CPW and the operators go through are there. That clarification may be necessary, but there's a lot on the books already that addresses these concerns. And again, if it's a drafting exercise, we need to do it, but these analyses are being done and then can be folded into the overall CIA that is proposed here. The last piece I would add on biological resources, again, this is important to Western and rural local governments, so spending a minute on it. As I've heard, you know, I think this goes to the conversation Commissioner Mesner, you just had with Ms. Sanchez, which was absolutely this commission should look to specialists such as CPW and CDPHE for insights, reflections, commentary, feedback, but the decision is ECMC's. Right, the legal recourse, if there were to be any, needs to be through ECMC. So I am not comfortable, and my recommendation would never be for you to sort of pass that buck and say, well, whatever they say goes. This is ECMC's decision to issue or deny a permit. And I would also say these commissioners, you commissioners, are the only ones in the seat to be able to look at sort of the broader picture, right? An individual specialty agency is not going to be able to see that. So closing out, the Western and rural local governments, we support responsible resource development. And in fact, it's vital to the strength of these communities. We ask for the commission to stay highly focused on people and communities and not just broad swaths of land. And third, the rules must continue to respect co-equal authority shared between state and local governments. The modest changes we've proposed to you address each of these three priorities. We walked through them today, but I'd also ask you to take a minute with our Exhibit 1 to our response. And with that, we are happy to take questions you may have.
Commissioners, the panel is open for questions. Commissioner Cross.
Thank you, Mr. Chair, and thank you for the presentation. I just want to briefly touch on the CIC discussion that you had. And I note that at the end, you said you would also be okay with the removal of CIC. And that's really what I wanted to focus on, because it seemed, at least looking at it, it looks like if you're talking about within 2,000 feet of an occupied building, it essentially is going to have the same impact as a DIC, correct?
Yeah.
Okay, so at that point in time, either including it or removing it, essentially.
Yeah, and to be clear, excuse me, sorry, thank you for the question, Commissioner Cross. We're not trying to limit the scope of analyses for CICs. We're just trying to clean up the rules in this regard, right? There's an immense level of overlap with respect to the use of DIC and then this sort of added layer of CIC. I think we just need what is our focus, what's our target, and then let's execute. But right now, there's just a couple of layers that are overlapping and creating a bit of confusion and conflict.
Okay. And with respect to the proximity issue, because it is obviously different in a lot of these rural and Western local governments, there's been a lot of discussion thus far about, we'll say, two sort of areas with respect to proximity. There was earlier today, for example, we had Green Latinos suggesting an alternative where you would have a larger kind of look at that 1 mile impact area and use that as the basis for the enhanced systems and procedures. And then there's also some discussion yesterday talking about maybe a larger area than the 2,000 feet for things like notice of different applications, et cetera. What are the WRLG positions on those issues?
Yeah, and this goes similar to our conversation around how we were sort of crafting and trying to focus both the CIC and the DIC definitions. And we had this discussion, which is to say, what's the right distance? 1 mile, like I said, is too far, insofar that when you're looking at western and rural communities, 1 mile is a huge swath of land, and it's going to cover a lot of open space, right? Where really what we're trying to get at with the DIC and the CIC, both of which are focused on community, is what are the impacts to people? So from our perspective, we've got to focus on the community and the people. We landed at the 2,000 feet primarily because that's what's on your books, right? That's the known quantity and the most sort of defensible used regulatory application. I think anything beyond that is more or less arbitrary and just picking out of a hat.
Okay, thank you.
Commissioner Messner.
Thank you, Mr. Chair. Thank you both for presenting and providing good information to the rulemaking process. You know, I acknowledge that there's some challenges with the application of DIC in more rural parts of the state, and so I've been noodling on this myself. First question. There was a proposal that was provided by Conservation Colorado. I don't have that presentation, so now I can't recite what it is, but do you recollect it and do you have a reaction?
If you could refresh specifically what you're talking about, that would be.
Well, it was a recommendation on how to address applicability of DICs of some of the rules that are being proposed. And I think this one was more specific to the Western Slope rather than rural Colorado. And so, no, I actually don't have it. I was hoping you remembered because I was just trying to go through my notes and remember it, and I don't have the presentation. It hasn't been submitted yet. And so I can follow back up if you
And
don't.
let me take the time to spend some time with it and give you a reaction to that, perhaps in rebuttal, when we'll have an opportunity to discuss again, but we'll take that as a take back.
Okay, great. And then I think one of the challenges that I've been thinking about in thinking about this and applying 2,000 feet, and I'd ask this to staff as well, but the 2,000 feet is the metric that was generated by a public health study to determine direct public health impacts, potential public health impacts to residents within 2,000 feet. But I'm not sure it applies in a lot of these other places that it's trying to be applied, right? And so I think that's where I struggle a little bit. I mean, a lot of this is going to be talking about notice or about cumulative impacts or about things that aren't necessarily direct public health impacts associated with one well in proximity to an RBU. And so I don't know if you have thoughts on that, but I do struggle with that 2,000 feet being utilized in areas where it maybe is not intended to be utilized, or at least it wasn't a basis for it.
Yeah, I appreciate that thought process, Commissioner Messner. I guess I just want to get, so I can think about it sort of more diligently. Is your concern that, so, you know, I heard you say that 2,000 foot is focused on the direct impact to those communities. I guess, what are we missing?
It's to an individual RBU from one well pad, right?
And your concern is?
My concern is
outside of that, there is an impact that is broader, more cumulatively.
And some of the rules that are being contemplated here, there are cumulative impacts that are trying to be evaluated, or there's notice that is part of it, or there's, other things beyond, evaluating the direct public health impacts associated with an RVU in proximity to a well pad. And so I think when I hear you say that you're applying this 2,000 foot globally to the rules, I'm wondering whether it's appropriate to globally apply it to the rules, or whether we have to be more specific about our metrics.
I'm going to interject one thing for you, Anna. So the 2,000 feet, the way that the draft for the DICs is written right now, the commission, the director can right up front say, you know what, 2,000 is not enough, and they can scale it to wherever they need it to be. And that's the point. Is like, you look at this map behind me, I mean, this is nothing but relief. 2,000 feet is 1,000,000 miles away in some locales where you have a home, and then you have a well pad that's like currently there, right? They don't even know it's there. They don't smell it. They don't hear it. They don't see it. They don't see the trucks. And so the 2,000 feet gives you a reasonable place to start and say, if it's there or closer, by golly, we're going to do all this stuff. But immediately the director has great facility to just say, you know what, it's a mile in this situation. And so we think that that's a good safeguard. And the agency's going to be there. They're going to be there at the pre-app stage, the ECMC, to make sure that the right sorts of looks are done and the right distances are set for a given application. We think that's appropriate to have that scaling ability.
Okay, well, I appreciate your opinion. So talking a little bit about that, kind of the point you brought up about the pre-application hearing and the deferral to the local government on the pre-application hearing, I guess 301 F and G. So understanding that Garfield County has a strong criteria for who's involved in the pre-application hearing and what is going to be discussed in the pre-application hearing. But the rule as drafted just blanket defers to the local government without putting any criteria on at least what the minimum standards need to be included as part of that. And Garfield County already does it. And so, but 301G identifies, at least at the state level, the minimum standards that need to be utilized in that pre-application hearing. Do you see any issue with at least having that as the minimum standard for local government pre-application process to eliminate any need to duplicate processes?
Just so you know, I 100% anticipated this question coming directly from you, so this is no surprise. But my response is, yeah, absolutely. The expectation is that it would be commensurate with, right? That it would be up to the standard of ECMC. Our proposed edit in our previous versions, what we objected to in that first go was that it was at the ECMC's discretion to determine if, it was adequate, an adequate process, but really it's a black and white, right? Did you invite the right people and did you host the meeting? And so it's did you do these things? Then it qualifies step. It is not well, they did it, but we didn't really like the way they went about the process. So we're just trying to pull out, I think what you are too, pull out the discretion on it, but we do agree that it should be as stringent as the ECMC process.
Okay, great. You'll probably anticipated this question as well. So, 302C, the defer versus the, and I understand it. I mean, I understand the argument you're making. I guess the challenge that I'm seeing in application is that by utilizing the term defer, it is going to require that the local governments go first.
Sorry, say that again. You cut out. It's going to require.
Local government is going to have to complete their process first if the term defer is maintained in the rule. Right now, there's the opportunity for a concurrent process, a subsequent process. And we maybe inappropriately applied the rule up to this point with the word defer in there to allow a concurrent process to occur. and to even make decisions at the state level without a local government decision. This solves that to still allow for a concurrent process by having consider in there instead of defer. But if defer is maintained, I read the rule as saying that the local government has to complete their process first.
And
So
let me
go ahead.
No.
let me just add on, because I have the
Oh,
same questions, and so you might as well get them all at once, right?
Yeah, of course.
You know, as I look at what the staff did in the SBP, which I probably would anticipate y'all drafted, you know, it seemed like to me that that's a good landing spot if you add the clarification in the SBP.
So two reactions, and I'll react to both of you separately. The first is this 302C3 is only where the local government goes first. So if the local government goes first and has a citing disposition, we use the words defer. And then if we go in parallel, it's a little bit different language. So I think that the rules you currently have contemplate the different sequences. But regardless, bottom line that I think we're all grappling with is I get that defer doesn't quite feel right, because defer would say you have no other option but to go with what the local government said. But that's not how it's going to work out in practice. I think all we're saying is consider also doesn't feel right, because it's very dismissive, for lack of better term. To respond to Chair Robbins, your point is, does the SBAP take care of it? All I would say to that is we're talking about today, do we need to incorporate and pull into the rule SBAP language about avoid, minimize, and mitigate because it's an SBAP and not rule? I don't want to have that conversation in 10 years about what is the intent and clarity on local government's role with respect to these siting locations concurrent with ECMCs.
And let me be perfectly clear, I think neither Commissioner Messner or I want to have that conversation in 10 years either.
I'll probably call you regardless, but hopefully none of us are doing that.
Well, I mean, I understand. I understand. So I'm thinking about this, but I do want to maintain sequential and concurrent options. So those are the only questions I have. So thank you.
Others with questions? Commissioner Ackerman?
Thank you, Mr. Chair, and thank you for touching on that last point. I also had a question associated with that. I think that consider is more in line with co-management than defer is, and I think we'll probably continue to probably work very similarly to how we have worked in the past. I just think that this is a cleanup that aligns the regulations more with the process as it's been occurring. That said, I wanted to go back to the point that you made on the 1 mile impact area. You know, we've had some significant discussion about that during this rulemaking, and the tenor of lots of that discussion has been that 1 mile impact area is too small of an area to start with. What I'm inferring from your comment is that's too large of an area to start with, and I just wanted to ensure that I'm inferring correctly. Can you expand just a little bit on that discussion?
That is the right inference, and I think the difference is you're hearing from a member of the state that is rural and western, or rural Colorado, and then the most of the other commentary where folks said 1 mile is not big enough was largely urban based commentary. So our point is it's two different experiences. So putting that sort of one size fits all across the state is something we just need to take pause and think through to make sure we're going through a process that makes sense and is meaningful.
Thank you. And just to expand a little bit more, your specific concerns associated with that were that topographically there's significant separation on the western slope that may not exist somewhere else. And the density or lack of density of people were two key factors that fed into that opinion. Am I on the right track?
And yes, I think that's right. And the issue being, what's associated with that obligation. And this goes to, I think, what Commissioner Messner is getting at is whether it's a process trigger that comes from the distance, or whether it's a regulatory command and control requirement. Those have two different outcomes, but if we're demanding in particular more command and control requirements, and as I sort of phrased it, uninhabited Colorado, I don't think we're not meeting our goal, right? That's not the purpose of DICs and CICs. Process could be a different conversation because, we're not opposed to, of course, informed and intentional decision making. But again, we got to make sure it's not additional process for the sake of process, but it has purpose tied to it.
Thank you. I appreciate that. I also just a comment, appreciated your points of view on the DIC and CIC discussion. Thank you for adding your unique point of view as well. That's all I have for now, Mr. Chair. Thanks.
Other questions for the panel?
And just one flag that Kirby, Mr. Nguyen will be disappearing. So if you have any specific questions for our witness, we welcome those.
Since this will be your last time to speak, or Mr. Nguyen, you've heard our discussion about an area that I know is near and dear to your heart. Did you want to provide any sort of final statement from Garfield County on that issue?
No, I'm happy with what we've covered within our session here today.
Great. Okay, just wanted to give you the opportunity.
Appreciate
All right,
it.
well, we thank you both. Hearings Manager Thomas, if you could visualize. Let's see, we generally are trying to break it for an hour and a half or so. It's 3:37. Weld County's next, and they've only got 20 minutes total allocated. Do we want to try to elevate Mr. Barker and Mr. Conroy and get through them, and then we can take our mid-afternoon break before our evening session?
Certainly.
All right, let's take 3 minutes, return at 3:40. All right, as we're waiting for folks to show back up, I'll just announce that it is still September 5th. It is 3:40, and we're taking up docket 2406-00145. We now will hear from Weld County. I see Mr. Conroy and Ms. Holliday and Mr. Maxey. It's good to see all three of you. Don't know who's going to lead off, but you are recognized.
Thank you, Mr. Chair, and good afternoon to you and the rest of the commission. I will lead us off just briefly. I'm Matthew Cartwright, an assistant county attorney for Weld County, also getting over a cold, so a little stuffy. And so I will just turn it over to our oil and gas energy director, Jason Maxey, who you are all familiar with, to start our testimony.
Thank you, Matt. Appreciate the introduction, and I'll echo thank you again to Chairman Robbins and the rest of the commissioners for allowing us a few minutes to speak about this very important rulemaking. I'm just going to take a few minutes, again, for the record, Jason Maxey, Director for the Weld County Oil and Gas Energy Department. And I just wanted to make a few points regarding some of our items that we would like to speak on regarding the cumulative impacts rulemaking. I'm really just going to focus on a few short items here before I turn it over to Ms. Holliday to make some additional comments regarding our process. So there's some bulleted items on the screen right now for what I want to talk about, and a couple of them do relate more specifically to the proposed rules. But the first comment I want to make is we do generally support the statements of Garfield County and the Western and Rural Local Government Coalition and appreciate their involvement in this process as well. The first large point that I want to make regarding the proposed rules and the red lines that we've seen, and that's been reflected in our party statements, are going to be regarding a definition. And I think the commissioners know how important land use authority is to Weld County. We've had many discussions about that over the years. You also know how important both the agricultural industry as well as the oil and gas industry are to Weld County. And quite frankly, not just important to Weld County, but also our state in general and the nation. You all know, and hopefully for anybody who's listening in, if they don't know, then I'll go ahead and state for the record that Weld County does lead the entire state in both industries. We are number one in oil and gas production, and we're also number one in agricultural production for the entire state of Colorado, which leads the state to rank usually 5th in the nation for oil production and easily in the top 10 for agricultural production as well in multiple sub-agricultural industries. And we're very proud of that. Growing up on a dairy farm here in Weld County, I'm very proud of that fact that agriculture and oil and gas work hand in hand for land use opportunities in Weld County. We generally do not feel it's a good thing to pit different industries or businesses against each other. And to that end, we just want to make a pretty firm stance that the inclusion of dairies in the definition of industrial facilities does just that, in our opinion. And it's concerning. I mean, especially considering that from what we've seen and what we've been involved in, there's really no thresholds mentioned when it comes to that type of agricultural development. You know, looking to the CDPHE, they already have some information and procedures for AFOs, animal feeding operations, or CAFOs, confined animal feeding operations. And so, in my opinion, and in Weld County's opinion, including dairies in the definition of an industrial facility, we don't believe that the ECMC should be duplicative of that. The second thing that Ms. Holliday will go into more detail on is that we want to really touch base on the whole pre-application process. And that is a very important part of the Weld County WOGLA process. You all know that we're always open to collaboration and efficiency and effectiveness of the permitting process, and that won't change moving forward. However, what we've seen in the draft rules really seems to want to be duplicative, really seems to want to not respect or not defer to what we, and when I say we, both Weld County and the ECMC have had in place for many years now. You all know that we have a memorandum of understanding with you all, which outlines general relational items, including permitting and timeframes. And when I say relational, I mean how we interact with each other. We kind of outlined things. One of the very important things that's in that MOU is the fact that you all commit to being a part of our pre-application process. And we have seen great success in that. And we've also seen really good personal relationships that have grown and gotten better over the last few years. You know, if we look 6, 7, 8 years back, I think we can, those of us who've been around a little while, can see where the relationships personally and through our two organizations have grown and where we have done good work in those last 5 years specifically, especially since our department has been created. But we do see gross duplication in the pre-application section of the draft rules. We don't see any deference to our pre-application process or to our MOU. We would definitely ask that that is acknowledged and respected, and that there would, I'll use the word off-ramp, I guess, or the term off-ramp, that we understand that you all are looking at statewide rules for oil and gas development, and we definitely can respect that. But there is no off-ramp for when you have an agreement such as our MOU, and we are very specific about our pre-application process and how we engage referral entities, other jurisdictions. We do not believe that the pre-app process is the right time to engage the public. And there's just no deference to Weld County or to anybody such as us who has an agreement with you all or has such a well thought out and defined pre-application process such as ours. So I'm going to let Kelly go into a little bit more of detail about the pre-application process for everybody's benefit. And then I think she'll kick it back over to me for a couple final comments. So Ms. Holliday, we'll go ahead and pass it to you.
Thank you, Director Maxey, and thank you, commissioners, for allowing me the opportunity to speak with you this afternoon. My name is Kelly Holliday. I'm the lead regulatory analyst for Weld County's Oil and Gas Energy Department. And I'd like to speak with you today specifically regarding our pre-application meeting process. Through the Weld County pre-application process, we take a comprehensive look at land use planning to determine that the siting of a proposed oil and gas location does not present any conflicts to existing or known future land use plans. Looking back to the implementation of Weld County's oil and gas regulations, the pre-application meeting was not initially part of our process, but we quickly realized that we needed to have these early conversations with both operators and fellow regulators. Pre-application meetings became a requirement of Weld County's process in 2020, and we have found that these early planning meetings are extremely valuable. Weld County's pre-application process requires that all relevant agencies are invited, including the state, federal, and local agencies. Due to that MOU that Jason described with the ECMC, a pre-application meeting would not be held without a representative from the ECMC being present. But we do not feel that this early planning phase, where land use experts are reviewing the development plans alongside operators, is the right time to get the public involved. Bringing the public in during these early planning phases could create conflicts of interest between landowners, mineral owners, industry supporters, environmentalists, and activists. While we're specifically speaking today to the pre-app process and the public is not included on those meetings, the list of impacted parties continues to expand throughout the Weld County permitting process. As plans become more solidified and we move through the process, in addition to the multiple referral agencies who are included in that pre-app meeting, the public is engaged, including homeowners, surrounding property owners, and our hearings are also publicly noticed in the paper. The intent of this engagement is to solicit feedback from the public. In addition to the outreach specifically through the permitting process, we're also available as a community resource that the public can reach out to our department at any point in time. And I'll hand it back over to Director Maxey.
Thank you, Ms. Holliday, very much. I appreciate that, those points on our pre-app process specifically, and a little bit on the remainder of our process of how we engage not only the public in Weld County and our property owners and our homeowners, but also other jurisdictional agencies. You know, the last bullet point on this slide talks about the availability of local recorded permits. That is something that we have done for many years now. The information is not intended to be decided upon and then be held behind this veil of secrecy. In fact, it's open to anybody who wants to take a look at what has been approved. The process is open for engagement, as Ms. Holliday mentioned, throughout our process. I do want to make sure that for the record, it's known that the decision makers within Weld County is not typically our department and our staff, just like it's not your staff. Your staff makes a recommendation to you all for a final decision, and that is what happens at the Weld County process as well. With our hearing officer, our staff presents a recommended presentation to them, and our hearing officer makes that final decision. And as we mentioned on that last bullet point, those permits are available to view and to see pending development for the community members within Weld County via our mapping system, or using us as a resource to provide that information to them. Again, 1041 WOGLAs do become a vested property right, and part of that is being of record so that they are shown and publicly accessible. So Matt, I think that that's all that I wanted to say before handing it over to you, and I think you're going to kind of wrap up our comments on the last slide, right?
If I can find the unmute button, yes, I will. Thank you, Jason and Kelly. Yeah, so just to reiterate, and I think for the pre-application process, a lot of our concerns were addressed with the August version of the rules. I mean, and then anticipating a question from Commissioner Messner as he asked it of the previous party. Again, as to reiterate Jason and Kelly's points, we would have concern with, we think the only real difference between the pre-application process in 301G and what we do already would be when you engage the public, instead of using the pre-application as the ability to get all the regulators on the same page before deciding, you know, how we move forward. And then the public can get, we think it's more appropriate when they get into the technical review process, or when, you know, when the application is out for comments. But so we think that the commission should adopt the staff's proposed rules from the August draft of the rules. And quite frankly, you know, also to your concern, Commissioner Mester, about that the pre-application process, you know, how does it matter if they're different? But the reality is that Weld County permits majority of the oil and gas operations in the state anyway. So as long as we are on the same page with our pre-application process, we think that should solve most of these issues. And then I do want to reiterate that we agree with the Western Rural Local Government Coalition that you should use the word defer. And to add my own gloss onto that argument, I would just say that the way that I read the SBAP language is that essentially the commission is putting in SBAP that they will defer, right? That there's language at the end of the SBAP, or a sentence at the end of the SBAP language that essentially says that if the commission disagrees with the local government citing disposition, they will give a detailed explanation of why. And sort of to my lawyer brain, that's all deference really is. That's saying if you disagree, you have to give a solid reason, instead of whereas consider just says we thought about it, but we decided to go a different direction. And so if you're going to put that in SBAP, I don't really see a reason why not to just leave it as deferred language, but I also anticipate that we're probably going to disagree on that. And so the SBAP language is at least a reasonable compromise. And then sort of a minor point, and this is a continuation from the deep geothermal rulemaking, we do believe that, and this was more extensively laid out in our response to hearing statements, but adopting similar language that's now codified in the commission's rules at Rule 1305C, and essentially currently the rules say substantially equivalent, and moving that to must be supplemented to just to help it make sure that if things aren't exactly the same forms or whatnot, that avoid duplication between our two processes, and so that when so something like a noise plan, the operator can submit the same noise plan. When the community is reviewing the noise plan, they only see one noise plan. They don't see like, here's the Weld County noise plan, and here's the ECMC noise plan, because they're slightly different because reasons. We think that will help both the administrative workload for our agencies as well as eliminate community confusion. And then again, while we don't have necessarily solid suggestions, we do believe that the commission should consider changes to the definition of industrial facility to provide more clarity as to what actually needs to be included, whether that's using animal feeding operations or something else to refer to dairies, or just some sort of thresholds. And of course, that's a horribly complicated topic, which I think is probably why it was left vague, but we do believe there needs to be greater clarity there. And with that, we'll be happy to answer any questions.
Let me ask a couple of quick questions on that last point. I am not educated in dairy versus animal feeding, et cetera. So, I mean, I almost want to defer to you guys because you're the experts in this arena. I would note that the definition of industrial facilities is not exhaustive or inclusive. Like, it's not just those things. It's like those are examples. But I'll go back and we can talk with our AAGs about the definition, and because I assume dairy like raises prickles in Weld County because you do a lot of dairies. Is that where you're coming from?
Yeah, if I could jump in, thank you, Chair Robbins. To answer your question, yes, and I think Matt said that as well, as far as even on this slide, just to provide greater clarity. For example, I come from a family dairy that my grandpa and grandma took over in the early 50s. If we were milking 60 head of cattle, that is a lot different of a impact than a commercial style dairy that might be milking 1,000 head or 2,000 head. But the way that it's phrased right now to just be all inclusive of dairies, that is my concern. And that's why I raised that. And that's why Matt was saying we feel there needs to be greater clarity surrounding that definition and the specific inclusion of that word dairy, because that kind of got my hair prickling up, whatever I have left of it that I don't shave off. So that's the reason why we bring that up.
Okay, well, that's why we have these rulemakings. That's why we encourage people to stakeholder with us to bring perspectives that wouldn't necessarily have been prickly to others to continue to use that term. Go ahead, Mr. Conrad.
Oh, sorry. I would just add on from a legal perspective. I think I'm not sure you want me to get into the details of the difference between, an animal feeding operation in terms of EPA water quality, right? And that's my general suggestion that I wholeheartly support talking to the AAGs is probably looking, and I think Commissioner Oath would have a much better understanding of this than even me anyway, but it's like looking towards how we do NIPIDs permitting for animal feeding operations and confined animal feeding operations, and finding some line in there. I think that's there's a regulatory framework along those lines.
Commissioner Oath?
Yeah, thanks. I appreciate being invited into this. This was going to be a question that I asked because I did want to better understand kind of your comments on this. It seemed like you were saying, you know, that you felt like including dairies in the definition of industrial facility pitted the industries against each other because they're covered by, you know, CDPHE regulations. And I am quite familiar with the CAFO regulations and how they're regulated, and been visited a number of sites myself, and so appreciate kind of where you're coming from. However, all of the facilities listed as examples of industrial facilities are also regulated by CDPHE and other agencies, so I don't quite follow that logic.
So, Commissioner, if I could, and I apologize because I'm not totally familiar with all the regulations of CDPHE. That's not my forte. But so does the CDPHE regulate dairies that are goat dairies? Is it only cattle dairies? Is it 60 head? Is it 500 head? Is it 1,000 head? That's the concern, and the question is the vagueness of what is included currently in the term dairy right now.
Okay, and that I understand, and so appreciate that. We probably should have some more conversation of like exactly how expansive is this intended to be. But so to be clear, then you're not saying dairies completely should be removed because they're dealt with by other regulations. Because for what I'm saying is, for example, in the definition of industrial facility, it talks about cement plants and airports and wastewater treatment plants, which are also, you know, addressed by other regulations. So they shouldn't just be removed because of that. But it sounds like what you're really saying is we need to be more precise about size of or type of dairy facility that it constitutes an industrial facility.
In general, yes. Personally, I don't believe a dairy belongs in the same definition of an airport or a cement plant. To me, that's not the same level of intensity for an industry. But if it is included, then we get to the threshold question about what classifies one dairy versus another based on scale, size. In Weld County, for example, depending on the amount of acreage you have, you could have a 1,000 head cattle operation, and it's a use by right. There is no land use permit because you have a certain amount of acreage that can support that use. Whereas if it's a confined operation, the confined operation might not have the acreage needed to support it. And that's why it's termed a confined animal feeding operation for Weld County even. So I think that the threshold understanding is where we would go to if it is going to be remaining in the definition.
Okay, that's helpful. Thank you. And then I have just a quick follow-up on this, if I may. Does Weld County define industrial facility like in your zoning regulations, and how do you deal with this? Or could you provide that definition?
Well, so essentially, like, not really. We have our various zone districts, and broadly speaking, like 95% of the land area of the county is zoned agricultural. And so then within the agricultural zone district, we have each use gets sort of a bucket, whether it's a use by right, you don't need any sort of permit. Do you need a lesser zoning permit in the agricultural zone district for, you know, I want to do my little like tractor pull or something like that? Or do you have a use by special review permit? And that's where you're starting to get into like the cement plants and stuff. So a lot of uses that you would think are of industrial are probably a use by special review in the agricultural zone district. But then we also have our separate industrial zone districts. And so it's, I mean, and that's kind of just a mismatch, I think, from a local land use process, right? Like, I'm not sure how to marry these things, but so that's why I didn't necessarily want to get into it, because I'm not sure you can match everything up. I mean,
Not apples to apples, yeah. Or the definition you all have isn't, this would not be applicable in this.
Well, And I guess the way I would phrase it is, from my perspective, if there were greater clarity of like what counts, we could work through our GIS system to kind of figure out what everything is. But when it's just kind of left up in the air, I'm not sure how, both as regulators and then when I would anticipate, operators coming to us for, what uses are around this location is like in the pre-application process, how we figure that out. And that's just going to be a learning experience. But so that's where I think, again, just having some bright line thresholds. I mean, I did, but then also I don't necessarily want to import our definitions into your rules per se, because they're a little.
Yeah, it'd be like fitting the square peg into the circular hole.
Yeah.
Not so. Okay, thank you.
Did you call on me?
I did.
Okay. Thank you, Mr. Chair. Thanks for the presentation. I did have a couple of questions. I understand the point about the dairy and the lack of specificity there. At the same time, this term industrial, I mean, it's utilized in local governments all over the state, all over the country. And so we've got to be able to come up with a definition that works to apply in this particular situation as we look at, how we evaluate other industrial impacts for whatever metric ends up being the metric. And so I hear what you're saying. I think Weld County has a unique land use process, kind of upgrading agricultural land. So I guess my ask is, rather than try to use the dairy as the, I'm not even sure how to peg it, but we've got to be able to come up with a better definition here from a local government process that will work in this situation. So it's a statement. I put it out there to all the local government folks to look at their definitions of either industrial zoning or industrial facility or whatever their particular land use process is, and see if there's not one that could be applicable. I think everyone understands the intent, and so I think that there's got to be a solution here. So,
Commissioner Messer, yeah, I mean, and I think I like the suggestion of the Western and rural local governments that it's, you list out the entities within whatever impact area you choose. I don't think we really have a strong position on what exactly that is. Just saying, well, what permits exist, like sort of building on existing knowledge, right? And that's kind of where my mind went with, bringing in confined animal feeding operations, because, you can look at, well, what does CDPHE do with their NIPIDs permits? And then and you're probably going to want to be collecting that information anyway for looking at water quality effects, because then those will start bringing in, total maximum daily loads and getting in, and I could go on, but right. So but again, that type of thing, again, just having some sort of ability so that, and there's certainty that we've considered everything that we needed to consider, and there's not this sort of piecemeal, well, you didn't consider this, and kind of interminable process.
I get it. I mean, one of the things that I think about, which is why I'm pushing this on local governments to some respect, is that there's some contemplation in the rules and in the legislation for permits that have been applied for or granted, which means that some level the local government or the state has granted an industrial operation. So whether that's an asphalt batch plant, whether that's a cement plant, whether that whatever would be classified as industrial, and probably heavy industrial and not light industrial, right? And so I mean, these are there's a solution here, and so anyway, I just throw it out there. But I do want to get to this pre-application piece, right? So, and I wonder if we could go to the pre-application kind of slide that you had put up there. So again, I think the pre-application process, it's a relatively standard local government land use process. It's, you know, designed to make sure that the applicant understands the landscape and the information necessary for the submittal of the application, right? Which is pretty much what you have here. So they understand the zoning, they understand the you know, land uses that are around it, the requirements for submission of the application, the kind of lay of the land. And so I fully support that. I agree with that. I think it's a good thing. I keep seeing this pre-application process get more and more added to it. So now it's being proposed to determine potential impact areas. Now and then, or I've seen in kind of summaries of pre-application meetings where BMPs are actually being discussed, or alternative location analyses are being discussed, or like more meat of like decision making. There's actually findings that come out of these pre-application conferences that say, you know, ECMC or CDPHE doesn't indicate that it seems like there's going to be any problems with this application. And so to me, the pre-application has become more than I think it is supposed to be. And so when I have concerns about the pre-application conference and continuing to add more to it, it is from an ensuring that there is an openness and transparency in the process, and that the pre-application meeting really is to make sure that the applicant understands what they need to do to successfully, you know, provide the information to an application, that they are understanding what the zoning requirements are going to be, or what the, you know, submittal requirements are going to be, and those type of things. And so I think this is what you're seeing people react to, is that the pre-application meeting is becoming more than I think it was intended to be. And so now you're seeing publics, organizations, other local governments want to be involved with that, because they do feel like some decisions are being made at that pre-application meeting. And so that's where I think the challenge here is. And so for me, I want to go back to the root of what the pre-application meeting was supposed to be, and that's just to make sure that the applicant has the information on how to submit an application, right? And
Yeah.
so that's where I'm struggling with this pre-application piece. And, you know, if we're going to continue to add more to the pre-application meeting, then I understand why the public wants to be involved.
So Commissioner Messner, thank you for that. And I really appreciate the question, I guess, or the statement about kind of the confusion, or the concern, rather, not the confusion, your concern. I think you verbalized that very well. And I truly do appreciate that. And I think that is why, going back to kind of my intro, to why I said it's concerning to me that there is no off-ramp from what I've seen in the rules. Because again, you have a view from what is expected when the ECMC needs to conduct the pre-app process. With all due respect, though, Weld County's pre-app process has not changed since we implemented it. Ms. Holliday said back in late 2020 is when we started implementing this, and we started holding routine pre-app meetings. And it honestly is more than just telling them what they need to do to submit a complete application. When we have in our code, and when you all expect as well, that the applicant be able to discuss alternative locations that they have evaluated, the time to do that is not when they turn in a stack of paper that's 500 pages long to your staff or to my staff to evaluate if that location is good. Because the last thing that anybody wants is your staff or my staff to waste time reviewing 500 pages of application just to come to the conclusion that we don't really think this is the best location. We should have done that at the pre-app stage and looked at it holistically, looked at the development area that they're wanting to try to extract those minerals from, see what land uses surround that from the county or local jurisdiction perspective, engage another county, engage another municipality if that's required, because we see that there could be impacts to them. So we engage the people, we engage the regulatory agencies at that time that we feel could be impacted not just from their preferred location, but in our analysis of the complete holistic view of where, if they can't go over here on the east, maybe they can go on the west. Tell us why you can't go on the west. Now, to your point, though, talking about BMPs, my staff can back this up. We do not want to be very specific as far as BMPs go, because the pre-app process is not the time to do that. The application phase is where they put the meat on the bones about why, through the pre-app, they heard concerns, they heard comments from the people who attended that, and here's how they're going to do and put their best foot forward on those BMPs for the preferred location that they've spent all the time and energy and money creating that packet to your staff and to our staff. That is the appropriate time for that. However, what we can do, especially on the local jurisdiction side of things, because we do not go off of zoning for 1041 WOGLAs. Again, we're unique in this. It is not based on zoning. Maybe other jurisdictions do, but Weld County does not. We have planning areas. And so we take a different approach to oil and gas development than other land use permits. And so based on our evaluation, it is an option, and it is something that we as the local departments do recommend to the operators. And we say, based on this location, we know that we can recommend a certain noise level. We know we can recommend a certain lighting zone that your application that's forthcoming can address in your BMPs and in your plans that you submit. So I want to be very clear to not only the commission and to everybody who's listening to this. There are no decisions that are made at this stage. We do not ask the ECMC staff to give a decision. We do not ask CDPHE, BLM, CPW, anybody else that we engage at that time frame to provide a decision moving forward. We understand our role as staff. Your staff understands their role as staff. However, we do find it very prudent to tell the operator after that robust discussion at the pre-app stage that we agree with them that this is the best location moving forward, so they can put that time and energy into their overall application, because nobody wants to waste time moving forward about presenting all that to your staff and my staff and then go back to the drawing board if somebody has a major concern. That's what the pre-application process is meant for. That's the appropriate time for planning. And again, I think we have seen tremendous success with the way Weld County handles the pre-application process and our interaction with your staff and with CDPHE, CPW, and others that we engage.
And if I could just
I appreciate that. And, I do think Weld County does a unique process. And I do think a lot of the process that you're talking about that is happening at the pre-application level is happening in a referral process and the actual application process in other counties. And so this is where I think I struggle a little bit with the process that, many counties at least, and I come from a county that also does not have zoning, and so I do understand performance-based land use planning, but at the same time, there's multiple referral processes that work through some of these things that you're indicating that are happening at the pre-application conference. And so it's not here nor there, but this is making me see that there may need to be a duplicate process if there can't be some more symmetry, I think, in the pressures that the state is feeling from a transparency standpoint and a process standpoint can't better comport with different local government processes around the state. And so I'm open to continuing to hear more about this, but I'm expressing kind of the challenges that I'm seeing with it.
Absolutely. And I for one, and I know Matt and I know Kelly would be happy to expand on this until, we've expanded all options. But I think what I hear from you is that when an applicant submits an application through the ECMC, it's going to go out for referrals. So it has a public comment period, right, to engage the public. And while you might be feeling the pressure to have increased public engagement, the pre-app stage, as Kelly mentioned, there's too many conflicts that can happen when you engage those people. There are too many things that could be introduced as far as competing interests that, quite frankly, some of the public has has no jurisdiction over. Jurisdiction is the wrong word. But you could get into a point to where you are literally pitting landowners against landowners, neighbors against neighbors. And I don't believe that that's what this process is about either. This process is about making sure that the operators are following the local land use rules, the state rules, the CDPHE rules, and that we are allowing responsible development for this industry. And I again will reiterate the fact that I believe Weld County's process does not cut out the public. There are multiple times after the pre-app meeting to where the public is engaged. Outside of that, we are open for questions all the time. You all have heard me and Kelly recently get on and testify to you about the amount of applications we receive, which overwhelmingly happen in Weld County compared to other parts of the state. And you've heard me testify and Kelly testify many times that we have no public engagement. Quite honestly, that's a little bit frustrating when we start hearing all these concerns that you all are hearing about, but yet they don't engage the local jurisdictions who usually are trending ahead of the permitting timeframe compared to you all, right? And so that's a little bit of a frustration on our end as well, is that we engage people. Our doors are open. And when that doesn't happen, it doesn't mean that the process isn't working. It means that the public needs to utilize those resources that are out there for them.
Understood. We'll have conversations further about this, but I want to be conscious of time. Sorry.
Yeah. Thank you, sir. I appreciate those comments. We will definitely continue to work with you all on them.
Further questions for the panel from commissioners? All right. Well, thank you very much. We always appreciate Wells County's participation with us. It is always helpful. Commissioners, we are at the point in the day in which we're going to take an 1 and 9-minute break before we return for public comment. I would just provide some procedural perspective to ourselves as well as all of our parties. I believe that looking at what's coming up, we should be able to get through the rest of the local governments and then some of the community groups tomorrow. That's about 4.5 hours of direct case in chief, which, given how we've been doing things with questions and answers, I could see that being a day. And then that leaves approximately 7.8 hours or 7.5 hours of industry presentation for Monday and Tuesday for cases in chief, which, given Q&A, is probably about right. So I want to thank the parties for the tremendous work of balancing getting their points across while being efficient and getting their work to us. Thank the commissioners for the questions that I think have helped frame the narrative for this highly complex rulemaking, and thank everybody for continued stamina in being with us as we move through a lengthy rulemaking. With that, we will adjourn until 5:30 this afternoon on September 5th. We will return to this Zoom meeting at 5:30. We've got about 40 public commenters for this evening. See you in 1 hour and 8 minutes.